Everything was very Emerson set up. Do it all. Oh. We've got state prison. So let's try to do that first, assuming we've got a lawyer here. That is.
Yeah, I'm Joy from the main office.
Oh, nice to meet you.
Joy from the main office.
I'm Bolton PD.
Here's all the Jones.
Good morning, Your Honor. I'm here on
Thank you. Are they?
Thank you for being here.
Yes. Awesome. Thank you. You can put it right there. Actually, I'll stay over there. I'll move my seat up.
Good morning, Dodge State Prison. Who do we have down at Dodge State Prison?
This is Johnny Hardiman.
Thank you. We want to try to take care of that first if we can, once we get oriented. It's position 9. Got it. Okay, thank you. We'll do that. Well, good morning, everyone. For those of you I haven't met, I'm Judge McBurney. It is the 20th of December, maybe one of the last sessions of 2022 here in courtroom 8D. Thank you, everyone, for being patient as we work through a number of calendars today. And we have one slightly unexpected hiccup. I learned I need to be sworn back in so I can stay a judge. So I have a little swearing in about a half hour. I have to go to another courtroom, and then when I come back, I'll look younger and more powerful, having been sworn in for my next term. So I'll try to minimize that disruption, but we've got lots to cover. We have a lot of inmates, and our sheriff's team has been real diligent in getting everyone up into our holding area. It's a complicated day logistically because the YSL case is back in the building, and it took me about 30 minutes to get in the building. I was stuck out on Mitchell Street because every sheriff's vehicle on planet Earth was bringing people into the building, and so we all had to stay out. So hopefully they're productive and get some more pleas today. So we have some defense attorneys in the new year. Our 9:30 calendars are 2. We have a bond motion on Mr. Robinson that we will work through, but we also have a plea and arraignment calendar. On that plea and arraignment calendar, we're tucked a few non-plea and arraignments to include a motions hearing for Mr. Hardiman, who is down at Dodge State and is on our screen. Says motion to withdraw plea, but I just looked in the docket and there isn't a motion to withdraw a plea. He mailed it. Okay. All right. Well, I'm going to need to get my hands on that. While we're doing that, why don't we get started with some of our plea and arraignment pieces to see what we can do. We should welcome our new line ADA. He has taken the seat of authority at the table. Mr. Jordan, welcome.
Thank you, Your Honor.
You ready to roll?
Yes, I am.
I noticed Mr. Hand is nowhere to be found. He truly pulled the ripcord now.
He is gone.
He's not here.
Off the premises.
All right. And Ms. Feely, you survived trial?
I did.
Okay.
I don't feel in neutral, but I really enjoyed that dinner.
You do or don't enjoy?
I do.
Good. He's
Like you.
well said. He enjoys 8D and has said, when can I come back? So it's good to know that because it may make it one of your cases, but this is what he does now. We'll see. But it won't be until well into the new year, and it needs to not be when you also have another trial with me. But he seems to like the staff and the lawyers and all that. So maybe we'll be fortunate and get him back here. So let's get started with the plea and arraignment calendar. We'll take a few positions at least, and then we'll see what's happening with Mr. Hardiman's situation. So position 1 is Willie Lewis. Is he in custody? Okay, if we could bring Mr. Lewis, he's got 2 positions. Great, thank you. Hey, Mr. Lewis, come on out to the podium, please. Ms. Bumpus, are you on? Nope. All right. Well, let's work through these. Mr. Lewis, I'm Judge McBurney. How you doing?
Doing all right.
You have 2 cases. They are consecutively numbered. You were indicted back to back. And we heard from Ms. Bumpus that she represents you. Oh, actually not on any of these cases. You have 3 cases that were indicted back to back to back. And Ms. Bumpus represents you. Have you heard that name before?
Yes, she came to visit me last week.
Okay. Let me look up this other case you've got. Okay, and she filed an entry of appearance, and maybe, gosh, you were on for plea and arraignment in August.
August 5th.
And the whole time to find out who represents me.
Okay. So there's no waiver of arraignment in that case. So we haven't done. Okay. Did you hire Ms. Bumpus or someone in your family hire her in that one case?
Yes.
Okay. Were you planning on hiring, or is your family planning on hiring Ms. Bumpus for your other 2 cases?
To my knowledge, yes.
Okay.
Reach out to her and see if I can get her to join the call.
Yep, we're going to see if we can track her down, because it's definitely time for you to be able to move these cases forward. Mr. Jordan, are these your cases?
Those are 88 Wettenauer's cases, Your Honor.
Okay. I see it. Mr. Whitenauer, good morning, sir.
Good morning.
Tell me, I haven't had a chance to look at the indictments. 3 consecutively numbered indictments. They are 3 separate cases, I trust.
They are.
Okay. They have similar looking charges. What are they connected in some way other than obviously Mr. Lewis?
All the same victim, Judge.
Okay. How separated are they in time? Is this something where the DA's office caught up with some older acts along with some newer acts and made it 3 indictments, or what's your understanding? This is not a quiz. I'm not holding you to it. I'm just trying to understand why it's 3 indictments instead of 1.
They are near in time. The first one, ending 696, is from November of 2021. The indictment ending 697 is from February of 22, and indictment ending 698 is from March of 2022.
All right. Well, I get it. Have you had any contact from Ms. Bumpus?
I've not, Judge.
All right. Well, Mr. Lewis, I'm not going to keep you standing up there any longer. We're not sending you away yet. We're going to try to get Ms. Bumpus to join the call. And then maybe she can
I'm
let
on,
us.
Judge. I'm sorry. I'm
Gosh,
so
that
sorry.
was fast. Excellent.
I thought it was a 1 p.m. calendar. I'm so sorry.
We do have a 1 p.m. and maybe you've got a case on the 1 p.m.
Yes, I do. So I thought they were both at 1. That is
All
my
right.
apology.
No problem. You're popular. You're on multiple calendars. We've got Mr. Lewis at the podium, and you represent him. He has 3 indictments, and you are listed as the attorney of record in one of them, but not the other 2. They're connected in that there's the same alleged victim in all 3, and they were indicted consecutively. They have 3 consecutive numbers. Other than that, we're just trying to figure out if we can do arraignment on any of the 3. Maybe we could do the one you represent, Mr. Lewis, on. But then the main question was who's going to handle the other 2. Mr. Lewis shared with me that he thought you were being brought on board for all 3, but I think that's something you need to answer.
Well, Judge, I think we've had this conversation multiple times, and I thought we did arraignment a couple months ago. I had spoken with the family, and they keep telling me they don't even want me on this case. So I had planned on filing a motion to withdraw, and I was hoping to be in person at 1 p.m. Is he not still going to be there?
No, we can keep Mr. Lewis here. So why don't we do that? You have for our 1 p.m. gentleman named Brian Marshall.
Marshall, yes, Judge.
Yeah, and why don't we have Mr. Lewis come back out at 1? But I'm going to tell you this, you should be here at 1:30. Don't be here at 1.
Okay.
Come at 1:30, and Mr. Lewis, we'll talk again at 1:30. Ms. Bumpus will be here. And then I'm wondering maybe Ms. Wood or Ms. Feely, one of you could chat with Mr. Lewis, because it's sounding like Mr. Lewis, maybe there's a little disconnect with your family and Ms. Bumpus. But if they are telling her, we don't want you on any of the cases, she's certainly not going to join in the 2 where you don't have a lawyer. And mostly I want you to get a lawyer so we can start moving your cases forward. Does that make sense?
Yes, Your Honor.
Okay. I'm going to have the deputies take you back. We will bring you back out around 1:30 this afternoon. Okay.
Yes, Your Honor.
All right, Ms. Bumpus, we'll see you at 1:30, but hold on 1 second.
Okay.
There's someone here from Mr. Lewis's family. Can you raise your hand? Hey, how are you? All right. How are you connected to Mr. Lewis? His sister. Ma'am, we have a lawyer who has dialed in, who at one point filed an entry of appearance for your brother in one of his cases. He has 3 cases. Ms. Bumpus is the lawyer who filed an entry in that other case, but we're trying to line up a lawyer for all 3 cases. And Ms. Bumpus had relayed to me just before you got in here that the communication she had received from some member of Mr. Lewis's family was that the family really wasn't interested in having, Ms. Bumpus would be a paid attorney. If she's going to represent Mr. Lewis on any case, it's with someone paying her. But of course, we've got very, very capable lawyers who can be appointed to represent your brother. He's been sitting around for a while, and it is time to move his cases forward. And today was a day to figure out who will be representing your brother on at least 2 of the cases for which he has no lawyer. And then there's the one Ms. Bumpus is sharing. She's been informed that maybe the family doesn't want her to continue as counsel. Your brother.
Stay on the case, Judge, not to interrupt you, but that's up to them 100%.
Right. No, I want to be clear. It wasn't that Ms. Bumpus said, I don't like the case or it looks difficult. That wasn't it at all. It was that the message she had received was maybe she should not stay on it. I'm going to have your brother come back out at 1 o'clock because Ms. Bumpus can, 1:30, because she can be here. I'm not asking you to stay that long, but maybe before you go, you could let me know what the family may be planning to do, because Mr. Lewis needs a lawyer to have these cases move forward, and he's going to be stuck until then. And I've got 2 lawyers right here who could step in and be responsible for all 3 of the cases. if he qualifies for appointed counsel. Do you have any thoughts on any of that?
I would like to speak with either the attorney that they have or someone in the court, because I don't really know a lot about what's happened and all the details of it.
Okay, got it.
And Judge, I can put my number in the chat if she wants to call me, because I've
Yep.
never spoken to her either.
Yeah, why don't you do that and I'll pass her the number and that way you two could chat this morning, and then Ms. Bumpus, we'll see you at 1:30 and we'll have Mr. Lewis come back out at 1:30. Okay? Mr. Lewis, do you have any questions about any of the things we've been talking about?
No, Your Honor.
Okay. Let me get this phone number. Okay. Deputy Gordon, if you could get this to Mr. Lewis's sister. That's the number. If you call, you'll get that voice you heard, ma'am. That'll be Ms. Bumpus. Ms. Bumpus, thank you for patching in, and we will see you at 1:30.
Thank you, Judge. See you at 1:30.
All right. Gosh, we've got a 4-defendant case. Raven Young. Hi, Ms. Young. I'm all right. How are you? Is Dwight Belcher here? All right, Ms. Young, you can come on up. Thanks, to the podium. Ms. Wood or Ms. Feely, is this, or would the,
So, good morning, Judge.
good morning.
So
You represent all of the, almost all.
it's very confusing because Tina Bryan is actually now with our office, but it appears that she had Ms. Young's case when she was with the conflict office. We have Mr. Furlow's case.
Okay.
Number 4, and then it looks like number 5 had a C3, and I don't believe.
Ms. Luncheon is on the call. Yeah, she's here. So we're good to go when we, but I don't know that Mr. Belcher is here. But we'll figure that out. So then there's also Mr. Sims.
Judge, I think that's.
Oh, that's a different number. Look at that. It's just flip those digits off. Good. So only 3 defendants. All right. So you represent Mr. Furlow. Mr. Furlow, it says loan out. So he is not here. Okay. All right. So we can't deal with Mr. Furlow today. Ms. Young, have you talked to anyone about representing you?
No, all I heard a couple of days ago was that I had a different lawyer, so I never talked to anybody.
Okay. So probably Mr. Johnson. We don't know. Okay.
Your Honor, I'll talk to her. 'Cause
Great.
I'm from that office.
Excellent. If you don't mind chatting with Ms. Young for a second, she clearly qualifies. That wasn't the concern. It was, I'd just love for her to leave with a name that she'll be able to associate. So there's a lawyer named Eric Johnson, Mr. Johnson, who handles several cases in here where there's more than one defendant and the public defender already represents someone, and Mr. Furlow has the public defender. This woman will chat with you a little bit, and maybe we'll figure out if that's going to be Mr. Johnson or not. I don't know if he can be here today. We're going to reach out to him. It'd be great if you two could connect, but I also don't want to make you wait around here all day. If he says, I'm going to be here at 3, we'll just reset it. But if he can be here or even appear virtually shortly, then do that. Okay, he's in the building, but he is stuck in another case. So if you would, can I have your last name? Walker. If you'd speak with Ms. Walker, she's a colleague of Mr. Johnson's, and I don't think we'll be able to do your arraignment today, which is okay. We'll just get you another date to come back.
Okay.
I'm going to confirm we've got a good address for you and all that, and then you'll probably be able to be on your way, okay?
Okay.
But while you're standing right there, let me look that up. So I have an address in Stockbridge. You live in Stockbridge.
Right now I currently reside with my mom.
So we need to be able to mail things to you. Is that address in Stockbridge where you stay, or you stay somewhere different?
Y'all can mail the information to that house.
Well, who lives there?
I'm gonna be moving back in soon.
But if I mailed something tomorrow, would it just get thrown away, or people at that address know you?
They know it's an apartment complex.
Okay, on Carrington Ridge? Okay, and when will you be back there?
Before next month. Like I could still go back to the apartment right now.
Okay, so it's still being rent, it's not empty.
Yeah, it's not.
Okay, all right. Let me check one other thing. So Carrington Ridge 101?
Yes, sir.
Okay. Let me look at one other thing. Is this one of these indictments where the victim is a co-defendant? Because Ms. Young's bond says no contact with the victim, Denzel Furlow.
I don't believe so, Your Honor. I think that they're all three true co-defendants, at least from my review of the file.
Okay. Well, you've reviewed much more than I have. I was just looking at Ms. Young's bond to make sure we're following it. No, you're right. The alleged victim is someone named Bristow.
That's correct, Your Honor.
Okay. All right. So Ms. Young, Ms. Walker will chat with you real briefly. When she's done talking with you, you're free to go.
Okay.
We're going to need to bring you back here, or at least connect you with Mr. Johnson. He may talk with you and do what we call waive arraignment, which means you don't need to come back for that. And then we can get your case moving along. I just going to remind you, this address that's in the system is where all the official notices will go, the address in Stockbridge. So that's how you'll know when to come back to court, if something will come in the mail. If that's not an address that's working for you, you need to let us know a better address. Okay? All right. Ms. Walker, you mind speaking with Ms. Young?
Not at all.
Thank you so much. All right. So Ms. Wood, will you be handling Mr. Furlow's case?
Yes, sir.
All right. He is not here. Loan out mean he didn't get brought over because of congestion, or? Okay, he's not at Rice Street.
It looks like I was doing a little bit of research, Judge. It looks like he's been with Union County since May. I'm not sure what's going on down there, but he
Okay, all
also has some other holds, so.
right. We'll do our best to get him back. And I guess we'll have to reset that. And that gets us to Ms. Lunchen's client, Dwight Belcher, who is on bond. Mr. Belcher? Hey, Ms. Lunchen, how are you doing?
Hey, Judge, I'm good. I haven't heard anything from Mr. Belcher, unfortunately.
All right, let's look up, his situation. I'm curious, has he hired you? Did you get this through C3? How did you get in the mix?
Right. So I got this through C3. And I don't know. I realized he was on the calendar today because Mr. Jordan did send me discovery yesterday. But that was my first inclination that he was on this calendar. So, I don't know whether he received notice or not.
Okay. He has an ankle monitor, I think, this bond. He's ankle monitor through the jail, curfew. He should be very findable. So let's see if the address matches what's on the bond. And there's supposedly a warrant for him.
And I don't know if the state knows if he's in custody somewhere else.
Yeah, so he's got two different addresses in the system, which are both different from the one on his bond. So that's interesting. Oh, no, that's where he's supposed to stay away from in the bond. So hopefully he's not there. He would have received notice at a either Lithonia or Atlanta address. And like I said, there's a warrant for him. But you have not heard from him. So what I think I'll do is issue a bench warrant for Mr. Belcher, but Ms. Luncheon, if you have contact with him and it was a mailing issue, that mail went to the Atlanta address that's in the system and not Lithonia or vice versa, I'm happy to work through it as a walk-in.
Great. Thank you, Judge.
You're welcome. One last question and then I'll let you go. When you say you got this as a C3, was that through the court C3 program or through GPDC or some new?
No, this was on, I got this case probably in like 2020 through GPDC.
Okay.
I'm switched over.
Got it. So this is actually a real old, I mean, it's a new indictment, but oh, look at that, right? October 2020. Well, thank you for sticking with it. We'll see if we can track Mr. Belcher down and we know how to reach you, but it looks like no one gets arraigned today on this case.
Understood, Judge.
All right. Thanks for joining us.
Thank you.
Well, let's see if we can get an arraignment out of this. How about Marquez Sims? And I apologize if I mispronounced your first name. Oh, he's in custody. Okay. How am I? Okay. Yeah. Thank you, Ms. Walker. Did you give her Mr. Johnson's contact information or what was the exchange?
Yes, my contact information is contact information and who our investigator is that's gonna start on the process.
Excellent. Okay. Good morning, Mr. Sims.
Come on.
Who is handling Mr. Sims's case?
That'll be fine.
Ms. Wood, great. Mr. Sims, today is plea and arraignment day for you. I'm gonna ask Ms. Wood, your attorney, if she's waiving arraignment for you or what's going on with your case, and we'll go from there. Ms. Wood?
Thank you, Judge. Yes, we will be waiving formal arraignment and if we are not guilty, I will get all that paperwork in. Also, I just want to let the court know he's got an unindicted case, so I'll see what we can do about taking care of everything together.
Excellent. So, Mr. Jordan, a skill set you may have developed with Judge Eaton, but will be valuable here is the ability to get things accused. If counsel for the defendant says we'd really like to work out the CP case as well, and it's within your wheelhouse of accusing. If it's a rape, you may not be able to get that accused, but if it's something that is they waive indictment or is otherwise accusable, that often is what prevents us from working something out.
Yes, Your Honor, understood.
Great. So Mr. Sims, I don't know what your unindicted charges are, but Ms. Wood is aware of them. She's going to be talking with you after she gets discovery in this case. You're charged with aggravated assault and a couple other things. And I'll enter a scheduling order. You'll come back here next, either because there's a motion that your lawyers filed that we need to hear about, or because your lawyer and you have worked something out with the state and will be resolving your cases. Okay? Any questions?
No, sir, I don't think so.
All right. See you soon.
See you.
And Judge, for the court's information, that'll be my case.
All right. Well, it's still helpful to be able to accuse cases.
And that's why I didn't interrupt, Your Honor, because even though I was gonna say it was 88 Wettenauer's case, that was still useful information, so.
Yeah. All right. Well, we'll see if Mr. Whitenauer can get things accused too. He's done it before. All right. Mr. Kuntz, before we bring Mr. Kuntz out, this is an Eric Johnson case. So he's not here. Ms. Walker, did you want to meet with Mr. Kuntz?
I can, Your Honor.
I didn't think Kuntz was not brought over. I thought that it was gonna be Miss Feely's case. I was told not that they were gonna do a waiver or waiver.
Okay, it says Eric Johnson on it. Oh, Mr. Kuntz, if I'm remembering, this is the right guy. He actually hired Eric Johnson, but on an old case. He's got several irons in the fire, and this is his trafficking one. And I think Mr. Johnson was going to speak with Mr. Kuntz, but not wearing the alternative defender hat, but the Eric Johnson PC hat. What do you understand about the situation, Ms. Feely?
gentleman that I referred to as a Renaissance man on Friday. I do represent him on his other serious case. I did not have his files with me when I filed the waiver, and I did not catch that he had, in fact, I believe, hired on this particular case. So I do represent him on the other case.
Right. This trafficking is from long ago. And when it was a CP matter, he had hired Mr. Johnson. And I think Mr. Johnson thought he was sticking with it. Okay. But he is stuck in another courtroom. So this is yours, Mr. Jordan.
That is correct, Your Honor. And I was present on Friday and understood from the conversation as well that Mr. Johnson was sticking with just the trafficking. So
Okay.
I
Got it.
sent him discovery on this case.
Ms. Feely, the case, do you have the other two cases?
I believe so.
Okay. And those we've already arraigned? All right. So we need to, either Mr. Johnson needs to do a waiver or we need to bring Mr. Kuntz back at some point. But that's where we are with that one. All right. No?
She did the waiver, but Mr. Johnson has to do the waiver.
Oh, you already did a waiver for Mr. Kuntz.
I was working from the courthouse office and it didn't have a file, and so it just didn't pick up on that error.
Yeah, Mr. Johnson needs to do that,
Yes, I'll reach out.
but he can also do a waiver. Okay. All right. So I think what we can do before I have to go get sworn in, are there any quick, I don't want to do the revocation. Mr. Hardiman is going to need to talk a little bit, so we'll come back and do that. Is Baron Carter here? Is he, I don't know if he's on bond or.
I spoke with Attorney Blevins, Your Honor. He did send me a waiver of arraignment. I'm not sure if he filed it with the court, but he also has discovery, so we're negotiating in that case. But he did inform me that he put in a waiver of arraignment.
They did. Excellent. Waived. Thank you, Mr. Jordan. How about Jonathan Huff? Before we bring him out, Ms. Wood, Ms. Feely.
I think this will be series.
Okay, it's position 12. Can we bring him out for a waiver or an actual arraignment? I'm just trying to clear some of the folks up back there. Let's bring Mr. Huff out, please. Is Scotty Wyatt back there also? Is that a name? Okay. Ms. Elder? Oop. All right, well, we're waiting for Mr. Huff. What case are you folks, ma'am in the pink jacket, what case are you here for?
Mr. Jones.
Mr. Jones? Okay, got it. Yeah, I gotta. Hey, Mr. Huff.
Sir.
I'm Judge McBurney. Today's your plea and arraignment day. Ms. Feely is the lawyer who has been assigned to represent you. I'm gonna ask her whether you're waiving arraignment or not. There she is. Whether you're waiving arraignment, and then I'll talk to you a little bit about what's going to flow from that. Okay, Ms. Feely?
Yes, Your Honor, we are entering a not guilty plea at this time. We've waived formal arraignment. I would like an opportunity to look into this a little bit further because it seems like he may have one other thing going on. Otherwise, I may speak to the state about resolving this case.
Okay. When you say one other thing going on, meaning an unindicted case?
It looked like a probation matter. I'm still looking into it.
Okay. Well, we might be able to handle that as well. So, Mr. Huff, what I'm going to do next is entering a schedule. I will enter a scheduling order in your case, which will get some deadlines in to make sure your case moves forward. It sounds like Ms. Feely is going to talk with you as well as the prosecutor. Mr. Jordan, is this your case or is this another unit?
Case, Judge.
Yes, Your Honor.
Mr. Whitenauer's case. All right. Ms. Feely is going to talk with the prosecutor, that voice you just heard, about maybe sorting the case out as well. But she does need to understand if you've got one other item that might be keeping you in custody. Okay?
Yes, sir.
Any questions?
No, sir.
All right. Ms. Feely, you'd like Mr. Huff to stay here?
For now, yes.
Okay. Got it. Then let's bring Mr. Wyatt out. Is that also, that's position 14. Is that?
And that's also aiding with our.
Okay. So it sounds like one of the first things you did upon replacing Mr. Hand is make Mr. Whitenauer take all your cases. That's pretty good because these all say Pierce Hand on them.
Yes. That was part of the exchange.
Yeah. Ms. Feely, is Mr. Wyatt your case? Okay. Good morning, Mr. Wyatt.
Good morning.
How are you? Can you slide that way a little bit? There we go. I just want to introduce you to Ms. Feely. That's your lawyer. If you haven't met before, she will be handling your case for you. And today's a day to meet her. It's also a day for me to understand how you guys are moving forward. If your lawyer is going to waive arraignment for you, then I'll get a scheduling order out, or if we're doing a formal arraignment. How are we proceeding?
Yes, Your Honor, we would waive formal arraignment, enter a not guilty plea at this time and ask for scheduling order.
Okay, so Mr. Wyatt, what is next is I'll enter an order that gives the prosecutor a deadline to get all the discovery to your lawyer so she can come meet with you to show you what the state has and doesn't have. You and your lawyer will talk about whether there are motions that she ought to file, a motion to suppress or something like that. If there are motions filed, that'll be when I see you next, because we have to come hear those motions and argue them, and I need to rule on them. Otherwise, I'll see you next either because you and Ms. Feely have come up with a way to work the case out that you're comfortable with, or to get you a trial, and the state will need to prove its case against you. Does that make sense?
Yes, sir.
Any questions?
Sir, what about a bond reduction or something?
Good question. That would be one of those motions I mentioned. So Ms. Feely needs to learn a little bit more about your situation and why you're in, and criminal history and any alleged victim. And then she will give you her thoughts about whether it makes sense to ask for a bond reduction. And if she agrees with you, then she'll file that. And that would be one of the reasons I'd see you before you resolve your case. So that's definitely an option. Ms. Feely just needs to learn a little bit more about your case so that she can make the right arguments if there are good arguments for a bond reduction. Okay?
Okay.
So if that's in the cards, I'll see you soon about that. Anything else?
Yes, like how soon?
It's a good question. It won't be this week. It'll probably be early in the new year if a bond reduction is something that Ms. Feely agrees with you is a wise move. It may be she looks at this and says, forget about bond reduction, let's work the case out, because you let her know this is what really happened, and she talks to the prosecutor, and maybe there's a lot of confusion here and the allegations aren't really what they look like. But that's something that the two of you need to talk about before Ms. Feely can get that overall strategy of, you know what, this could be a little bit of a messy case, so let's try to get you a lower bond. Let's work on finding some witnesses. Let's file some other motions. She'll be coming up with those ideas. Okay. All right. I'll see you soon.
Okay.
All right. Let me ask at Dodge State, do we have Mr. Hardiman for a little bit longer? Because I have to go get sworn in so that I can keep being a judge. I want to make sure we've got Mr. Hardiman for a few more minutes. Are you able to unmute things, Mr. Hardiman?
He'll be right here.
Okay, and do we have a few more minutes, or do you need to get someone else in front of that camera?
No, he's the only one for today.
Okay, great. We'll be back as soon as I can, and we'll do Hardiman next. Let me ask in the where'd that met in the Tyrone Robinson matter, and you're here for that, Ms. Walker.
I am your honor.
Do you have a lot of folks here for that from the county side? Because I don't want to make those folks wait around too much either. I don't want to make people wait at all, but I'm balancing things.
Yes, Your Honor, we're here from the county attorney's office as well.
Okay, yeah, my understanding is that Mr. Regis subpoenaed from the sheriff on down, like the top 27 officials in the office. Okay, all right, I'm sorry to keep you waiting. When we get back, let's handle Mr. Hardiman, and then let's do when I get back, we'll handle Mr. Hardiman, and then we'll do the Robinson bond motion, okay? Thank you. All right, I'll be back soon. Wish me luck.
I'm just summarizing these.
See, I'm morning. Yeah, if he's easier to. And you.
Did Jasmine say the name of the expert that's testifying at 1? At 11?
Yes, I need to talk to him about that, you guys. Okay? Yeah. Hold on. Like, he's nice and happy.
Page 9. Well, there's 10, I think. So there's 9, 10, 11. I see 11. I thought you said there were 13. Oh, yeah. Mine are a mess. I've like printed everything at once. So let's see.
Your mics are still on.
Thank you. Can't turn them off. Are we able to turn the mics off? It came back on. Can you hear us?
I can hear off of other mics in the courtroom. I was just wondering if the table mics were on.
No worries. Thank you, Doug.
Dodge. That's hers. The very large. No, just the weather changes, there I go. You're welcome. That's a COVID, everybody's like. No, it's just the science street.
Now I Let's just take it from that one. Throw away all the
Come on, man, go. Oh, you put on the neighbor's thing.
All makes sense, right? This is all the jail stuff, right? Here's for front and back. And then this is just the version. I didn't know. Oh, no, I just want to be sure something. Yeah. Huh? Yeah.
No, I gotta go to the phone. No, you gotta be outside for a
You have to re-up that same oath.
Congratulations on that.
I'm official. Good thing we didn't try to take any pleas before then.
Congratulations.
Thanks. It feels the same, but. All right, Mr. Hardiman, if you will come off mute, we're going to get on the record in your case. There he is. Let's do this. Spotlight. There he is. All right, so let's get on the record in your case. You do. Is she back talking with inmates? All right. Yes, we do. Thank you. Okay, let's go on the record in 21 SC 179555, State versus Johnny Hardiman. Mr. Hardiman was charged in that case with carjacking. And if I pull this case back up, at the end of August of this year, he entered a non-negotiated plea. I sentenced Mr. Hardiman to 20 years to serve 15 with the balance on probation, followed by 5 years consecutive probation for a firearms charge. This plea was in conjunction with pleas to 2 other cases. So Mr. Hardiman resolved 3 cases round about the 31st of August of this year. And then Mr. Hardiman wrote a letter to me that I'll make sure we get copies to everyone. Have you seen it, Ms. Wood?
Miss Nelson shared it with me, Judge.
Okay, Mr. Jordan, have you seen it?
I have not seen it yet, Your Honor.
Okay. Well, guess what? I'm going to do this. If you want to take a seat, you can look on your screen and you'll see it. It is a one-page letter. It asks me how I'm doing, and then it gets down to business. Mr. Hardiman indicates that he wants to withdraw his plea. He alleges that Ms. Woods didn't give him knowledge of important details and that she allegedly forced him into taking the plea by using scare tactics such as trial. I'm going to let Mr. Hardiman elaborate on this, but he, in the letter, bounces between, I think I should have a lower sentence, as in I want you to modify or amend my sentence, and I want to withdraw my plea. But this letter was written on August 31st, so the day of the plea, presumably when he got back to his cell, and then we received it in chambers in September. You can see that date stamp on there. So what I'd like to do is hand things over to Mr. Hardiman to let him share his perspective on what his concerns are, and then we'll be, in a better position for Ms. Wood to respond if she has anything she wants to share in response. And Mr. Jordan, of course, will hear from the state as well about the standards for withdrawing a plea and things like that, because it doesn't just happen because someone asked for it. Mr. Hardiman, why don't you tell me, please, why you think you ought to be able to withdraw your plea, assuming that's what you still want to do.
How you doing today, Judge? I actually no longer care about withdrawing the plea anymore because I'm already being sentenced. I'm already incarcerated. I'm already at prison. I've been through diagnosis already, so it's like I had a change of mind. You feel me? Like, so, Your Honor, I understand the circumstances. I understand I'm not in position to determine the outcome of my case, but actually, I just look at it like it was important detail that wasn't shared with me during the process.
Got it. Okay, well, I appreciate you sharing that. So what I'm hearing you say, Mr. Hardiman, is that insofar as your letter, your very thoughtful letter you sent to me might have been read as a motion to withdraw a plea, you are now withdrawing that motion, saying, you know what, Judge, I meant some of the things I said, but I've moved past that and I don't want to pursue that anymore. Is that a fair statement?
Yes, sir, Your Honor.
Okay. Is Dodge State where you've been designated for now, or is that still part of diagnostics?
That's just where I'm located for now.
Okay. Did they say how long you'll be there before you move?
I don't know if I'll be here for the next 20 years or what, Your Honor.
Okay. Well, it won't be 20 years. It'll be less than that, but got it. All right. Mr. Jordan, is there anything you want to add?
No, Your Honor.
Mr. Hardiman, I appreciate you being patient. I know I had to go handle this one appointment. I hope you have a good holiday down there in Dodge State, and you know how to reach me. You can always send something if there is a legal issue that you have with one of your 3 cases that you and I worked on, okay?
Yes, sir. I also have a question, Your Honor.
What's that?
They said something about I had a hold or something like that for a while. It's like an open case. I was concerned about that, Your Honor.
Okay. Was it out of Fulton County, or would you have had business in a different county?
Fulton County is the only county that I have been arrested in.
Okay. Well, we're checking right now. I'll let you know if there are any holds. I would not want that to interfere with your ability to move around with Department of Corrections or get into any program or anything like that.
Yes, sir.
Back in 2015 and 14.
Okay. So you, Mr. Hardiman, have some electronic warrants. Don't worry about the electronic word, but way back when you would have had matters in juvenile court. So those are old and extinguished. You aren't a juvenile anymore. So we're not seeing any holds that would prevent you from participating in anything. But let me tell you this, if you raise your hand to be a trustee or to be relocated or something like that, and you're told no because of these holds, please reach out and we'll do what we can to clear it up. But there's nothing that ought to prevent you from doing something like that, okay?
Yes, sir.
All right. Take care.
All right. Have a nice day.
You too. Thank you, Dodge State. Let us turn then to Tyrone Robinson. Ms. Walker, are you ready for Mr. Robinson to come out, or are there things you need to talk about before he comes out?
I believe that there's a motion that you need to address, Your Honor.
Okay. Would you like Mr. Robinson? Why don't we get Mr. Robinson out here for that? I just wasn't, sometimes there are logistics that you want me to know about, but let's get Mr. Robinson out here. And I'll ask Ms. Wood or Ms. Feely to slide over so we can get Mr. Robinson next to Ms. Walker.
We've lost audio on the Zoom.
Ms. Jackson, can you hear us now?
Yes, Your Honor.
Great. Good morning. Thank you for being here.
Good morning.
All right. System's working again. Ms. Walker, I interrupted you and I apologize, but I got the alert that the sound wasn't transmitting outside the room. I could hear you just fine, but the rest of the world couldn't. What did you want to get on the record before I hear from the county attorney's office?
Thank you, Your Honor. I was simply wanting to state, in an effort not to prolong these proceedings, if you would like to take judicial notice of the conditions at the jail, the overcrowding, the many jail fights, the deaths that have occurred, and the infectious disease outbreaks, we can forego that.
Okay. I do want the county attorney's office to be heard briefly, but I'll want to hear from the state in terms of judicial notice, but everything you've described, I'm aware of, and is certainly something that I think about when we're talking about bond for anyone. They've been there one day or hundreds and hundreds of days, which is Mr. Robinson's situation. So I think we will be able to short circuit this a little bit, but I want to make sure the county attorney's office gets to be heard. So if you would get on the record for the county attorney's office and let me know what you want to add, please.
Sure, yes. My name is Sandy Malord. I'm from the county attorney's office. We represent the officers that were subpoenaed in this matter. It's pretty straightforward from our end. We didn't get proper service. It was said via email, not personal service certified. My understanding was the officers were going to be called to testify to the conditions at the jail. It's also my understanding that that's not one of the ILO conditions that's considered for a bail bond. And for those reasons, Your Honor, we'd ask for the subpoenas to be quashed.
Can you spell your last name?
Sure, Malord, M-I-L-O-R-D.
Great. I agree with everything you said. I think we don't need to litigate it. What I'm going to do is deny your motion as moot because of what Ms. Walker shared and I think the general information that people have about some of the things that are happening at the jail. I'm not going to require it to reach the level of proof primarily for that last point you made, which is it's really not an IALA factor. It's a human rights factor that we ought to be thoughtful of. And I am certainly thoughtful of and considerate in each decision I make on bond. But there isn't a fifth IALA factor, which is how miserable is it in place X where someone's being held.
Understood.
So I appreciate you being here. I know that it created a little bit of a fire drill for the sheriff's office and then ultimately the county attorney's office. I know the sheriff is laser focused right now on getting this YSL proceeding safely moving. And that has been a very, very heavy lift and his office has been doing a good job with that. And that doesn't mean that in the future, an official from the office would not need to come into a courtroom somewhere in Fulton County to address the concerns that I think I'll hear about from Ms. Walker. So I think with proper service, then we'd be having a different conversation. But I think your points are all well taken.
Understood, Your
All
Honor.
right.
Thank you for your time.
Thank you for being here and the rest of your team. All right.
Thank you.
So with that, Ms. Walker, do you want to shift now to making your argument for it's bond reduction? Mr. Robinson has a bond, one of the largest bonds on my docket. So it's a motion for bond reduction. If you are ready for that, I am ready for you.
Good morning again, Your Honor. Joy Walker for Mr. Robinson. Mr. Robinson has been in jail more than 1,000 days. He was originally given a bond of $850,000 because he had not been indicted within the 90-day rule. And that bond was in essence a no bond. And it was he had no ability or means to make it. At the time he was arrested, he was 20 years old, had not completed high school and didn't have any means of making that bond, but the judge wanted to put a bond on the record. And
had to because of the 90 days.
Right.
Yep.
And they didn't consider any of the IALA factors. The state's going to discuss with you, which I think it's at this moment in time, is that you should give some deference, but the deference you should give is minor, of his juvenile record. Mr. Robinson was entitled to have his juvenile record sealed, but no one took him through that process. And thus they're going to bring up his juvenile record in this proceedings. Other than that, other than his juvenile record, he is, as an adult, this is his one of his only offenses. He may have another one, but I'm not sure on that. Mr. Robinson has been in Georgia, in Atlanta his entire life. He can live with his mother. And he is one of the few defendants that we are representing that's been in jail this long, that has not been a part of any of the jail fights. He has done a great job keeping himself out of the fray.
Good word.
And so he is not, he has roots in the community. He does not, won't reoffend. He does, and the reason why we're saying he's not gonna reoffend is that we're gonna ask your honor to give him a bond. We're asking for a signature bond, but if not a signature bond, a reasonable bond, and put him on 24-hour arrest with an ankle bracelet through the overcrowding jail program. His case is coming up soon, and we need to work with him to get the particulars of this case, because as you are aware, many times this case has come before you, the parties, the original defendants have rotated, and some are turning state's evidence and those kinds of things. And we need him to let us know what exactly happened that night and take us through it. So we would like for him to have an ankle monitor and 24 hours house arrest, except if he's visiting with his attorney, and we're working on those specific cases. And Your Honor, the conditions at the jail as it stands now, as I meant earlier, I know that's not an IOLA factor, but that's dangerous. And it's specifically dangerous for somebody as young as he is, that has not had the finesse of finishing high school, to continue to stay out of that fray and not to get in further trouble, because it appears that those encounters are happening daily. Additionally, we've got some place for him to stay.
This is mom's house.
This is mom's house.
And was Mr. Robinson living with his mother at the time of the alleged incident?
Mr. Robinson.
I was down my mother for a little street. I was down my mom for a little.
Yes, yes, Your Honor.
Okay.
My client categorically denies the facts surrounding this incident. There's a lot that's going on, and we're now trying to delve into it a little further. Mr. Regis has interviewed him extensively. Our investigator Benham has interviewed him also, and we're ready to fight this case in court. And we just need him out of that situation, because it's so detrimental to him, given the fact that there's deaths, there are diseases, there are fights, and he is still standing after more than 1,000 days. And that's my argument today, Your Honor.
Okay.
Thank you.
Thank you, Ms. Walker, for that, and also for agreeing to pinch hit for Mr. Regis today so that we were able to move it forward. All right, and on behalf of the state.
Good morning, Judge McBurney. I'm here on behalf of the DA's office, on behalf of ADA Reeves Hiles. Your Honor, let me start with the jail. Oh, I'm sorry, Laura, Laura. Jansen is Janssen. Chief Senior Assistant DA on this case. Judge, it's interesting that Ms. Walker said that he has stayed out of the fray. He has had 11 incidents at the jail fighting. Let me go through these, Judge. I know that a lot of times when the court has a bond hearing and has there been some change in circumstances since the last bond hearing when bond was made? What has changed? He has actually made it worse to the point where he doesn't even deserve this good bond. He was entitled to it when he got it, because truly, I agree, it wasn't indicted until actually about a year after the incident, but it is now indicted. Here's how he has spent his time in the jail. Incident 1. Now let's remember, he got arrested, went into the jail December 6, 2019. Episode number 1, December 28, 2019. Defendant physically attacked another inmate. It took a taser to get him to stop. He was sentenced to lockdown, charged with rule violations. Incident number 2, April 15, 2021, fighting another inmate. Incident number 3, May 18th, 2021. While he was on lockdown already for a previous incident, he refused to let the cell door shut when that deputy came up. He then called the deputy a police ass hoe. I should fuck you up. Lunged toward the police officer. The taser failed the first time. Took a second time to get the taser to get him to stop his obstruction. Number 4, June 19th, 2021. Here we get into weapons. The defendant had a sharp item in his waistband. He then when they found it, he admitted to having a shank. So see, he's got weapons. So when we talk about how dangerous the jail is, he's making it more dangerous. He's part of the danger and the daily encounters. I'm using the defense's own words. He's part of this. He's also, here we go, incident number 5. June 21st, 2021, the defendant stabbed another inmate under his right eye, causing major injuries from a fight. The defendant had slid a shank. Let's remember, he just had a shank 2 days before that was taken away from him. He got a hold of another shank, slid it under the door. Number 6.
How many incidents did you say there were?
11.
Okay.
Number 6. November 29th, 2021, and that one, his back was bleeding. He refused to say what happened. Every single one of these incidents, he refuses to make statements.
Okay.
So I can't say, but that's an incident. Number 7, December 15th, 2021. This one was not violent. This was him masturbating in public in the jail. He would not stop, and he had to be stopped and given another lockdown. Number 8, January 18th, now they're in 2022. He, along with 3 other inmates, jumped and stabbed another inmate. That's his 3rd stabbing. Number 9, January 19th, the next day. So they are daily encounters, but he's in them. Defendant not getting along with his cellmate, bullying him, constant conflict. They had to be separated. Incident number 10. April 22nd, 2022, failed to obey the guards. Again, they tried to pepper spray him. He wouldn't stop. He had to be pepper sprayed again. So he's every time it's an obstruction as well. Number 11, judge on this one, June 15th, 2022, he had a man-made knife, otherwise known as a shank, and he stabbed another inmate in the back and the neck. So he does not even deserve the bond that he has at this point that was given to him, that he was entitled to, but does he deserve it? And does the community deserve to have somebody back out there? When we look at the IALA factors, Judge, danger to the community, if this is what he can do in a detention facility where he has to make his weapons and where he is so desperate to get another one as soon as one is taken away, how much easier will it be for him out in the community when he has access to real weapons, such as firearms, real knives he doesn't have to make, and he has no problem getting a hold of these things. And he is, hopelessly attracted to always having a weapon on him. Now, Judge, what we go to is what led up to this incident. And I will flatly deny that he has had any right to have any of his juvenile records sealed, because under 1511-703, all of these, yes, can be used in this case. Furthermore, Judge, these cases for which he was adjudicated in juvenile court are Class A and Class B designated felonies. Those don't get sealed. So that's an absolute misstatement of the juvenile law. So let me go toward that, Judge, and let you know that he actually started committing crimes, which at the age of 13 for him were called delinquencies, but the same crimes that are in our statutory book, they're the same crimes. 8/23/13, entering auto, possession of tools for a crime. That was adjudicated. He was adjudicated delinquent. Even though he was sentenced for that, it did not stop him. Then when he was 15, March 28, 2015, aggravated assault. He's already escalating and already using weapons back when he was 15. And again, Judge, that is a designated felony. He was adjudicated guilty for and sentenced. Nonetheless, 2 months later, May 10th, 2015, when he was still 15 years old, he was found delinquent for false imprisonment, possession of a pistol by a minor, and criminal damage in the second degree. We have a second firearm charge again within the same year by this defendant. When he turned 16, Judge, we have September 22nd, 2015, right after he turned 16, robbery. He was adjudicated delinquent for that. And that is my understanding, being used in this case. There will be a motion for that. When he was, going back to when he was 15, June 17th, 2015, entering auto, same crime that he did when he was 13, continuing to escalate, continuing to commit crimes while under sentence. Again, when he was 16, May 21st, 2016, criminal trespass, disorderly conduct. Finally, Judge, it gets worse as far as harm to other humans and not just property. His last adjudicated juvenile offense was when he was 16 on the date of August 18, 2016, aggravated battery and robbery against another person, for which, again, he was adjudicated guilty and sentenced. We go then right into this, Judge, the seriousness of these offenses. He has, just to sum it up, one count of home invasion in the first degree.
I'm familiar with
Yes.
what this case is about.
What I want you to know, Judge, is that the reason there are 7 counts of these violent crimes is because we have 7 victims. And 2 of them, as the court knows, had broken bones. And as the court knows, we have the gang charge. He is affiliated and committed to and a member of YSL, Young Slime Life.
So can we transfer this to Judge Glanville?
No.
No.
Nope. But thank you for,
Okay.
yeah, it was worth a try, Judge. His ties to the community are YSL. Again, he stated himself that he can live with his mother. But looking back at his juvenile records, I saw that it was his mother that was the guardian on all of the petitions. That has not prevented him from going out and hurting others in the community with weapons, and doing so in a group. He did these, the state is alleging that he harmed these 7 people to the benefit of the gang. It was premeditated and it was done in a group. We are concerned, as we often are in gang cases, with intimidation of witnesses. No, the state is not alleging that he has intimidated any witnesses, but there is the potential for that. I've spoken clearly now about the potential to commit, the propensity to commit another felony. His flight risk is large because he is now standing before a superior court judge on felony charges that carry a long sentence, which would give him no incentive to return back to the court to face these. It's different from juvenile now, and that makes a big difference in his life. So
Do you have any, Ms. Walker said she didn't think, but she wasn't going to commit to it, that Mr. Robinson had picked up any felony convictions as an adult. You seem to have very thorough records on Mr. Robinson. Does he have an adult criminal history?
I have nothing other than this, Judge.
This case?
Correct.
And then the juvenile history you
Correct.
described and the, we'll call it Rice Street history that he has. Okay.
And it could be that some of those were brought over for indictment, but at this time, my answer is no.
Okay.
Despite that. So, the judge, the state is, as you can tell, very concerned, even with the bond that he does have. If the court is in any way inclined to keep this bond and not go to no bond or reduce it, we would ask that the court add an additional condition that I didn't see in the original one, for no contact with co-defendants, and also pursuant to OCGA 1615-4 subsection L, no contact with known gang members. And of course, no weapons and everything else I'm sure Your Honor adds. So I thank you for hearing from us, Judge.
You're welcome, and thank you for filling in for Mr. Hiles. One question before you retreat. This is a case that the state has always announced ready on as long as I've had it. Does that remain the state's posture? It's cycled through several gang prosecutors, but I think Mr. Hiles had said he would be ready whenever it's called. His predecessor, I'm blanking on his name, was always Michael P. What was it? Parrish, Mr. Parrish. Thank you, whoever said that. Yes, Mr. Parrish was. I could go tomorrow. Let me know when, and that's just good because if it was the state that was causing this to be over 1,000 days old, then there's a whole nother factor that I need to evaluate. And as it bounces from prosecutor to prosecutor, I need to renew that inquiry. Mr. Parrish being ready doesn't mean Mr. Hiles is ready. He's got his own portfolio of cases, but you are happy to assert for him that he is ready when reached when it comes to, it's really Robinson and Pritchett. And it's not Mr. Robinson's fault that Mr. Pritchett is making it more complicated, but he does.
I understand. And yes, Mr. Hiles isn't going anywhere. He's
well, he goes to lots of places like the beach, apparently.
He
but
does, but he comes back always to the gang unit and
Okay.
to Your Honor's cases. He
All right.
remains. And then so the answer to that is yes. And I do appreciate the inquiry. I understand the inquiry, but I'm confident that Mr. Hiles will be ready when the court calls him to trial, Judge.
Great. And you were going to introduce someone to me at one point.
Yes, Your Honor, sitting with me, co-counsel, this is Jasmine Dilligard. She is a third-year law student practicing under that act. And so I just wanted to include her on the record.
Great. Welcome. Where are you a third-year law student?
Georgia State.
Georgia State. Fantastic. And how long have you been doing DA stuff?
I started with the DA's office in April of last year as the DA's executive assistant, and then she moved me over to gangs to get some trial experience. So.
Well, that's quite a shift from executive assistant to gangs.
She's also our gang writer, indictment writer.
Well, all right. That's a lot of writing to do. There's rarely a gang indictment that's only 1 or 2 counts and easy to process. So welcome.
Thank you, Judge.
You bet. Ms. Walker, as the movant, you get the last word. You just heard a whole lot. You may say I rest on what I had to say, but I want to give you a chance if there's something that you want to add to the mix, having heard Ms. Jansen's presentation on behalf of the state.
Yes, Your Honor, just very briefly, Ms. Jansen listed 11 incidences. Interestingly enough, there hasn't been a CP case taken out on any of those 11 incidences, so I am going to accept as an officer of the court that these incidents actually happened, but they did not rise to the level of a prosecution. So I want the judge, Your Honor, to realize that.
Sure. No, I appreciate that because Ms. Jansen would have given us the CP numbers if they were there. I think the sad reality of that, assuming they happen, and these are allegations, and I'm not thinking, oh my gosh, Mr. Robinson is a serial stabber, but it does sound like his time at Rice Street hasn't been as peaceful. Not that you described it as peaceful, you described it as horrific, but that maybe he was caught up in more of it than you were relaying. but the sad reality is, I think there's a numbness to it. And you know what? It's a stabbing and charges aren't brought. And that's unfortunate for everyone involved. So I hear what you're saying on that, but I don't know that it's necessarily remarkable anymore that someone is stabbed at the jail and there aren't charges brought. And that tells you a lot about what's going on at the jail. Okay. Mr. Robinson, I remain, as I have been throughout, committed to getting you your day in court. And the initial struggle when we were working together was to get you a lawyer after Ms. Taylor cycled off your case. And we've done that. And clearly Mr. Regis and his team are working hard on that. Ms. Walker, I meant to ask you a question beyond giving you an opportunity to add anything you wanted to add. It's the same question I asked Ms. Jansen. What is your sense? I know Mr. Regis is pulled in many directions, but he was very specific that this of the many cases he had to put that placeholder entry in. This was one that he was going to keep, and so I'm curious how soon you think he can be ready to move forward, because Mr. Pritchett is ready to go whenever, since he and Jesus are representing Mr. Pritchett. And Jesus is always around. The question is, when will Mr. Ray, I'll specially set it so we can protect him from other commitments. But what I can't do is imbue him with all the knowledge he needs to be ready to go on this.
He's just finishing up a murder trial in Emmanuel. He's still down there because I informed him of what was going on today. And as soon as he returns, can we contact everybody so they'll know he's got some specially set cases, and then he does our unit's murder trials. So as soon as I contact him, I will make sure that he notifies the court a specific month where it looks good.
Yeah, well, why don't we do that? Because then I'll figure out which weeks do I have criminal trial in that month, and then we can specially set it. This is old enough that special setting should protect us from other commitments Mr. Regis may have. But we need to get closure on this. And it sounds like closure may need to be a trial. It certainly will be for Mr. Pritchett. That's what he's relayed to me. I think I have the same understanding you do, that the two female co-defendants are going to resolve their matter short of trial. And so then that leaves Mr. Robinson. And we had a trial date when Ms. Taylor then rolled off. So
I inquired about the further hearing, Mr. Pritchett. I know that he intends to represent himself. I didn't know where that was in the process.
So, boy, I've tried 4 different times to get all the way through one. And I'm not using the right name. And how do I have sovereignty over him? And what are the laws? And who is the judge? So it's not for want of trying, but I've also done a fair amount of research, and it may be that we need to have a lawyer sit there, even though that lawyer has been told you don't represent me. But I'm going to work through that. That's not a Mr. Robinson problem. You bet, but it's a fair question. So, Mr. Robinson, I could lower your bond some, but I'm not interested in lowering your bond down to where you'd be able to make that bond. You're familiar with these charges. You know what this case is about. I'm familiar with the charges. I don't know what the case is about because I haven't seen all the discovery and whatnot, but this is a matter that's going to resolve by way of a trial. It sounds like it may be Mr. Regis gets close enough to the evidence that he wants to try to convince you to work it out, but the stakes are real high. What I will tell Ms. Walker and you is that I'm very open to working with the sheriff to see if there is a different location for you. We do house inmates in Cobb County, and I have had lawyers ask to have their client be in Cobb County because of a specific situation at Rice Street. And if I ask nicely and do it the right way, sometimes that can happen. So I can't guarantee it. It's understandably and appropriately the sheriff's decision and not mine. But rather than play a game like, well, I'm a lawyer bond of $500,000. I don't know where 850 came from. That's a crazy number, but I think it is reflective of the seriousness of the charges and the more I learned about some of the issues you were working through, both as a juvenile and at the jail, I'm not inclined to either turn it into no bond, which I think was Ms. Jansen's request ultimately. And in theory, there'd be a basis to do it, but that's not what I'm going to do. I don't want to tweak it at all. I want to make sure you've got the lawyer. We've done that. And then we need to figure out when can we get you and that lawyer in court with a jury so that once and for all, the jury can say, here's what happened in December of 2019 at that Airbnb party. So I'm going to look to you, Ms. Walker, to convey to Mr. Regis the need to get hopefully it's in 2023, a month. And he may say, look, it's half of this month and then half of an adjacent month. But that's what I need to get from Mr. Regis so that we can give everyone, including Mr. Robinson, the certainty of here's our trial date. And so I won't call it light at the end of the tunnel because I don't know how the trial will play out, but it's that knowing this is my end date. And after that, not guilty, I go home. Guilty, I'm not at Rice Street anymore. I'm going somewhere else. But that's where this case needs to end up. And I want to reiterate, I don't find that Mr. Robinson has done anything to slow it down. The state has done nothing to slow it down. The system hasn't worked right for Mr. Robinson. Once his retained attorney rolled off, we should have been able to have someone parachute in to sit next to Mr. Robinson and navigate it with him. And we weren't able to do that. But GPDC and the court are now working hard together to make the C3 practice a meaningful reality for defendants. And I'm grateful to Ms. Ali on down from GPDC and my colleagues here for setting up that parallel program that's partnering with GPDC. Ms. Jansen, anything else from the state on behalf of the state in connection with Mr. Robinson's case?
Just one more thing, Your Honor. I should have told you, the state does not object to him being moved to a different facility. So just wanted to put that on the record. That's never an issue for the state.
Okay. I didn't think so. I want to be clear. This isn't because I think it's a scenario where, he's got to be away from co-defendants. It's more what he's been enduring and what Ms. Walker described. And frankly, some of what Ms. Jansen described, that a change of scenery might help settle things down a little bit. But that's a conversation for Mr. Robinson to have with counsel, and then just reach out to Ms. Nelson and I will take it from there as best I am able. Mr. Robinson, I know you were sharing some things with Ms. Walker as we were working through all this. Do you have any questions for me? This isn't the time for you to tell me, hey, I didn't do these things, or let me tell you what really happened in the case. But do you have any questions about the process I've described? You do? Why don't you tell Ms. Walker what the question is, and if she says, go for it, you can ask.
Your Honor, his question is not about process.
Okay. Then you and or Mr. Regis can help Mr. Robinson with that. I appreciate everyone's time on this. And again, thank you to County Attorney's Office for covering this. I wish we could have gotten you in here before today, but it's not how schedules work at the end of the year. Thanks for your work. So third year Practice Act person, will you be following Ms. Jansen around, or you follow gang attorneys where they go?
I work really closely with Jansen. She helps me a lot with the indictment writing, but I follow wherever I can learn, so.
Excellent. Well, enjoy it.
May I excuse Your Honor?
Yes, ma'am. Was that it for Mr. Regis? I think it was.
Yes.
Thanks for your time. Nice to meet you.
Nice to meet you, sir. You'll see me periodically.
Good.
All right.
Seeing people from your office is a good thing.
And that's specifically because Mr. Johnson is going to be at YSL.
Yes, we are doing double fingers and toes crossed that his case works out in there. It was every time there's a plea, I get online to see, was that Eric Johnson's? And so far it hasn't been.
We'll keep you posted on that. We make sure that your courtroom is covered.
Great, thank you so much.
Your Honor, thank you. And this does conclude my business. I am our third year practice lawyer. Be excused.
You may. Thanks for coming by.
Thank you, Judge.
So Ms. Feely, I think this is your case. We were going to do Calvin Coley next. If we just go back to that calendar. Or is that Ms. Woods? It says Ms. Patel, so I assume that went from. I don't have a warrant for Coley. Can you, that's position 8. My guess is it's based on the new charges. You're all alone, Mr. Jordan. Good luck.
Thank you, Your Honor.
Oh, yeah, I can put it on back. Yeah, that's fine. Thank you.
Okay.
Judge, would you like me to send you a copy of the warrant?
I think I just got it from Ms. Nelson. Thank you so much.
Okay, no problem.
Can we make sure that this is the right warrant? Because we've already resolved this one. Mr. Do you pronounce it Coley?
Coley.
Mr. Coley had a revocation hearing in January of 2021. I revoked 150 days, and it was based on this warrant. So, Ms. Tucson, do you have a warrant that is more current than the one from May? Well, I guess I signed one July 1, 2020. There should be a newer one that's based on the charges that Mr. Coley has in front of Judge Edwards. He's got an aggravated assault case in Judge Edwards. Ms. Wood, do you have anything?
I am an updated one.
Mr. Jordan, do you have any? The only warrant I see is one that we've already dealt with.
Your Honor, I don't. I didn't see a new warrant based on the charge that's currently with Judge Edwards' courtroom.
Okay.
I believe that we had a stipulated agreement, but only as sounds like it may have been revoked previously.
Yeah, I don't want Mr. Coley to stipulate to something he's already stipulated to. Ms. Tucson, do you have is there an active warrant for Mr. Coley from probation?
Yes, it's showing still active, signed for the 18 SC 158735, and it was signed May 4th, 2021.
May 4th, 2020 or May 4th, 2021?
May 4th, 2021 by you.
Okay, that one I don't have.
I'll send it over to Ms. Nelson right now.
Okay, thank you.
No problem.
So that's the one.
Okay.
So this is it.
Mhm. Yeah, we're good.
Interesting. Okay, here it is. Let me put it up on the screen so everyone can see it. All right, so Mr. Coley is alleged to have violated criminal law by, in April of 2021, committing the new offense of aggravated assault in DeKalb County. This was a warrant that I signed on May 4th of last year. That can't be the case that's in front of Judge Edwards, because that's an aggravated assault that happened in Fulton County. It doesn't sound like there is a warrant for Mr. Coley, a probation warrant flowing out of the case in front of Judge Edwards. I'm looking at that indictment right now. That involves an incident date of October 2019. So that may be one reason why it's just a real late indictment. So let's deal with what's in front of us. I don't know if the stipulated resolution still applies, but let's start with the defense. So we're here on 18 SC 158735, a case in which Mr. Coley received probation in front of a predecessor of mine for this docket. And there is an allegation that in April of 2021, Mr. Coley violated that probation by being arrested for aggravated assault in DeKalb County. Ms. Wood, is Mr. Coley stipulating to that allegation?
Yes, Judge.
Okay. Tell me a little bit about how long he's been in, what his situation is, and then let me know what, if you think you've arranged something with Mr. Jordan, what that is.
Thank you, Judge. He has been locked up consistently since that date in the warrant. He was in the DeKalb County Jail from April 26, 2021, all the way up until May the 12th, 2022. I believe he went to the Department of Corrections upon release from DeKalb, is that correct?
Mhm.
And then came here directly from the Department of Corrections, Judge. So I do apologize. Mr. Jordan talked about this, but I don't think we put the exact number for the revocation on there.
Mhm.
The understanding was it would be revoked for the time served. And then I'm asking for it to close out. I think he's only got like 2 months left on this case. And so then he'll have to go through whatever happens with Judge Edwards' case. He's 30 years old. He's got 1 3-year-old child. He's got a good address here in Atlanta. He's got his GED. He's a carpenter by trade. He's also working on his CDL. We would just ask that you would accept that stipulation, Judge.
So, Mr. Coley, you were arrested in DeKalb and basically have not gotten out since then.
Yes, sir.
Okay. So your kid was maybe 1.5 and is now twice as old.
My daughter was like 5 months. last time I
Okay.
seen her.
Was even smaller since you've seen her. Got it. Do you know the status of the case in DeKalb?
It's finalized. I took 18 months on that case.
So you pled. That case is closed. I mean, you may be on probation on it, but the DeKalb case is closed out. Okay. I don't know what the bond situation is with the Judge Edwards case. The bond was a sign-on bond in June, a signature bond in June of 2020. So I don't know what's going on, but I don't control that part. That'll be something for lawyers in Judge Edwards's courtroom to work through. Ms. Tucson, how much time remains on Mr. Coley's probation in this 18 SC case?
There's only 2 months and 20 days left remaining on his case.
Okay. Mr. Jordan, do you agree that a revoking time served from April 26, 2021 to present and then suspending the balance is a reasonable disposition?
I do, Your Honor, especially given the information that he has been in continuous custody since this arrest and given the short amount of time that he has left on probation, the state believes that's a fair resolution.
Okay. Mr. Coley, anything you want to add?
No, sir.
So if you get out tomorrow, to say hypothetically you get out, where do you go? Where will home be for you?
Fulton County.
Okay. And is it, who were you going to a house, an apartment?
Yes, a house. My mother owns a house in Fulton County.
Okay. And your mother lives there?
Yes, sir.
Who else lives there?
No one.
Just your mom?
Yes, sir.
She lives all by herself?
Yes, sir.
Okay. And does she know that there's a possibility in the next few days you could be knocking on the door saying, Mom, I'm home?
Yes, sir.
And she'll let you stay?
Yes, sir.
Okay. Where does your daughter live?
In DeKalb County.
Okay. All right. Well, Mr. Coley, I find that you did violate the terms and conditions of your probation when you, sounds like were arrested for and pled guilty to that situation in DeKalb County, for which you were sentenced to 8 years to do 18 months and maybe some probation. That's a violation of your probation in this case. And what I will do is revoke. Well, I guess, Ms. Tucson, for me to say I revoke 18 months, I can't really do that. There are only 2 months and 20 days left. Because I guess his clock was still running. The probation was not told while he was in custody. Is that a fair way of saying it?
Correct. That'd be good. Because it's only 2 months remaining, so it would be suspend the rest of the
Yes,
balance.
so I can't really say revoke 18 months and suspend the balance because there's not 18 to revoke.
That's a good question. I'm going to ask.
Pardon me?
I'm going to ask.
Oh, good. Thank you. So what I plan to do, Ms. Wood and Mr. Jordan, so you know, is to revoke 18 months credit for time served from April 26, 2021. That gets us to a date before today and then suspend the balance. But I don't, if that's going to cause the revocation order to blow up because some system processor is going to say, wait, there's not even 3 months left on the sentence, then I don't want to do it that way. I just want it to reflect that those 18 months that he served, that Mr. Coley served, relate in part to this revocation.
Thank you, Judge.
We'll see if we can do that.
And I'm gonna write this down for you too, okay?
How did you find this? The incident report.
Oh, it's under the jail. Under that.
Thanks.
I was kind of wondering if something was done from that. So.
So this is your next court date with this Kelly's case.
We can revoke the balance.
Okay, and then just reduce it to time served?
Yes, and then, you know, of course, in the section where we put credit for time served from, and
Yep.
then we would put the April 26, 2021.
Oh, well, then we don't need to reduce it to time served. All right, so I will revoke the balance, but Mr. Coley will get credit for time served from April 26, 2021, which is far more than 2 months and 20 days ago. That'll close out this case, Mr. Coley. You'll need to deal with whatever's going on in Judge Edwards's courtroom. I don't know if you've got a bond there or not. You at one point had a signature bond, but Ms. Wood can help you work through that, okay? Mr. Jordan, anything else in Mr. Coley's case?
Nothing further from the state, Your Honor.
All right, thank you, everyone. Ms. Feely, what's the update on Mr. Torre? He was not brought over.
Yes, and that was at our request. I
Yeah.
have spoken yesterday and today with Ms. Patterson, and she is diligently trying to get him a placement. And so I think that process unfortunately is continuing.
Okay, so we should reset this for,
January.
okay.
Thank you.
Anthony Jones, before we bring him out, let me see if I can find that.
I talked to him.
I don't have that warrant either.
I also don't have that one yet, Judge.
Yeah. And Ms. Wood, that's gonna be you again?
Yes, Judge.
And Mr. Jones has a CP case?
Yes. I think this is the only thing that's currently holding him in.
Okay. He can sit between the lawyers. Thank you.
Thank you.
Is Stephanie Elder here? Oop. All right, Ms. Tucson, do you have a warrant for Mr. Jones? Oh, never mind. It's coming, I'm told. Here it is, freshly signed. Let me share that with everyone. All right, let's get on the record, please. This is position 13. It's 18 SC 161453, State versus Anthony Jones. Good morning, Mr. Jones.
Good morning. How you doing?
I'm okay. How are you doing?
I'm doing all right.
Good. Mr. Jones, that case I just mentioned, which is an old case, you got probation on that for an aggravated assault, and there is an allegation, the lawyers can now see on the screen, that you violated your probation in that case by getting arrested for some drug offenses in April of this year. April 19th, you were supposedly arrested for possession of probably cocaine, it says Schedule 2, and possession of marijuana with intent to distribute. That complaint is the CP case we've got, the 208414. So it's not been accused or indicted yet. That's the basis of the revocation. Ms. Wood, I know you hadn't seen this warrant yet, so I'm not sure if you and Mr. Jordan were in a position to talk about a resolution, or if you and Mr. Jones have had a chance to work through anything. But what is Mr. Jones's going in response as to contesting it or stipulating, or gosh, we'd like to get that CP accused and we want to work it all out?
Well, Judge, I haven't had a chance to speak with the state about this, but it appears that the basis of this warrant was actually a decline to prosecute on December the 8th. So very recently.
Oh, the CP has been, if I look up that CP number.
I'm looking at this right, the 22 CP 208414.
Okay.
That was my understanding as well, Your Honor.
You were about to chime in with that.
Yes.
Okay. Tell me, Mr. Jordan, I know what the words mean. I haven't seen one of these before. So Ms. Iqbal signed saying that there was probable cause to arrest Mr. Jones, but your office is deciding not to prosecute. And the explanation is prosecutorial discretion.
That is correct, Your Honor. I believe we recently had a project where we went through several drug-related cases. And if there weren't currently GBI for those cases, then we did decline to prosecute, and that was one of these cases.
Okay, got it. Then what's the defense recommendation?
Judge, it looks like he's been in for 50 days on this violation. So we'll admit to the arrest and then ask to be reinstated if there's time left on this.
Let's find out. Ms. Tucson, how much time remains for Mr. Jones?
Mr. Jones has 10 months and 7 days. It ends October 27, 2023.
Okay. How old are you, Mr. Jones?
23.
23?
Yes.
All right. What's your thought, Mr. Jordan, as to how to handle this?
Your Honor, the state has no objection to defense's proposed stipulation to revoking time served and continuing him on probation. I would like to ask Ms. Tucson if he's had any previous violations, because if he hasn't, the state would not object to probation being suspended upon this violation that's been declined.
Got it. That's a great question. So, Ms. Tucson, is this Mr. Jones's first probation warrant on this case or any? He has a bunch of cases. I'm assuming they're all being tracked in your office if you got probation on all of them.
I am looking in regards to this case. It looks like there's a few prior probation warrants on this case.
Okay. There you go. I'm taking a look too. Yep, in March of this year, Mr. Jones had his probation revoked. There was a probation progress report. I don't see those all that often. We recommended not terminating it in January of this year because of an arrest that had come up. So I think I agree with, I guess, the alternative you had, which is don't suspend the balance given what's been going on with Mr. Jones. Okay.
Correct.
Mr. Jones, anything you want to add?
No, sir.
Okay.
Oh.
Yes, Ms.
I'm
Wood.
sorry, I promised his family I would let them know that I would let you know that they're here. He does have sisters here in support, Judge.
Hey, sisters. Oh, more than sisters. All right. So Anthony Jones, you got family here. That's good. So Mr. Jones, in light of your arrest for the cocaine and marijuana, those charges that the state is no longer going to pursue, I'm going to revoke 2 months of your probation. You'll get credit for all the time you've been in, and then I will reinstate the balance, and you will have a little more than half a year left on probation. Ms. Tucson, I see several other cases for Mr. Jones here, 17 SC cases. Is he on probation for those? And if so, do they have the same end date? Because I don't want to mislead him to say, hey, you'll be done with all your probation if one of those goes for another 10 years.
That is the only one. The 17 SC, it ended in March of this year. So this is the last one he is on probation for.
All right, you're on the home stretch, Mr. Jones. If you can, for the next few months, stay out of harm's way, then you'll be done with this probation. And maybe you'll try something new, okay?
Yes, sir.
All right, anything else, Mr. Jordan?
Nothing from the state, Your Honor.
Ms. Wood?
No, Your Honor.
All right, thank you, everyone.
Clarify the arrest date from when he was, for his credit for time served.
Sure. When did you go into custody, Mr. Jones?
It's November 1st.
November 1st.
November 1st, 2022.
Yes.
All right, thank you.
You're welcome. Thanks for doing that.
Judge, does he need reporting instructions?
Yes, I'm moving too fast here. So do you have a good, what address do you have in the system, Ms. Tucson, so we can see if Mr. Jones, you've got a good address for him and we need to let him know what he needs to do?
Looks like the address we have is Mason Turner Road in Atlanta. He should report here to 276 to the field office within 48 hours of his release.
So I have an updated address that I got from the sisters, and it's actually a Jonesboro address. So I think that would be Clayton County instructions.
Okay, is that where you'll be going, Mr. Jones, to stay with your sister in Jonesboro?
Yes, sir.
Okay, then we'll get that address to you, Ms. Tucson, and then we'll need to
It's still
give.
report to Fulton, and they'll transfer his case.
Oh, okay. So you still need your first reporting when you get out, which will be real soon. You need to go back to the Fulton County Probation Office, the one that's just a couple blocks from here on Memorial. Ms. Wood will give you that address, but then you share with them, hey, I've moved. I've got this new address in Jonesboro, and Fulton Probation will transfer your stuff to Clayton.
Yes, sir.
Does that make sense?
Yes, sir.
Okay. If you don't show, they're just going to send me another warrant. I'm just letting you know now, if you get scooped up on another warrant, I'm just going to let you spend the rest of your probation over at Rice Street. So get this one right, okay?
Yes, sir. Appreciate you a lot.
All right.
Have
You're welcome.
a good Christmas too.
All right, you too. Ms. Wood, are you loading them up with the information?
Yes, Judge.
Great. All right, thank you. All right, so I want to finish this calendar. I know we have one more, but we're gonna have to take a break, one more from this morning.
Thank you.
Vanderpool?
Yes.
You did. So he's in custody. He just wasn't brought over.
He has to work on it.
Okay. But Parrott, Piles, and Anderson should all be here in theory. Okay.
Oh, I probably took them. Is that it? Sorry, keep grabbing the wrong calendar.
So that leaves us with Stephanie Elder on this calendar, position 15. But I called for Ms. Elder several times. That's not going to be your case. Who's got that?
It's not, Your Honor. It's the Crimes Against Children Division, but given that it's a plea and arraignment, I can handle it on their behalf.
Okay. Well, it's going to be an easy lift for you because there is no Ms. Elder here. Ms. Feely, are you the higher numbers, just so I can remember? All right. Tell me what contact, if any, you've had with Ms. Elder, or if this is actually a 2018 incident.
We have not had contact with Ms. Elder, unfortunately, so I don't have legal excuse this time for her absence.
Okay, let me take a quick look at it. So she got bond 2 years ago. She bonded out in November of 2020 and then was indicted in September of this year. Let's see. I will do a bench warrant, but I will also be very open to a walk-in should you establish contact with Ms. Elder. So we'll do a bench warrant. Mr. Jordan, if you'll work with Ms. Nelson on that, and we'll handle that one that way. All right. We had probation revocation for Mr. Parrott and Mr. Piles, and we'll do that. That's going to need to happen in a little bit. And then we have the bond hearing on Mr. Anderson. Are any of you here for any of those things? Anderson and Parrott. Is Parrott one that you all have resolved, or is that a complicated one, Mr. Jordan? Or is it not your case?
It is my case, Your Honor, but I believe after a very short discussion, we could have that worked out.
Okay. And then Anderson is a bond reconsideration, or he doesn't have, Mr. Anderson doesn't have a bond.
I think he's in no bond status, Judge, but I will double check.
He is in no bond. Your motion says he's in no bond. So why don't we let's do these expeditiously because we've got folks here for that.
That's
And
fine.
and we'll let them get out of here. So if you wouldn't mind, Ms. Feely, I don't know who has Mr. Parrott, but Ms. Wood, we need you for both things. You have Mr. Anderson?
I believe that should be 88 Wittenauer. I will confer with him just to be sure, but I do see family violence related offenses on there.
Mr. Whitenauer, are you handling the Anderson bond?
I will.
Great. Well, why don't we do that first? And I'll ask Ms. Feely to talk to you, Mr. Jordan, about Mr. Parrott, just so that it can still be Ms. Wood who argues it when we get there. But if you could just get it ready, that way we can knock out both these things. So if you could bring Mr. Anderson out, please. Then we got a break. And we're going to, 1 o'clock is going to be at 1:30.
The investigator Natalie Bloom, I think she's coming over for.
I can talk with her. There's now this, we may be cleaning some of this stuff up, but 2 scheduling conferences went away. Have her come at 4.
Okay.
All right, Ms. Rivers, are you ready?
Yes.
This is case 22 SC 184-011, State versus Timothy Anderson. Good morning, Mr. Anderson.
Good morning, Mr. McBurney.
Mr. Anderson, Ms. Wood has filed, I think a couple times now, a motion to have argument about you getting a bond. I think you have no bond right now.
Yes, sir.
And I'm going to hear from Ms. Wood why you should get a bond. The prosecutor for your case is appearing virtually, so you'll see him on the screen when it's his turn to go. It's Mr. Whitenauer. I'll hear from him, and then I'll let you know if I'm going to change your bond status at all. You'll leave today knowing what the deal is, okay?
Okay.
All right, Ms. Wood, when you are ready.
Thank you, Judge. Mr. Anderson is 33 years old. He's originally from North Carolina. However, he grew up here in the metro area. He has a lot of family here. Notably, he has 2 family members here in support. He has 2 children, 2 sons, ages 12 and 14. He also has completed his GED. His prior work experience includes a steel factory as well as a bread factory. He also did some work for Iconic Catering Services. He tells me that he's in good standing with all of those places, Judge, so would be able to return to gainful employment upon release on this case. Judge, he does have a hold. So I have advised him that even if he does get a bond, he will have to deal with the hold. But we're just here asking for a reasonable bond to be set. He's been in custody on this case since June 3rd of this year. So he's at 201 days at Rice Street so far, Judge.
Got it. Where is the hold?
With the feds, Judge.
Do you know, Mr. Anderson, what the allegations are with the
Yes, sir.
feds? What are they?
I just did a 10-year sentence, so I'm on supervised releases probation.
Got it.
And Your Honor, I've been doing my probation, my treatments, everything I've been complying with.
What was the charge, or what were the charges for which you were on supervised release?
Trafficking marijuana and possession of a firearm.
That was a federal case?
Yes, it was an operation they did, actually.
Oh, you got swept up in was it here in the Northern District?
Yes, sir.
Okay. All right. What, ATF or
ATF.
HIDA?
ATF.
ATF. Okay. All right. How much supervised release do you still
They
have?
gave me 3 years. My probation officer is Michael Murphy. Like I said, I'm in good standards with him. I'm doing everything I'm supposed to do, sir. I just got out and made the wrong decision on my own.
In connection with these charges?
Yeah,
Got it. So the hold is predicated on this case?
yes.
Got it. Okay. Mr. Whitenauer.
Thank you, Judge. Your Honor, we are asking that you deny the defense motion for bond in this case, as we believe this defendant presents a risk of committing further felonies if he were to be released. Your Honor, the defendant's criminal history includes the following: a 2007 conviction for VGCSA here in Fulton County. That conviction came on one of 3 VGCSA cases at that time. One, he was given PTI, another was dead docketed, and then on the third, he entered a plea of guilty. The same year, there was a failure to appear. And at the time, he was arrested for a false name. He entered a guilty plea to that. In 2010, he was arrested for armed robbery. That was resolved with a plea to a disorderly conduct charge here in Fulton. In 2011, he had a possession of a firearm conviction here in Fulton. And the same year, he also had another VGCSA conviction here in Fulton. He currently has 2 open cases. This one here in Fulton County, Judge, which is a domestic, in which the victim, Ms. Butler, reported that he had punched her in the face, had pushed her head into the window of a car, and then pointed a gun at her, stating, "I will shoot you." Officers were able to observe surveillance video of the defendant punching the victim. He also has a pending case out of Coweta County. That one was from January 26 of 2022. This case stems from an incident in February of 2022, so just 1 month later. But in Coweta County, it's for VGCSA and the firearms possession. Again, that's pending. GCIC does not indicate any disposition. And then, as noted by defense, the defendant does have a hold by the U.S. Marshal's Office in reference to case number 1:11 CR 00313. And so we would note that, of course, at the time of these 2 new offenses here in Fulton and then in Coweta County, he was under sentence for that federal case.
Got it.
Ask that you deny bond.
Okay, thank you. Ms. Wood, do you have any news about the Coweta case?
I do not, Judge. I'm sorry, did I miss, does Mr. Whitenauer have a case number for that?
I didn't hear a case number. He had a date. It was a January 2022 incident, and he mentioned that the GCIC doesn't show a disposition. So I wasn't asking about the facts so much. It sounds like it's drugs and gun, but whether it was open, closed, I mean, it sounds like it's open, especially if Mr. Anderson hasn't been back to Coweta recently.
I can provide the case number that's listed on GCIC. I don't think this is one that's actually going to be the indicted case number, but it's the 12th cycle, and the case number is listed as 2201 000 858.
Thank you.
Mr. Anderson, have you been to Coweta recently to deal with those charges?
No, sir.
Okay.
I had got arrested in Coweta County, and I haven't been back.
Okay, got it. Well, Mr. Anderson, you've got a few irons in the fire. I think if there wasn't the federal hold and an open matter in Coweta, we might get a little traction on things. But in some respects, a bond doesn't make a lot of sense. In particular, because we'd lose you to the feds. I don't know when we get you back. It's harder to pry people out of federal jurisdictions than if, for example, if Coweta were called to say, hey, can we get Mr. Anderson down here to do plea and arraignment or something like that, we'd get you back. With the feds, it's harder to get people back. So it is my inclination to keep you here and have Ms. Wood work with Mr. Whitenauer, who you see on the screen there, to see if there is a resolution to this case, because that'll certainly get you on to the feds. And you'll be able to take care of Coweta business, if that's even going somewhere. I'm not putting a lot of weight on the Coweta thing. It may be real serious and they may be coming after you hard, but they can't be too eager because they haven't put a hold on you as well. That's one sign that we'll know that they're ready to see you. So I'm going to leave things as they are, but I will tell Ms. Wood what I tell her and her colleagues always, but I want you to hear it. And that is that if things slow down because the state is moving slowly, then we need to talk about bond. As long as Mr. Whitenauer is getting all the discovery to your lawyer, Mr. Whitenauer is saying, I'm ready to go, which is what typically happens, then we're able to move the case quickly, which is what you're entitled to. But if we start hearing, well, I can't find the victim, or I don't have this discovery yet, the crime lab is backed up, that's not your problem. And then I need to make sure you can go take care of some of your other business, whether that means going to deal with whatever judge it would be over in the Northern District or getting down to Coweta. But right now, I think we can be front and center and try to get these charges resolved. Okay? Mr. Whitenauer, anything else on Mr. Anderson's case?
Nothing from the state, Judge.
Ms. Wood?
No, Your Honor.
All right. Thank you all. Ms. Wood, is there anything you are missing at this juncture in the case as you think through it that we could get Mr. Whitenauer to be working on?
I do know that I have initial discovery and I've seen a couple of the body cameras, so I will get with Mr. Whitenauer if I'm missing anything else.
It does sound like there's a pretty critical piece of surveillance footage that Mr. Whitenauer described, being able to see part of these allegations happen on film that could help shape a resolution if it shows what Mr. Whitenauer says it shows.
Thank you, Judge.
All right. Thank you. Can we bring Mr. Parrott out now? And Mr. Whitenauer, I don't know if you are on our afternoon calendar, but again, that's not going to be until 1:30, okay?
Thank you, Judge.
You bet. I do have Mr. Parrott's
He's locked up elsewhere.
warrant. That's one that you sent.
Went overboard on this.
Yeah, that's what he told me,
Oh, that's good.
but I don't have that verified yet.
Hey, Lacey, we can hear you at the table.
Thank you.
Hopefully you were saying nice things about people. Big. All right, Ms. Rivers, you ready? This is case 20 SC 174043, State versus Don Travis Parrott. Hello, Mr. Parrott.
Hello, Mr. Barron.
How are you?
I'm doing great.
Good. Mr. Parrott, I have a warrant that I signed in January of this year that alleges that you violated your probation in this case. You were sentenced for an aggravated assault conviction to some probation. And the allegation is that you missed a meeting. You were contacted by your probation officer who told you to show up for a meeting about a year ago, 27th of December of last year at 9 a.m. Didn't show up. Says you still owe restitution, haven't paid any probation fees, and you have not obtained your GED yet. So these are all what we call technical violations. They're not good things, but they're not as serious as some of what we see. You haven't gotten arrested for something else. That's good. But they're things that you were obligated to do, like show up for your meetings, get your GED, pay some restitution, and that has not been happening. So we're going to need to work through why that is. I'm calling up your final disposition right now so I can see, boy, lots of counts. And you got 5 years to do 6 months. and the rest is on probation. And then you had 5 years suspended after that. So you had about 4.5 years of probation, had to pay some restitution to 2 people, get your GED, et cetera. So Ms. Wood, is Mr. Parrott admitting to these allegations, or is he challenging them?
Admitting, Judge.
All right. And what are you recommending happen?
Judge, he's been in 57 days on this case. So we would ask for a vote for 2 months and then reinstate.
Okay. Ms. Tucson, how much time remains for Mr. Parrott?
He has 2 years and 9 days remaining on this case.
Got it. Thank you. Mr. Jordan, what is the state's recommendation?
Your Honor, that the state has no objection to revoking the 57 days, just stressing the importance for Mr. Parrott to report to probation and comply, and also get on paying restitution and his GED as well.
Sure. What I appreciate that. What's the update on the GED? We'll talk about finances in a minute. Life is complicated, but what's going on with GED? And if not working towards that, why not working? And if working, why not restitution?
Judge, thank you. So he is it 1 credit or 1 class? Yeah, he's real close to being done with that GED. So
Great.
I do have confidence that he can complete that. And he has family here in court. I spoke with his mom. She's helping him out with the restitution aspect of this. And he also tells me that he can return to his job. He was working with FedEx and UPS prior to getting arrested. I'm wondering if it's possible to get him on a mental health caseload with probation. In speaking with him and his mother, I think that's been part of the situation, is just having trouble making sure he's on his medication and staying.
Sure. That's a great request. So Mr. Parrott, are you supposed to take medication?
Yes, sir.
For what?
Bipolar and schizophrenia.
Okay. And have you been doing that, or sometimes not?
Yes, sir.
Yes, you have?
Yes, sir.
Okay. Does your mom help make sure that you have your prescriptions around?
Yes, sir.
Do you take that medicine once a day or twice?
Once a day.
Morning or night?
Afternoon.
Afternoons?
Yes, sir.
Have you been getting it at the jail?
Yes, sir.
Okay. And do you take it at afternoons at the jail?
Yes, sir.
When you take that medication, does it make you sleepy or woozy, or does it help you stay focused?
It helped me stay focused.
Okay. Do you feel like you're understanding what's happening right now?
Yes, sir.
Do you have any questions about what we've been talking about?
No, sir.
Okay. Well, Mr. Parrott, I'm going to revoke 2 months of your probation, which you've pretty much done. I'm going to reinstate the balance of your probation. I'm going to ask that probation assign you to a mental health treatment officer. It's someone who will just be more comfortable with what you're working on and will help you remember to make sure you're going to the doctor, that you're taking your medication, et cetera. I'm going to waive your probation supervision fees for the next 3 months, so you don't need to worry about that. I am going to require that you finish your GED in the next 6 months. Maybe you finish it real soon because you only have 1 credit or class left, but your original sentence was just get it at some point. I'm saying you got to finish it by June of next year, get that GED. And then hopefully you can get back to either FedEx or UPS. That'll make it easier to pay restitution. If you're earning some money between you and your mom, you ought to be able to take care of things, okay?
Yes, sir.
Any questions about anything?
No, sir.
Mom, anything I ought to add to this, or you feel like we can make this work?
I feel like we can make it work. I just want to help or to be.
Part of it, that makes a ton of sense. And I'm sorry, we didn't know to make that happen before. Okay, well, now we do, and we can treat it, and that ought to make a big difference. So let's just stay on the treatment.
Thank you so much.
You bet. Will Mr. Parrott be staying with you? Is that his address, or he has his own spot?
So we live with his grandma, but I help out taking them to, making sure you go to all the doctor's appointments and stuff like that.
Great. Well, thank you for doing that. So Mr. Parrott, what's the address where you, I just want to make sure probation has the right address for you.
372 Chapel Road, Atlanta, Georgia, 30318.
Ms. Tucson, is that the address that is in your system for Mr. Parrott?
I'm checking right now. 372?
Chapel Road?
Yes.
Yep.
Okay, yes, that's what we have. So he'll report here to 276, 48 hours after release.
Yep. Okay. So Mr. Parrott, you'll need to show up at the probation office within 2 days after you get out. You're going to get out in the next couple days. When you get released, you've got 2 days. You can go home and see mom and grandma, but within 2 days, you got to go to the probation office to say, here I am, it's Mr. Parrott, so they can get you signed back in and get you plugged in with a mental health treatment officer who will be, like I said, much more aligned with what you're working on. Okay.
Yes, sir.
All right. Any questions?
No, sir.
Mr. Jordan, anything else in Mr. Parrott's case?
Nothing further from the state, Your Honor.
Ms. Wood?
No, Your Honor, thank you.
Excellent. Then I will sign that paperwork and we'll go from there.
Thank you, Judge.
Yep. You're welcome. So we'll do Mr. Piles when we get back. And then we've got our afternoon calendar, which will include Mr. Lewis from this morning's calendar.
Judge, do we have a hard stop this afternoon?
We do not. We have, I have 2 civil scheduling calls where I have to be gone for like 10 minutes. So I think one's at 3 and one's at 4:30. So we should cover everything we need to cover. I mean, hard stop is your dinner time. Ms. Rivers saying I quit. That would be the hard stop. But no, this was built to be an elastic afternoon because I know we had to say no thank you to some of the folks you wanted to bring over. I'm gonna be in Cobb County tomorrow and Thursday for this JQC thing. So today is the day to cram stuff in.
There's one of the people that I thought we were saying no to is actually back there, and so I was hoping we could squeeze in the calendar.
Let's do it.
Thank you.
Yep. All right, 1:30.
Thank you.
Everybody's on their mind, lunch, bro.
Yes.
What about everybody, y'all? Coley. No.
Yes, I
Harriet.
Harris. Anderson.
Tim's on that, right? Tim's on that.
I don't know if he will penetrate.
Oh, these are walking.
Your name Morgan.
Private attorney.
Up, on that.
Private attorney.
Why? Robinson?
Robinson. Yeah, she is. Robinson. I guess he gone because he ain't has. I told him.
And who's gone?
Oh, yeah.
Yes, you gone.
Thank you. Yeah.
You were like,
Which one she going?
Jonathan.
Oh, yeah. I mean, because. Well, I know, but I'm very confused as to why.
So this one time it's been raining as well?
Yeah. I don't think there's a lot in it, though. Yeah, who do you have left?
Talk to where else, maybe.
I'm trying to think. We're looking at that.
I know, right? Just about enough.
He's not.
Okay,
Well,
that's private attorney, and then we have a private attorney. I did talk to him. Yeah, so. Yeah.
Oh, excuse me. Sorry. Can you come this way for a sec?
okay.
Thanks.
We're good to go on Mr. Cockrell.
Yes, I think you said it's cool to do the misdemeanors on this. Okay. I'm emailing you right now. Mr. Swindle.
Mr. Swindle, okay.
So he wanted me to just ask you if you had an offer on that case. I know he's got 2 cases and it's a lot of discovery,
Yeah,
but
it is.
I told him I would just ask, but it's completely fine if we just have to do a waiver of arraignment on him.
I was thinking something like 8 serve 2 on that.
Okay.
It sounds like they were pretty much caught red-handed on burglary, so.
Oh, he has a code for that?
Mr. Elder.
Oh.
Yeah, so 8 to serve 2 on that would be
Okay.
fine globally for both cases. I don't think that they didn't get away with the items that they were trying to take, so I don't
Okay.
think any restitution or anything.
Do you have position 15, Brian Newcomb?
I believe, yes, that's mine.
So we were trying to figure out why he's in this courtroom.
Yeah, I'm not sure either. It says forensic report, but then the only order that I see is that he was found not competent, so not sure why it got transferred up.
Yeah, and because I just talked to him, he seemed fine.
He was fine, okay,
So yeah, I'm gonna try to figure this one out.
okay.
Because he's been in since June. Okay, that's fine.
Especially if you're taking.
I just don't know.
And yes, Mr. Jackson, that's absolutely fine.
Okay, perfect. Let's see.
Hey, how you doing?
Good.
Hi.
Andrew Hall.
Oh, nice to meet you.
Here's him.
Julie and Jordan, I'm taking over for Pierce.
Oh, Mr. Jordan, okay.
His last day was Friday. And
Well,
which,
get out of here, is that right?
yes, his last day is Friday.
Where did he go?
He is going to a 501 nonprofit, but he'll still be in the building. So, but it's just not.
Been out the DA's office anymore. That's why I didn't return my phone call. I'm trying to figure out what happened to him. So
Which case are you here
I'm here on Forrest Valentine's racial notification matter.
It's Valentine, okay. And he's the one that has the charge out of Lee County in Alabama.
Yep.
What's going on with that?
We don't know anything, but he's never been arrested on it.
I reached out, didn't get any information on it, so I think this is his first revocation in a while, because this is an older case. It's what I see.
I mean, it expires in 3 weeks. We're just trying to get him home for Christmas.
Home for Christmas, let's see. So, yeah, I mean, I'm fine with, he's currently in right now?
Oh, yeah. I said actually it's November the 9th. So
Gotcha,
I've been
okay.
Trying until I get him out.
Given the spotty information that I have, me just being in the courtroom and reaching out to Lee County in Alabama, I'm fine with revoking it for the time that it's served, just continuing the probation.
No, it expires in 3 weeks.
Oh, it expires.
Yeah, we're not gonna stipulate. So I mean, I'd rather just terminate. You guys already got the time out of them. You guys got DA time out of them.
Yeah, that's true. That's true.
It expires on January the 7th.
Given that I'm fine with that, given that it's so close to termination.
Yeah.
It doesn't make sense to hold them or continue him on probation if it's just gonna expire. So I'm fine with that.
And he still got to go deal with Alabama. We don't know anything about it. This is not a situation where he was arrested, bonded out, and then got, you know what I'm saying?
Gotcha.
So it's weird. And I reached out to them as well and I haven't gotten any response. Not that they're going to respond to the defense lawyer, but
Gotcha.
you've tried and you think they'd respond to you. I've tried and maybe they respond, maybe they don't respond. I did confirm with the jail, they never have.
So from my understanding, though, in order to basically suspend the balance of it, wouldn't we need to revoke him based on just the time that he served?
No, I mean, that's one way you can do it that way. The other way you can do it is just withdraw the petition and I suggest to terminate, or you can withdraw the petition and you can continue. I'd rather not continue because it's only 3 weeks left.
Gotcha.
And judges, it's gonna take some kind of judge action on it, and so my 2 cents would be just withdraw the petition and we'll ask whether jointly or individual, or I can ask him to go impose it.
Sure.
Just terminate and let's go, you can do it with Lee County.
So he's never been arrested on that.
Yeah, right. Yeah, that's the thing. That's why it's so
can't even
weird.
stipulate to the arrest.
Yeah. We can't even say it's been an arrest, right? So, I mean, we can't, it's just, It's nuts. And it's from 2021, so I mean, it's the whole thing.
Yeah.
It's
Like you
weird.
said, I heard those out of state charges, so they usually very hard.
I don't need all that.
I appreciate it.
I use whatever color I get.
Thank you. Good to meet you in person. Yeah. I just stand by. Okay. You guys are coming back at 1:30?
Yeah.
Okay.
Yeah, we got kind of a late start, so we just kind of.
Sure.
We have a lot of clock calendars.
Before. Right, I'll stand by. But I'm here. I've got it. Thank you again. Good to meet you.
Nice to meet you as well.
That's gonna be crazy when he still on my hand already ain't steady.
Oh, you know. Wow.
Yeah, because you gotta see. So over the light, not over the light.
I'm so confused
Oh,
about this brand new.
Yeah, cause it's
Okay,
not
so
gonna
it's
move.
showing.
If you look through the,
Like, I don't
through the,
know, it's showing that he only
what you
has
call
a misdemeanor left.
it's not gonna hit the surface, the dot not gonna hit.
And
Hey, Sheriff. Can I go back and see him for Valentine?
I ain't gonna lie to you, I'm gonna break, I'm gonna get something to eat. If you can wait for like 20, 30 minutes, I'll be right back.
Not only can I'm going to have it. No worries at all. You've been working all morning and you gotta get the food. I got it.
Thank you. Thank you.
We got some time. So we are not gonna rejoin at 1:30 anyways. I got some bucks. Yeah, I'm good. Okay.
I'll be back.
No, appreciate you. Thank you.
I don't, and I just emailed Miss Nelson because I'm also just so confused about this.
Sheriff, I'll probably be right here, but if not here, I'll be right up the hallway and I'll stick my head back in about 30 minutes. Okay, cool. Thank you.
You seem fine. So yeah, I don't know, she hasn't emailed me back yet,
Okay.
but sometimes she can like reach out to her contacts and get an idea of what the deal is. But yeah.
I am more than willing to close that case.
Yeah, I just like, it seems like it's something we could resolve.
Yeah.
And I was very eager wanting to get it over with, so.
Sure. What I would do is I run back to, I think that's one where I call the victim, no longer have a working phone number for them.
Okay.
But maybe if we can just say that the state reserves the right to bring a motion for restitution in
Yes.
the next 60 days.
That's usually what we're agreeable to.
Excellent.
So yeah.
Okay.
But yeah, that's, I think he seems fun.
Yeah.
And he's very eager to try to resolve.
Absolutely.
So,
So, and how long has he been in?
since the summertime, I think it was June. Yes, June 28th,
Okay.
this year.
Something like 3 years to serve, 6 months or something like that. And then, just do the motion whenever we can, for restitution.
Yeah, that should be fine. And I'll talk to him again, but like I said, he seems fine.
That sounds great. Do you have Mr. Flint?
Let me see.
His position, margin position.
Oh, so that's a conflict.
Okay.
Yeah, I'm not sure. I think she's still with their
I
office, but I'm
did,
not positive.
yes, I did see her name as a alternative public defender. I guess that's the non-conflicts.
Oh, I guess because we have, this was, I didn't realize I was the co-defendant, and that'll be Miss Feely's.
Gotcha, okay.
But yes, okay, so that'll be, will be a plea. I need to go talk to Swindle. Dawson, has anyone, a private attorney reached out to you by now?
No, he's reached out, and nothing that appears forward to me.
Okay, so I'll just give you the background on this. This is literally like his third or fourth inquiry calendar. He had an attorney, like a private attorney on this case. They withdrew, so the judge would want me to talk to him. I talked to him. He was very adamant that he wanted that attorney.
Yeah.
So on that court date, the judge was like, okay, go figure it out, see if you can, get it together.
Yeah.
Well, then the next time he showed up, like the next, at least one time since then, he didn't have it together. I think he's like right on the cusp. He would qualify, but he's just been very adamant about wanting that one particular attorney.
And how does the judge normally do those? Does he just give them as long as possible to hire?
So I think this might be his last one.
Okay.
Yeah, so this would be the third time.
Gotcha. Okay.
So, and I'm happy to tell the judge that, but he's good about coming to work, so I do expect him to be here.
Okay.
It's just a matter of if he shows up with an attorney.
Gotcha. Okay.
But yes, and let's see, 9 and 10 have private attorneys, 11 have a private attorney. Did you see the email about Ms. Tidwell?
I did.
Okay.
And I spoke to the attorney that has the one entry of appearance.
Okay, Mr. Merrill?
Yes.
Okay.
Mr. Hirsch, I'm sorry, he's in
Oh.
position 14.
Hirsch, okay. Is that a conflict or is that private?
He's private. He said that he only represented her when it was a misdemeanor. And then he said that she was deemed not competent. He sent me but it was from last year, so I don't know if judge would want a new evaluation or not, but she was.
So there was an updated one.
Okay.
Let me see if I asked Ms. Nelson about this too. It was like earlier this year. But that's Pearson's email to me. I want to say it was like either late spring or early summer, but she was just sent to Georgia Regional on December the 6th.
Gotcha, okay.
So yes, I was just gonna ask the judge, I can't remember what we do if he goes in judicial hold.
I think so.
Yeah.
Normally that's what Judge Eaton would do.
Okay, so then, yeah, so that'll take that off, and then Newcomb I'll talk to, and yeah, that should be it, and then Leonard Jackson.
Excellent.
Yay!
Awesome.
Thank you.
Get some things closed out.
Yes, absolutely, welcome aboard.
Thank you so much.
Officially.
Yes. Gonna run back to the office, but I'll let you know if I get in contact with the victim for Newcomb.
Okay.
I don't think that I will, but
Okay.
I'll definitely let you know.
Okay, sounds good. Enjoy your lunch. See you a little bit.
Yes. Oh, Yes, so I can. Yeah. Yes, so she's. So for felony. For felony. Okay, that's. So there's no numbers. Yeah, it was. So you're absolutely. That was. That's my. Yeah, absolutely. I will. Awesome. Thank you so much. Bye-bye.
Busy morning, huh?
Yeah, absolutely. Trying to get some stuff wrapped up.
Yeah.
Yeah. Hello. I'm good, how are you? Good. Yeah, of course. Yes, she was actually on the morning calendar for a different case and she's gonna pop back on. Oh, actually, she's coming in person. Okay, yeah. So yeah, awesome. And she's great. And also, did you say she's already here?
She said she's gonna be here on 1:30.
Yeah, because the judge had to do something, so we're gonna start a little bit later.
He said on start.
Yeah, so 1:30. So yes, but so you're pretty here for the so hopefully. Yeah, so the morning calendar got a little bit late, but this one shouldn't take long.
Is there food in there?
There's, if you go down to the second floor and then you cross over, there's like like a walkway thing, there's like a cafeteria, or not cafeteria, but they have a vendor, and there's also vending machines, there's a vending machine on the first floor. And there's various ones like in the elevator. So short answer is it's not easy, the second floor might be your best bet. Okay, I'm good, thank you. How annoyed will you be if I pop back there? How annoyed will you be with?
Well, I'm gonna go back. Yeah, go ahead.
Okay.
Let me just start somewhere real fast.
That's fine, thank you.
Y'all ready? Yeah.
You want us at the same time?
Yeah, you can.
Okay.
Well, you got, you pull your paperwork out from the end, it's over there.
Oh, okay.
Yeah.
There you go. Okay.
Yeah. Thanks. Oh, fourth down.
And we'll have, put over.
Swindle. Thank you so much.
Thank you.
Try to knock some stuff out quickly, don't worry.
But I agree with
So you're fine. Right, come on.
make sure your phone's on, make sure your phone's on silent, make sure your phone's on silent. Hey, ladies, can you sit back on the back row? The front row will be for attorney. Thank you.
Oh, sure, happy to do so. Sure.
No. Your turn? No.
Hey, did you see my email about? You're fine.
I'm saying, y'all come in, make sure your phone's on silent. Make sure your phone's on silent.
Do you have somebody?
No, sir. 1:30.
I have 1 o'clock.
We're gonna start at 1:30.
6 years to serve. It's like 6 years to serve. 6 months. And, just truthful testimony.
Okay.
Sure, yeah.
Oh, yeah, I'll let you know.
Okay.
Thank you. I'll have this on
No, I think that's a human trafficking case. It's not, what's the difference?
It is a big
Okay. See, which one is it?
Yeah, this one. Yeah, I record twice now.
I forget the unit that's on there, but I know it's a special
Yeah,
unit
me too.
because it's by.
That,
I'm not sure who it is. I can definitely check them out for you.
Okay.
And I know you probably had to serve with Discovery.
No, but they serve the public defenders that they don't have.
Who served it? Do you know who served the public defender? Or who supposedly served it?
So.
That might give me, you know, which unit it is.
But the truth is.
I can't remember. I've been trying to get some. I was like,
This is my first week in this courtroom. I was a judge. Yeah, he's. This is something more fast paced.
yes.
Do you have your little this?
I think I know. I have to reach out to the Okay.
La Portia Lamazon?
Thank you.
Well, if it was a Portia, because she's traveling, I don't know if she was with case intake when she did that. But I
It
think
was in, happens twice. Oh, the 26th day of August. So I've been calling the number and I haven't been back.
August of this year,
Mhm.
because she's on trial with me, so
Courtroom she in?
she
Was
is.
she in the courtroom?
No, she's in.
I'm saying at that time.
I don't think so. I think she's always been in the same courtroom. I think she's in Cox. I'm not sure though. But yeah, let me look into that. I don't know what's going on with my VPN right now. Otherwise, I would look into the case. But as far as like the plea hearing today, I can make sure that we get you served with that
Really
discovery.
need to, I need to talk to, we should have, we don't need to take this foolishness up to them. I think I'll have an offer, but this is straight.
I got you. I'm all about the case. Sorry about that. Yeah, he's already. Right, it said the pleas are on the calendars, it's like August, October, November. But it says he hasn't retained counsel for some reason.
Oh, so you never been.
Until I'm prepared.
I just wanted to make sure that was needed. Did you look like taking care of? Okay. You want to turn it all Which one? Mama is having a Sure. So, I think actually I said let me give you more colors. Perfect. Thought I recognized you. You're good. You know how much longer? This morning, the judge said 1:30, but it's obviously well after that now. Should be soon. No. Supposed to be hot. Sorry. The question is James. Need information about it. I know, wow, okay, well, that's me. You can transfer that. It was not discouraged. Do you have a recommendation for this person? Yes. Because he told me, they seem to know that he was so that's what I was thinking. Okay, cool. Thank you. Yes, so when you tell the judge, we always want to know. I feel like we got rid of. And then we had to turn here earlier. So when you said that, I was like, just a point. Thanks. Because we can get this done. Are you scared of one? Yeah. To ask the state, 2 cases would have run was not discharged. And so the veterans court, I'm not.
Yes. I talked to Brenda about it, and she said that that's what we were to do, we were sign on one, and that was gonna be correct. Okay, ever talk to the
Have you told Julie?
Is he?
So I think he'll be on that one. I don't have that calendar. Do you still have the morning calendar?
Yes, I do. Well,
Yeah, Lily's on Lily. Yes, it's the first, Lily, I think he would be yours. Oh, just kidding, it says my hour.
that's right.
So who, do you have him?
I got into my VPN.
Oh, okay, who let me get?
Who has it?
Where is that? Jim's calendar.
Oh, here it is.
Didn't know what we still on do the agent.
Do you have to detail that?
No. Right, you're trying to figure it out.
Oh, okay, sorry. You don't know. I'm bombarding you. Well, I usually spell it.
Yes.
W-E-I-T. If I could just add it. And then M-A-G-Y-T. V-R. Oh, yeah, that's my fault. And U-P-R. Yes.
Was he here tonight?
He was on Zoom.
Why does his emails go to Linda, not Nelson?
So it says it's just try line for some reason on Addison. I'm gonna look into it.
Okay. That's all I need. This order. The essay, this is stupid.
I wish I knew enough about it to be able to.
Yes, hold on. I'm coming. And they can put a hotel room? That's what I wanted. That's a lot of money. That's why. Yeah. No, oh, absolutely. Okay. Because of the court program. No, so this one. No, I'm saying because we was in that time too. Yeah, and he didn't do it by that. Yes, yeah, but yeah, he oversaw a few of my pursuits. Yeah, I believe it. I'm sure you don't even call it. Yeah, you go to court every. He said, that's probably what I'm about. Just need to decide. Well, we gotta get it, guys. Yeah, but the school that we do it, so. He said he got a lot out here. No, I'm saying he had. Yeah, but he's not objective. He's right there. The problem is you don't know. I'm just gonna go on the. All right, well, I'm just tired of, work on trying to. I'm just.
So it looks like it's my case, so I just engineered. Discovery, you want to try to get another calendar, like first week of January?
Yeah, it's stupid, look. I'm saying some stuff is something.
Okay, cool.
But I need to do this. I just want to understand this stuff.
It says in the report that it's necessary. So.
Okay, I'm gonna give you a chance to review it because that's not fair.
Yeah, I appreciate it.
And then we can have another conversation.
Okay.
But this is what I do. How are you? Are you serious?
Yeah. That's why I was surprised this comes from, but like you said, the board is.
Did you accept the bus?
I haven't looked at it for
Can't even.
Okay. I got you.
No.
Okay. I'll make sure it is. Yeah, you can call them.
Okay.
And I'm sending out my contact information.
Okay.
We should be able to do that. Yes.
I got the X on it.
You got the X on it?
Yeah.
Okay, cool.
That's probably what it is.
Really? He's going, okay. I'm not saying. So what's that? Nothing happened on me. Nothing on me, huh? I mean, not on, okay, fine.
Yeah. That's what I'm gonna do. What did they tell me? What's my boy? Glad to see you.
Happy holidays. You taking any time off? 24 hours?
Yes.
All right, enjoy it. All right, sorry for the delay. We are back in session with what remains of our many calendars, and I'm trying to get to the right ones. So we still have Mr. Piles to do from this morning, and we'll get to that. Is that going to be a Wood or Feely production? Okay, I promise we'll do that, but I'd like to call the supplemental calendar since folks have been waiting for a little bit and see where we get with that. So position 1 is Travis Flint. Are you Mr. Flint? Hey, good morning, Mr. Flint. This looks like a C3 attorney, Ms. Hemingway. Is Ms. Hemingway?
Either conflict or C3.
Right, it's in that category somewhere. It's a new GPDC name, but I'm not seeing anyone. Mr. Flint, have you met with your lawyer before? You don't have one. Well, so you have 2 cases here. Look at that. The okay. Let me look at what the docket tells us. We've got a co-defendant. Is Martin Deese here? Is Samantha Findling from your office?
She is, Judge.
Okay, so this will be one of your cases.
Yes.
It's a 6, so it's Miss Feely's case.
Yes, Judge.
Look at that. All right. Have you met Mr. Deese?
I have not.
All right, but we're focusing on Mr. Flint, who is standing right there. And let me look at one thing here, Mr. Flint. Why? Oh, because Mr. Deese is a repeat offender, which is why this got sent here. Okay. Pardon me? Okay. He is indicted with you. If I look at the charges here against you, you and Mr. Deese are charged with possessing marijuana with intent to distribute and obstruction because you walked away from an officer when you were told to stop. Sorry, I don't want you to tell me about it. You may be exactly right. I'm not trying to get you to talk about the case. I'm just telling you what the allegations are. You may have been in Texas when this happened. You may have nothing to do with it, okay? It is alleged that you and Mr. Deese had some marijuana. This is old. This is from January 2020. And this is the new indictment, not the 2020 indictment. Mr. Jordan, good luck with these. And these came from non-complex because they only recently determined that Mr. Deese, the non-co-defendant, is a repeat offender. I'm just trying to figure out where your lawyer is. Let's see. There was a motion to withdraw. That was Mr. Dark. Mr. Dark used to be with a conflict defender, I think.
Yes.
And he tried to withdraw from representing Mr. Flint. Do you remember meeting Mr. Dark? You think? Right. Yes, that's a fair statement. Oh, here's an entry of appearance. This is what I was looking for. Yes, Ms. Hemingway is your lawyer. She has filed an entry of appearance. It doesn't sound like you've met her before. Are you planning on hiring a lawyer, or do you need an appointed lawyer to help take care of your business? Okay, well, that's why Ms. Hemingway is in the mix. So I'm going to have Ms. Nelson, who just walked in, reach out to Ms. Hemingway to see if we can get a report from her. I'm going to ask you to take a seat back down. We will work through your situation today, I promise. All right. Mr. Deese has a warrant for him and he's not here, but we also know that the case for which he's been indicted actually happened way back in 2020.
Yes, Your Honor, and I think my office does have a file for him, so once I am physically in my office, I will hopefully be able to get some contact information, and if I am able to get a hold of him, given the nature of the case and the age, we would ask if he could maybe walk in.
Yes, so Mr. Jordan, we're going to do a bench warrant for Mr. Deese, and we'll move that forward, but if Mr. Deese can get here with Ms. Feely, I'll probably deal with that bench warrant in a way that works out for him.
Yes, Your Honor.
All right. So you're going to reach out to Ms. Hemingway? Thank you. Andrew Cockrell in custody.
My judge.
Okay,
This will be a negotiated misdemeanor today.
excellent. You're handling it, Mr. Jordan?
Yes, Your Honor.
All right, we'll get him out in a little bit. Bernard Swindle.
He's also my judge. I just need about 2 minutes and I think we'll have a plea on this one as well.
Okay, 2 minutes to chat with him or Mr. Jordan?
I've already talked to Mr. George, just Mr. Swindle.
Okay, looks like one that ought to be able to work out. He's got 2 cases. All right, and both would work out. Great. Moving right along, Colby Elder. This is a co-defendant of Mr. Swindle in one case.
He's excused, Judge. His attorney filed a waiver arraignment.
Great. All right, so Mr. Jordan, you will get, I don't know if Brandon Rosenblum is his lawyer, that's who's listed here, but you'll work to get discovery to Mr. Elder's lawyer?
Your Honor, I did try to serve discovery on Mr. Rosenblum. There was another attorney that was also listed on the e-file. For whatever reason, on Attorney Rosenblum, it bounced back, but I believe that the other attorney is with his firm, so I'll call them to make sure that they got the discovery.
Got it. Whoa, this says Judge Cox.
It's supposed to come into question.
Oh. Why? You mean you?
Because we have the other case.
Oh, because we've got the older Swindle
Yes, she just
case.
transferred one defendant, not both.
Of course. I've got Mr. Jordan. Just yesterday, Mr. Rosenblum filed the entry. So hopefully if you send something to that strange email, pleadings at whatever I can't read it all, the handwritten one, but try that. There's a phone number. Hopefully you can connect with him and we'll make it happen.
Yes.
Great. Thank you. Quachez Dawson. How you doing, sir? Well, I can answer that after you tell me whether you have hired an attorney or if you need appointed counsel. Where?
It's Brian off the page on my case.
Really?
Yes.
I'm looking. Just give me a sec. Were they going to be dialing in? Well, they either would be in court or they'd be on the call. So you're saying, I already entered an order in July that let Mr. Arca get off the case and Mr. Howard. You're saying now they're back on?
That's correct.
As of when?
And 13.
Recently, like 13th of December. Okay, so Ms. Nelson's going to call their office and you're saying that they'll be able to look it up and say, oh yeah, Mr. Dawson, he's in good standing again. We represent him.
Correct.
Okay, take a seat. Thank you. I just sent you the info. This is which Mr. Dawson and I, position 8, we're talking. He says he's back with the people he broke up with. So I just sent you their contact info, at least a phone number. All right, let's move on. I can't tell the name of the person on position 9. And it lists Jennifer Ventry as a defense attorney. She is a law clerk for a Supreme Court justice. So I'm guessing that's not who is, but it's an 08 case. So that sort of makes sense. Let me pull it up here. It really is Morga. Ms. Marco Morga. Marco Morga, are you here? Oh, he's in custody. Oh, all right. Any sense, it's a 9. Ms. Feely, if this is position 9.
So the new case, Judge, the 22 CP case lists the conflict office on the first appearance court action, but there is not an entry. So I'm trying to figure out.
He may only have a theft by receiving stolen property auto, but I guess this new case could be holding him as well. So we'll see. Okay. Let's come back to that. All right. Brian Marshall. Hey, how are you?
I don't believe my client has been arraigned because he didn't have representation at the previous hearings, so we will.
That's why you're here.
Right, I'm here.
Excellent. Is that your kid or his kid?
Mine.
What's your daughter's name?
Hendricks.
Hendricks? All right. Well, welcome to Hendricks. So Mr. Marshall's retained you. Are you waiving arraignment for Mr. Marshall?
Yes, Your Honor, we'd like to ensure not guilty. I received discovery during the break. I came, we were able to do some pre-negotiations. I would like to be placed on the next soonest available calendar, as long as that's okay with the state, because I do think, and I do anticipate we're going to resolve this fairly quickly.
Okay. So Mr. Jordan, is this your case or is it through a specialized? I'm just looking at the first couple counts. They don't seem to be in your wheelhouse.
I thought so as well, Your Honor, but from previous discovery that's been filed, it's all been for my unit.
Okay.
This is my case, and I did serve discovery to Attorney Bumpus, and we will work on getting a negotiated plea very quickly.
Can you fill out, if I get to you, Ms. Bumpus, a waiver of arraignment form? Because then we'll get that e-filed and that'll trigger the production of a scheduling order which will lock in dates for motions, et cetera. Not that you'll need to go through all that. If you and Mr. Marshall reach an agreement with the state, then you just need to let Ms. Nelson know this has been resolved. When can we get in here? And she will get you on the next available. We won't automatically put you there until you reach out to say, actually, done deal, or it's non-negotiated, but we're close enough. We want to try to work it out. Then we'll get you on a plea calendar. We can do that at any point. Even if we're in the middle of trial, we can do it at lunch or just before trial starts. But the scheduling order will lock in a motions deadline and a final plea date, et cetera. That may not need to apply to this case. Okay. I don't know. Our forms went away because the jury was here. Oh, you just emailed one? Okay. All right. Would you want to do it electronically or do you want to fill one out? What do you prefer? Let's fill it out while she's here. So if you could get a waiver of arraignment to Ms. Bumpus. All right, so you can take a seat, Mr. Marshall. Ms. Bumpus, if you would fill that out, I'm going to see what we're doing with the next position. And then because you're here, we'll circle back to Mr. Lewis so we can sort that one out. All right, next up is Alexander Ballantyne. I think I see Mr. Hall here. And we'll bring your client out in just a moment. Is this something that you and Mr. Jordan have sorted out? Is this a contested revocation or how do you envision it playing out?
Here's my understanding from my conversation with Mr. Jordan. First, good afternoon, Your Honor.
Good afternoon. Same.
Spoke with Mr. Jordan. My understanding is the state's going to withdraw the petition so that Mr. Valentine can be released from Fulton County custody. His probation is due to expire on January the 7th of 2023. So I'm going to be asking the court to go ahead and terminate his probation. My understanding, Mr. Jordan, is the state doesn't oppose that. And then the only thing that's holding him in the Fulton County jail is, am I giving too much information? Should I stop? Okay. Is this heretofore unheard of Alabama detainer charge that they've kept him there for 42 days. And so I'm going to ask Your Honor, to please consider giving him a bond so that he can get out of Fulton County jail. And we're happy to self-surrender over this. No problem. It's just, this has come out of the blue. We have no idea what happened. And he can see it out for 42 days.
Okay. We'll probably have to talk the most with your client out here about how I can grant a bond on an Alabama detainer. I'm not opposed to the notion. If they've got a hold on him, though, I can't necessarily make the hold go away, but we can work through that. And you can get on the record why you're dismissing the probation warrant.
Your Honor, from my
No, I don't mean right now, when we get Mr. Ballantyne out here.
Yes.
Okay, I think we can manage all that. Do you know what the charges are in Alabama?
Only from the petition, which Ms. Nelson kindly gave me a copy of. And my understanding is it's breaking what I would refer to as entering out.
Okay.
That's not the name of the charge.
Sure, but it's the equivalent.
It's the equivalent of that, right? And he's never been, this is not a situation, in Your Honor, so I say it's a little odd, where he's been arrested and bonded out and then probation warrant pops.
Yeah.
That's never happened. And I actually took the affirmative step to reach out to Lee County to confirm they've never had him in custody. I received back information. I shared with the DA's office. They've never had him in custody.
Okay.
He told me that, but I wanted to corroborate that.
Yeah. All right. We'll bring him out in just a second. I want to make sure we got Ms. Bumpus squared away, and then we'll get Mr. That helps me understand what we're doing with Mr. Ballantyne. Thank you.
Yes.
Yes, please. Can we, Deputy Gordon, get Mr. Lewis? And he can just stand in the doorway there, or he can come right up next to. What's the answer with Mr. Lewis?
The answer is I am feeling very in the holiday spirit, and I'm just going to do all three.
Okay, then thank you. We'll bring Mr. Lewis. He can stand right next to you, and all we have to do today is waive arraignment.
Your Honor, I have a weird request. Is it possible while he comes out, I can hold his baby? He's never seen his baby before.
Is that his baby right there?
Yes.
Yes, but you'll need to stand over at the corner of council table.
Got it.
Mr. Jordan, am I remembering these are actually Mr. Whitenauer's cases?
That's correct, Your Honor.
Okay, did the Scarfed Wonder rejoin us? He did. There he is. Excellent. Okay. Mr. Lewis, welcome back.
How you doing? How you doing, Your Honor?
I'm about the same as I last saw you. I got an update for you. Ms. Bumpus is going to handle all three of your cases. Your family had retained her for the case ending in 696. Today you were here on 697 and 698. No lawyer. We needed to figure out what was going to happen. Ms. Bumpus has spoken with your family and she has agreed to manage all three of your cases. She is also holding someone who you may not have met before, but is related to you. It's about as close as we can get you guys right now, but that's a little holiday hello from your kid and the court system, okay?
Much appreciated, Your Honor.
You're very welcome. That doesn't solve your issues, though. You've got three cases. Ms. Bumpus, is Mr. Lewis going to waive arraignment in the three cases?
Yes, Judge, it's or not.
Pardon me?
Yes, or not.
Great. So you get to fill out that same form again. You can just do it one time. Yeah, she'll put the three numbers on. Oh, wait, is that for Mr. Lewis? Right. So if you'll do one for Mr. Lewis, Ms. Nelson will get it in all three cases. So what's going to happen next, Mr. Lewis, is that Ms. Bumpus will get all the discovery in your three cases from Mr. Whitenauer, who you already got all the discovery.
While we were on lunch.
Okay, well, the gentleman you see on the screen there, that's your prosecutor, and he has already sent to Ms. Bumpus, now that we know she's going to be your lawyer in all three cases, the discovery that the state has. So Ms. Bumpus has a lot to digest, seeing what the state has in this situation. She will then get with you, and you guys will talk about, are these resolvable, or do we need to file some motions? And it may be that there's something that needs to be suppressed, or who knows what. And Ms. Bumpus will drive that bus and let us know whether we need to have a motions hearing. If we do, you'll come back in here for that. Otherwise, the next time I'll see you is because you and Ms. Bumpus have worked something out with Mr. Whitenauer, and it's going to be a plea to something. But it doesn't have to be. In the end, it could be trials, and then we'll get you a trial. The state would decide which of your three cases it wants to try first, and we'll just keep doing trials until all your cases are resolved. But that's a little ways down the road. I'm just sharing you the long view so you know what to expect. What will be next is Ms. Bumpus will be coming to visit with you to talk about next steps, discovery, motions, bond, any of these different things. And then she'll get you back in front of me with whatever we're going to do next. Does that make sense?
All the sense in the world, Your Honor.
Okay. Any questions?
So had one, and I can't recall it at the very moment, unless you would in fact know my next date by any chance, or is that kind of?
I don't, because it depends on what you and Ms. Bumpus decide you're going to do. If she's going to file a suppression motion, then the next date you'd be here would be to argue that motion, unless there's something that's important, but there could be something more urgent, like a bond motion or something else that could come up where Ms. Bumpus says, look, we need to talk about it now. And then the next available window I make to you and the prosecutor and to Ms. Bumpus, and then we'll talk about whatever that urgent thing is. But the natural course would be either you work the case out or we do these motions, and eventually get you trial. Okay?
Yes, Your Honor.
Mr. Whitenauer, anything you need to share about the three Lewis cases?
Judge, I would just add that Ms. Bumpus and I have discussed the possibility of referring these cases to an accountability court, and I'll work on that. In the meantime, I have sent the police reports for all three, and I'll have full discovery served as well.
Okay, excellent. Do you know what an accountability court is?
Yes, Judge McBurney, I'm aware of what accountability court is. The question that escaped me earlier just
returned.
Yes. What would be the chances of me actually seeing the discovery myself, or would that be something I would?
Yeah,
Right on.
100%. The only thing that is difficult for you to get would be, for example, if there's body cam footage. That's a digital file, but then Ms. Bumpus can either get an order from me to bring a laptop into the jail, or we make other arrangements. All the paper discovery, she can give you copies of. You're allowed to have that, but you don't get discs or thumb drives or anything like that. But we can make arrangements so you and your lawyer can look at it together.
Understood.
All right, Ms. Bumpus, anything else? Okay. Okay. All right. Well, I'm glad we sorted this out. In particular, thank you for the holiday spirit, Ms. Bumpus. And the other two?
Yes.
Good. And I think the waiver of arraignment serves as an entry. So you're in, all three.
All right.
We'll see you. All right, Mr. Lewis, that's the news.
All right. Thank you very much.
Let me just get Mr. Whitenauer off the spotlight. All right. Yes, ma'am. Your question.
Yes, Judge, I submitted, I heard that you were a judge that would maybe be inclined to sign in some beyond the bars orders. I had submitted to Ms. Nelson, and I just don't know if you got a chance to see them or not, but if so.
So it's a good question. And yes, I am. And I did get the email, but it came in the midst of other things. And so I was more confused, and it meant I was going to need to talk to Ms. Nelson about it. And she was busy and I was busy. We had a visiting judge. These would be unindicted cases. You were working with Ms. Hollander and you've reached an understanding. If you and Ms. Hollander have, if it has your seal of approval and Ms. Hollander's, I'm happy to take care of it.
I believe it does.
Okay, good. Then I have the email still. I will deal with that. I'll make a note and take care of it.
Okay, thank you, because I forget her name, the program director keeps asking.
Yes, she's persistent.
Susan.
Yes,
Susan,
yes,
Sorry.
but she's good at what she does.
Thank you, Judge, and that concludes my business. May I be excused?
Yes, ma'am. Thank you for coming all the way down. Sorry we were late.
No, thank you.
All right, let's turn then to, I think that finishes that calendar. Mr. Ballantyne, can we bring Mr. Ballantyne out? And Ms. Feely or Ms. Wood, if one of you wouldn't mind relocating room for. Those are some pretty serious holiday pants, Mr. Marshall. You too. You too. Ms. Wood, do you have Ms. Tidwell's cases? Because the oldest one, just by a few digits, is a low number.
Yes, Judge, I do have 12 and 13, and I do want to inquire.
Oh, Mr. Hirsch is on the call, so.
I want to inquire about that.
Okay, we'll get there. He's here, and that's next. Ms. Tidwell is next. I just was looking ahead to see what we could do. And then Samantha Findling, I think you told me, is your office. So that's Ms. Feely's case?
Yes.
All right. Oh, she still, I couldn't see. Yes, it means to act like you're not here. That Ms. Feely, Judge Emerson's favorite lawyer. All right, let's go on the record in position 11. It's 12 SC 111-150, State versus Alexander Ballantyne. Mr. Ballantyne is here with his lawyer, Mr. Hall, and Mr. Jordan is here for the state. Good afternoon, Mr. Ballantyne. I'm Judge McBurney. I don't think we've met before. Okay, that would fit since I think I had just become a judge when you resolved your case with Judge Downs. I've inherited her docket through a few other judges, which is why we are working together on your situation. I took the liberty to speak with Mr. Hall for a few minutes before you came out while we were waiting on another matter. And he's explained to me the complexity of your situation with Georgia and Alabama, both wanting some of your time. And we'll now get on the record a little bit of his proposal. We'll see what the state has to say about that. And then we need to figure out what, if anything, I'm in a position to do about the Alabama situation. I just want to manage your expectations. Just Mr. Hall's request was sensible, but it doesn't always mean it's doable. And I'm a Georgia judge, not an Alabama one, and that may preclude me from getting you out to travel to Alabama under your own means, as opposed to letting Alabama know Georgia's done with Mr. Ballantyne, and so you've got X hours to come get him. If you don't, then of course we need to let him go, because we don't generally just hold people. Okay, but we'll sort all that out. I'm looking to see if I do. I have your warrant. So the warrant, which I signed in February of this year, alleges that this is the Alabama stuff. The basis of your warrant here is what you allegedly did in Alabama, which supposedly occurred on March 15th of 2021, when you broke into a car and stole some things in Lee County, Alabama. Those are the allegations. But you being arrested for something or charged with something is a basis for revoking probation in Georgia. That's really all we're talking about. Is someone says you did this thing in Alabama, and so that could be a reason to revoke your probation. But layered on top of that, you weren't supposed to be in Alabama without getting permission from probation. And it follows naturally, if you were arrested for something in Alabama or allegedly did something in Alabama, you crossed state lines, and that was without permission of probation. So bigger issue, new charges. Lesser issue, you took a trip without getting approval. Those are the two things you allegedly did that were violations of your probation. Mr. Hall, it sounds like Mr. Ballantyne doesn't need to admit or stipulate or deny, because the state is dismissing. We'll have to see what verb we use, because it's not the DA's warrant. It's my warrant. I think that maybe the DA isn't going to pursue these charges. Is that your understanding?
Yes, that's my understanding, everything you just said. And I think I already mentioned this. Let me make sure I'm not neglectful. So one of the primary points, which of course I understand from this officer of the court, and Mr. Jordan will address, is Mr. Ballantyne has never been arrested. Okay, I thought I'd said that. I just want to make sure we're on the record now. So he's never been arrested on these Alabama charges. They're unknown to us. And so therefore, we don't even have a situation where he's out of state.
So you did mention that, and Mr. Ballantyne, in a non-poker player way, reacted when I said, well, so you've been arrested in Alabama, telling me actually he doesn't think he's been arrested in Alabama. Maybe entirely correct. We don't need to litigate that today. There are somehow 3 warrants listed so specifically that they're like 12 digits long, supposedly for Mr. Ballantyne out of Lee County, Alabama. But let me find out from Mr. Jordan, are you declining to prosecute the probation warrant in Mr. Ballantyne's case?
That is correct, Your Honor, and I do think that that's the most appropriate verbiage to use. After speaking with Attorney Hall and looking at the amount of time that's left on this particular probation, in the face of judicial economy, I don't believe that it would be good practice to ask for a continuance in order to be able to prove the charges that Mr. Ballantyne has been charged for out of Lee County. So in the interest of justice, the state would decline to prosecute this warrant and just allow Mr. Ballantyne to be able to handle the situation out of Alabama.
Got it. Okay. I think that's the terminology I would use as well. So I will find that the allegations are unsubstantiated because the state is choosing not to pursue them. And I think you had mentioned how much time remains, but let's get the official answer. Ms. Tucson, good afternoon.
Good afternoon.
Did you have a good lunch break?
It was quick.
It was quick. All right. Well, thank you for coming back. Can you tell me how much time remains on Mr. Ballantyne's probation?
On that case, he has 18 days remaining, ends January 7th, 2023.
All right. This seems like a banner candidate for terminating the probation or suspend, whatever we need to do to have Mr. Ballantyne no longer on supervision or responsible in any way to DCS.
Okay.
So let's do that. That doesn't get us all the way to where you were trying to go, though, Mr. Hall. So I don't know what the right term is, Ms. Tucson, but I'll dismiss the warrant, or we'll void the warrant because the state's not pursuing the alleged allegation, the allegations. But that leaves then the Alabama situation.
Yes, sir. And just to take a brief step back, Your Honor, would be going to whatever the language you just used, and then add in terminate and close probation.
Yes.
This language I'm used to seeing to make sure it's buttoned up.
Yeah.
Then that brings us to, so there's no longer a Georgia basis to hold Mr. Ballantyne, and he normally would be released from the Fulton County. How?
You're good. That was Ms. Nelson.
Oh, got it. However, there is an Alabama detainer sitting on him. And so, and I think Your Honor has already pointed out, well, I'm open to hearing some ideas, but there's only so much that my powers allow me to do as a Superior Court judge. And I agree with that, Your Honor. So I have a couple of different ways to think of solving this. The way I originally thought of it was that the detainer that's actually, it is a detainer from Alabama, but the one who is holding it here is Georgia. And so I was thinking that Your Honor could grant him a bond, a low bond, or a UJR bond, what I used to call a signature bond, with the condition that he report. My request would have been report by the close of business on December the 26th, so he can spend Christmas with his family. That doesn't move the court, then within 24 hours of release. But when Your Honor made that comment, it did cause me to, step back and rethink it. And so I think I can see a potential problem with that. And so my second and third suggestions would be these. One is that you enter an order that provides that Alabama has 48 hours or 72 hours, whatever the appropriate time is, to come get Mr. Ballantyne. And if they don't, he is released from custody. That seems to me, because otherwise I'm put in a situation, if they don't get him within 48 or 72 hours, whichever number we arrive upon, that I then have to file a new petition. We have to get back on a calendar. And in the meantime, Mr. Ballantyne, who's already been in the Fulton County Jail, and as we all know, not a great place to be under any circumstance, is sitting there even longer, not just through the holidays, but sitting there until we can get back on the calendar. And my experience, no disrespect, but it's just a busy court system, not necessarily Your Honors. But
we're all busy. It's okay.
So it's just difficult. I would propose that. And then a variation on that is if they don't pick them up within 72 hours, and you wanted to say something more than just he is to be released, is that he is to be released with instructions to report, in so many days or by date certain to Alabama. I think the middle one is one that to me makes the most sense and causes the least possible problems.
I think that's right. I don't know what I'd be entering a bond on. There isn't a Fulton County case for which I'd be giving Mr. Ballantyne a bond. It's a detainer or a hold from Alabama. And I don't think I can attach to that conditions of release. I probably do have the authority to tell, and it really would be an order to the sheriff saying, if Mr. Ballantyne is still there after X days, you need to let him go, because that covers the sheriff. If Alabama shows up saying, what did you do? It was McBurney. And so then Alabama can be unhappy with me and I can deal with the consequences. I'm going to need to have Ms. Nelson talk with people in the sheriff's office about how that has been navigated in the past. I know that the presiding judge, we have a different one every week, but there is right now someone who is presiding for Superior Court. handles I'm not remembering the word. It's when you have a detainer, you are seeking to, starts with E. Extraditions, handles extraditions. We just don't do them very often, but we handle extraditions. So there is a judge who ought to be able to hear the extradition if in fact that's the situation we're in. But it doesn't sound like Mr. Ballantyne would contest that.
We are not contesting. I'll state that on the record. We are under
Right.
no circumstances contesting extradition. And I am worried that, just the processes.
Yep.
Okay.
Yep. Because the few times I have handled extraditions, after I explain to the folks who are wanted out of state, we have two options. You can sit in the county jail for another 3 weeks and we'll have the hearing, but we have to give the state a chance to get the governor's warrant, et cetera, et cetera. Or I can let them know you don't contest it and you'll leave in a few days. And universally, it's, I'll take a few days. But that's still a few days. So let me find out what I can about the propriety of an order and how it would get to Alabama, because I don't think it's fair to Alabama for me to write an order and it just it doesn't have a docket to go into. It would, there need to be a channel it flows through so that someone in Lee County is like, look at that. McBurney says we got 48 hours to get Ballantyne or he's going to be released. Well, we really, really care about this breaking and entering into a car. We're going to get there in 24 hours versus we got warrants on them if they do, and we'll just let those stay in the system. And my order will have said, you don't just get out, you then need to get to Lee County within X days, whatever it would be.
So, and I have not researched this. I'm going to do exactly what I'm not supposed to do, which is talk about the law in the area I have to research. I don't know if it's 48 or 72 hours as I stand here before the court, but I do believe it's one or the other. And that upon whatever that expiration is, that constitutionally, Mr. Ballantyne is entitled to be released under kind of the Riverside theory of cases, that you can no longer detain someone without being heard by a judicial officer. And I don't know in this detainer situation, whether it's 48 or 72, but worst case 72, I think he would be entitled to be released at 72 hours and 1 minute. And what I'm trying to avoid is that leaking into many, many more hours before I can get back before a judicial officer. That's why I wanted to preemptively raise that with John.
Okay.
I appreciate you hearing me out, so thank you.
No, this is interesting and new. And we need to figure out what the answer is because it will come up again. It's infrequent, but that doesn't mean it never happens. So we ought to come up with an answer. Mr. Jordan, really not your problem anymore. You have done what you committed to Mr. Hall you do. Any thoughts about how we process this?
No thoughts, Your Honor, especially since it contains an Alabama offense. So I would just defer to Your Honor in this matter.
Okay. Mr. Ballantyne, do you have any questions about what we've been discussing?
No, sir. Mr. Hall and myself discussed it earlier and I'm fairly clear on that.
Okay. You understand that if things flow the way Mr. Hall believes they do, and I don't have any reason to doubt his understanding of the flow, that you would need to get yourself to Lee County. I don't know where Lee County is in Alabama, but I do know Alabama's right next door, so it can't be that far. But you would need to get yourself to Lee County pretty soon after you got released to address whatever these allegations are.
I do, and I want to be clear that had either myself or the two of us in conjunction known of any of this, then we would have addressed it. I would have self-reported and we would have met that head on.
Where is Lee County?
Auburn, Alabama, so roughly 2 hours.
Okay.
I'm giving you ballpark travel time, depending on how slow or fast one drive, but 2 hours.
Good. All right. Yeah, don't get a ticket on your way to Lee County. That's even more reassuring. We're not talking about getting to Alaska. You'll be able to get to Alabama and you will need to. All right. I will do some research. At a minimum, the part over which I have direct control has been resolved. Ms. Tucson, who is with probation, will get me something to sign that indicates that the warrant is being canceled. And then in addition, that your probation is either being suspended or terminated and your case is being closed out. So I don't know if home for you is Alabama or Georgia, but your case from way back when with Judge Downs will be officially over. All right, Mr. Jordan, anything else?
Nothing further from the state, Your Honor.
All right. Mr. Hall, good seeing you.
Good to see you, Your Honor. And then one question. First of all, thank you very much, Your Honor, but can I follow up with Ms. Nelson in a day or two, just kind of see what Your Honor finally decides or determines, or just so as we head towards this weekend, I have a sense of what's happening or not happening?
You should. Ms. Nelson may be on leave, but you should call my chambers and we'll make sure that someone is plugged in to be fluent on this question because it involves someone stuck in jail.
Thank you.
All right.
Happy holidays, Your Honor.
You too.
May I get to-
You may. Mr. Flint, we haven't forgotten about you. When Ms. Nelson comes back, we'll hopefully have an update. And same with you, Mr. Dawson. Haven't forgot about you. Ms. Nelson is reaching out to those lawyers, okay?
And Your Honor,
Whoop.
Valeria Hemingway with the Conflict Defender's Office.
You're here. Great. You're one of the people we were looking for.
Yes, Your Honor. This case is actually going to be assigned to Mr. Eric Johnson, but I could handle the plea and arraignment for him.
That would be fantastic. I wasn't sure if that would flow. Are you mostly doing non-complex or how did your name get associated with it?
Because I represented him when he was in non-complex.
Got it. Okay. So Mr. Flint, if you'd come on up to the podium, we'll get Ms. Hemingway big on the screen there. So Ms. Hemingway is a colleague of Mr. Johnson. And it sounds like you didn't get a chance to meet Ms. Hemingway. You may have met Mr. Dark, who used to be a conflict defender. And then Mr. Johnson is another conflict defender. So Ms. Hemingway is going to pass the case over to Mr. Johnson. He'll get the discovery in the case. He will meet with you and you guys will figure out how you want to move forward with these charges. They're not crazy serious charges. They're still felonies. So they're important to work through. But it sounds like you're going to be able to stay out on bond as long as you continue to comply with the conditions of bond. So Ms. Hemingway, are you going to waive arraignment on behalf of Mr. Flint in these two cases?
Yes, Your Honor.
And you may have already done that in non-complex, although I have learned, I don't know that non-complex does arraignment waivers. They just plow right into scheduling. So either way, you had been representing, I saw your entry of appearance, Mr. Flint, for a little while now.
Yes, that's correct.
All right. We will actually send the waivers to Mr. Johnson, but we'll represent that you, on his behalf, as his colleague, waived arraignment for Mr. Flint. Mr. Flint, do you know what I mean by saying, do you waive arraignment? I don't want you to be nervous that you're giving up all sorts of valuable rights.
No, sir. What you mean by that?
So everyone who has been indicted for a felony has the right to have the charges read in open court on the record so everyone can hear what you're charged with. I can explain to you the charges, tell you the penalties for the charges, and let you know you have the right to an attorney and that you have the right to remain silent. That's what an arraignment would be. I'd tell you each charge, et cetera, et cetera. Most folks waive it because their lawyer tells them, hey, this is what you're charged with. And I'm your lawyer. You don't need to worry about your right to an attorney because you've got one and yours is right there on the screen. Yeah. So when Ms. Hemingway says we're waiving arraignment, she says, Judge, you don't need to read the indictment into the record. We know what Mr. Flint is charged with and he's got a lawyer. So you don't need to tell him he's got a right to an attorney. So that's all we're doing here. Ms. Hemingway is going to let Mr. Johnson know that he needs to connect with you. And Mr. Jordan, who's sitting behind you, will double make sure that discovery has gone out. It's a little bit tricky for him because your cases were in non-complex. And so there were other lawyers touching it on the state side as well as your side. Yeah. But we're going to make sure things happen with this. I want to confirm that we've got good info for you. So let me look you back up. Where did you go?
Yeah, I seen her last time.
You see, I told you met her before.
Yeah.
So she's a real good attorney. Just I'm not lucky enough to have her work in this courtroom. You work with Judge Richardson some, don't you?
I do.
So you do non-complex and Judge Richardson?
No, I do complex now.
Oh, you were in non-complex.
I was in non-complex.
Got it.
Yes.
Okay. Well, Judge Richardson was singing your praises. Like, wait, she's not in my courtroom. So I've got an address of Rose Circle in Atlanta. Is that a good address?
Yes, sir.
Okay. That's where you're going to get things in the mail saying you need to come to court. Your lawyer will get something too, and your lawyer hopefully will give you a call when he gets those notices. Ms. Hemingway, do you have contact information for Mr. Flint, phone number, stuff like that?
If I can just get it again, I'm pretty sure it's in the file, but
Can you, Mr. Flint, what's the best phone number? Mr. Johnson's going to need to call you. What's the best number for him to call?
678-704-3016.
Great. So she'll pass that to Mr. Johnson. He's going to get discovery. He will meet with you. And I will see you next, either because Mr. Johnson has filed some motions on your behalf or because he is working the case out with you and you're coming in to plead guilty or the state's dismissing your charges, however that's going to work out. Okay?
All right.
Any
Yes,
questions?
sir. No, sir.
All right. I appreciate your patience.
All right.
You're free to go.
Good to go. All right. Have a good day.
You too.
So I'm just waiting on the phone call and the letter in the mail, right?
Right. So letters will come. We'll never call you. You'll get letters from us saying have to come to court. Mr. Johnson will call you saying, hey, I'm your lawyer. You got to meet with me. We got to talk about your case.
Gotcha.
One last thing. What's a good number we could give Mr. Flint so that if he's wondering, why have I not heard from this Johnson guy? He could call Mr. Johnson.
okay. I will give him my phone number. It's 404.
Hold on one second. Do you need me to write it down? You have here, it's going to be written down. Let's try it again. Ready?
Yeah, all right.
404
795
Yeah.
2487.
87. All right. 447952487.
Yes, that's correct.
And that's Ms. Hemingway. That's not Mr. Johnson. If you call and say, hey, Mr. Johnson, she's going to sound confused.
All right. 2487.
Yes,
2487. So you say Miss Hemingway?
yes.
All right. I got you. I got you, Judge.
All right. Thanks for getting me, Mr. Flint. You have a good holiday, okay?
All right. You too. All right. Y'all have a good.
Ms. Hemingway, thank you for dropping in on this one. It may not have been on your radar because you thought Mr. Johnson would be here, but he is being held hostage by Judge Glanville.
Oh, okay. Well, all right. Thanks for having me.
All right. Have a good holiday.
You too. Thanks. Bye.
Bye-bye. So let's do Ms. Tidwell, please, because we've got Mr. Hirsch, who's been waiting patiently on the phone. Oh, wait, we've got Mr. Arca. Hey, Mr. Arca, how are you?
Hey, Judge, good to see you.
Same. So Mr. Dawson says he has rebroken bread with your firm, and I needed to confirm that because I want to make sure we can move his case forward. What say you?
That is correct, Judge. And I told him you were a great judge, a man who's very entertaining with his words. So he's very excited to have us all back united once again.
The band is back together. All right. Well, let me see how far we got with this. I don't know that we ever got to do arraignment. So what I'd ask you to do, and we'll email it to you, Mr. Arca, is complete a waiver of arraignment and entry of appearance, because I did enter an order in the middle of July letting you withdraw. So
Correct.
currently it's listed as Mr. Dawson with no lawyer. So Ms. Nelson will send you the form we use that'll waive arraignment. Then Mr. Jordan, the prosecutor on the case. Oh, it may be Mr. Whitenauer. Is this a Whitenauer case?
Is.
It is. So Mr. Whitenauer, another prosecutor, Mr. Arca will get you discovery and we'll get the ball rolling.
Is that Mr. Jordan over there?
It is.
Is that the one that's married to the famous young lady?
Yes. Yes.
Judge, you've got a great young man right there, Judge.
Well, I'm glad to hear it because this is his first day. So I'm deciding, do we keep him or do I press that button where he falls into the floor?
I'd say get him out of there.
All right. Well, so far I'm keeping him. But unfortunately for you, you're going to work with Mr. Whitenauer instead on this.
Sounds good, Judge. I'm sure he's just as good.
And his wife is wonderful too. So
Fantastic.
there you go. So Mr. Whitenauer will get you discovery. We'll get a scheduling order out that'll have a deadline for filing motions that is a ways down the road and a date for final plea. And we'll go from there.
All right. Fantastic, Judge. Can't wait to get it.
All right. Mr. Dawson, do you have any questions? No? Okay, good job getting back in good graces with your lawyer, okay? Stay out of trouble. You're free to go.
Oh, no, I do got.
You do have a question.
Yeah,
How do I get my charges dismissed?
I got to, but no, the angry monitor people, was calling me and they was saying they was gonna reach out to you because I had, a balance, but you know, during that time, I have a lawyer and whatnot.
Yeah.
So they was gonna make it seem like, I don't know, she said she was gonna contact you guys.
So is your ankle monitor one right now that you're supposed to be paying for? We switched it over to court. Okay, but there was an outstanding balance during that time when you were saving up to afford your lawyer. Okay, we can fix that. I don't know that I've had any outreach from the ankle monitor company. Okay, well, it wouldn't come to me directly anyway. Someone would manage that and then bring it to my attention, but we'll fix it. If they continue to bug you, let Mr. Arca know. Now that your lawyer's back in place, he'd be the right one to reach out to Ms. Nelson saying, how do we manage this? There's a $3,000 balance, but it's now a county paid ankle monitor. We get the ankle monitoring company paid. Okay, all right. You're good to go. All right, thank you, Mr. Arca.
Hey, Judge, thank you for your time.
Look for that email from Ms. Nelson.
I will. Just watch out with Mr. Jordan, all right? Watch your pocket when you're walking around.
All right.
All right, Judge. Good to see you.
Judge, that's all the business I have. May I be excused?
Yes, Mr. Whitenauer, I hope you feel better.
Thank you, Judge.
You're always sick.
Well, that is
Lots of babies.
children.
Exactly. Yep. All right. Well, happy holidays.
All right, same to you.
All right. Let's now, poor Mr. Hirsch has been on the cusp each time. Is Miss Tidwell here?
She's loaned out.
She's loaned out. Okay, she's busy. 3 cases and loaned out. So the cases are on for arraignment. We've got 2 cases that the public defender is handling, and then one where Mr. Hirsch is listed as counsel of record. Why don't I start with you, Mr. Hirsch? Let me know what you understand is going on with Ms. Tidwell.
I have no idea, Judge. I do not, in fact, represent her on this case. I think that an entry pre-indictment was filed in a complaint room entry back in 2021. We did represent her on a misdemeanor case that she was declared incompetent on. I shared that evaluation with Mr. Jordan this morning. And I was let out of the case. I thought the case had been closed. And then I received a notice about it in July, but because of all of the same circumstances, Judge Morrow signed an order withdrawing me from that case because it probably should have been done in 2021. And I think that it just followed me here on this complaint room, this felony, which I know nothing about. I have never had any contact with Miss Tidwell. I tried last year, but she refused to see me, which is what precipitated the evaluation.
Okay. So I'm looking at an entry of appearance that you signed in June of 2021 when this was a complaint, a CP case.
Right.
Nothing has happened in the docket until now, November. So we'll call it a year and a half, a little bit less. Then Ms. Tidwell is indicted for not just misdemeanors, but it looks like a felony obstruction for allegedly kicking an officer, and then maybe 2 misdemeanors. So I don't know how it got elevated. But either way, you are saying that you are not representing her, not in a position to represent it. There's nothing that says you were allowed off the case. I don't mind doing that, to be clear. I just wanted you to know what's in the docket.
I understand, Judge. I apologize for that. I don't know if there was a way that I after filing that entry. I don't even remember doing it, honestly. Mr. Jordan reminded me this morning that it was there. And while we were trying to make contact, she was in custody, and I would go to visit her and she would refuse to see me. It happened about 3 or 4 times. And so at that time, we were trying to represent her as best we could. And then I think that's probably why I didn't know to seek a withdrawal on this entry. Honestly, I didn't really even know it was there.
Okay, got it. Well, let's get you off the case. Can you file a motion to withdraw and I can grant it?
Yes, sir.
Do you need the case number?
I do have the calendar. I have everything I need, Judge.
Okay, great. If you will file a motion to withdraw, I'll enter an order letting you off the case, which now gets us back to Ms. Wood. You would, I assume, take over for that case since you start with the 002 case. Do you know where Ms. Tidwell is loaned out?
Georgia Regional.
Ah, okay. Because of a restoration order that's in place?
Yes, Judge, so it looks like she was transferred over there on the 6th of this month.
That's good.
And thanks to Ms. Nelson's investigative talents, we determined that there was an order. I think it was just, we're scared Judge for one of those. And it came back in August of this year. She was not competent at the time, Judge.
Okay.
So I do have a question though. Would that put all 3 of these into judicial hold? Okay.
It should, and that's what we'll do. And so I don't think we even do an arraignment. I think the action I'll take is to sign Mr. Hirsch's proposed order, letting him withdraw. If you could do an entry in all 3 cases, so it doesn't say Rashid Merrill or Matt Hirsch, and then we'll figure out which case resulted in the order, the 90-day order. And then these 3 would go into judicial hold and we would do an inquiry a little ways down the road. And at some point, the state will need to be thinking about, well, which do we pursue? I mean, there's some alleged violence in the mix. So they may want to persist on at least one of them. But mostly it sounds like we need to get Ms. Tidwell some help. Okay, you bet. Mr. Hirsch, anything else?
No, sir, Judge, that's all I have. I'll get that filed by end of tomorrow.
Okay, thanks.
Thank you, Judge.
All right, I got to go get on one of those scheduling teleconferences I mentioned I have. I'll do that when I come back. Mr. Newcomb is next, and then we have gotten through the calendar at least once other than piles, and we can start taking those pleas and all that kind of stuff.
Mr. Newcomb is in custody and it's a waiver, so we don't really need to.
Oh, we don't need to bring him out? Okay. Then I will jot that down. So waive and schedule. And you're saying that because you can now leave?
If the court excuses me at the end.
I do excuse you. You had a long last week. I won't see you again. Have a good holiday. Glad you have a roof over your family's head. All right. I'll be back and we'll take pleas in Ms. Wood's case and do that one revocation. Okay?
Judge.
Take over for me.
Yes.
Did you just like the way Mr. Newcomb? I just filed it today.
Oh, and then I'll forward you what this else is. Thank you for doing this.
You're welcome.
Was Martin? I think that's a good for it. Yes. Yes. You take my plea on Sunday. I am. That's yours? Yes. Oh, that's the last, so we were trying to figure out who has, so it was conflict at first appearance for the new case, 2260 case. But I couldn't tell, it said Nicole Jones was the conflict attorney handling the California day, and I don't know if she's still with us. What's that on me? Well, it shows as a whole. Can you look at the bookings? I think there might be a retrial bid for him from like 2000.
That's a new one.
Yes. It's just something. Thank you. Well, so what are they going on? Taking saving notes, and closed out.
So you just have two.
Three. This we get to letter Jackson add on. I need to see your case number. Jackson, I'll send it again.
Okay.
Thank you, Ms. Nelson.
You're welcome.
How's it going, Mr. Jordan?
It's going good. How's it going for you? Ms.
Okay, you
Nelson?
hanging in there?
I'm enjoying it so far.
Okay, well, let me know if there's anything you need.
I appreciate it
Feel
so
free
much.
to email me. You've been doing so great so far.
Thank you so much. I appreciate it.
All right. Holiday.
Enjoy your Christmas and your New Year.
And don't forget your water bottle. Yes. Bye.
Did Pierce talk to you about that, that motion for, that you have? I think it's a motion to suppress identification, some.
No.
Yeah, he didn't talk to you about that?
Did he talk to you about it?
No, I was hoping that he'd talk to you about it.
So we might need to, this just now occurred to me today. The co-defendant's attorney on that is wrapped up in YSL stuff.
Eric Johnson, yes.
So yeah, we'll probably need to see. And I only bring that up because it was reset from, because I think that attorney prior to that had actually filed the co-defendant's motion. And then we reset it to the January date for Mr. Johnson to get familiar.
Gotcha.
And so now I'm just wondering if it's gonna actually need another reset. Yes, because I just now remembered that when he said he was wrapped up in the YSL stuff. But I'm happy to talk to you about that case. Yes, thank you for reminding me. I forgot that I saw that on the calendar.
No problem, because those are some of working on the January 9th trial calendar, trying to get out as many subpoenas as I can before things really shut down.
Yeah,
So,
that's, yeah, smart. I'm trying to think if I have anything on the 9th calendar.
See.
I have Raheem Conley, but that's also the situation where Mr. Johnson is tied up in that one.
Yeah. Don't think we did. I think everything is later in the numbers.
Okay.
Well, they settled. Civil cases are very different from criminal. I got on about 5 minutes late. I said, I'm so sorry I'm late. Judge, we've settled it. Well, all right. I'll be late next time. So how did you know Mr. Arca?
My wife is actually good friends with him. We met out in Cobb County. We were both solicitors out there. And
You and Mr. Arca, or you and your wife?
Yeah, my wife and we went to, I think she's known Mr. Arca for a while, but we both helped in a race out in Cobb County, and I met Mr. Arca there.
Races in running or races in I want to be elected?
Our races in being elected, it was Chris Lanning when he was running for Solicitor General out in Cobb County.
Did he win?
No, he didn't win, unfortunately.
Okay.
Yeah.
Note to self, do not have Mr. Jordan assist your campaign. All right.
So I met him there, and we hit it off. He's a lot of fun. So.
Good. He sounds like a funny guy.
Yes, he is.
All right. Where would you like to start, Ms. Wood?
Well, should we start with Mr. Kyle's
Sure.
situation? Simple.
Okay. I mean, if they're going to be tricky, doesn't matter. We're going to have to do them all anyway.
Yeah, that's fine.
But let's find a deputy and do.
Right here.
Do you think they were bringing people downstairs?
I just reached out to Deputy Gordon. I thought maybe that is what they're doing.
Temperatures are going to be 35 degrees below normal. That's a big number.
Sounds awful. Judge, I have an off-topic question for the January 9th trial calendar or the January 5th call of the calendar that is going on January 9th.
Yeah.
Is there anything that's specially set for that particular date? I'd been told that, but I couldn't decipher from the calendar. If
Yes, it's not on the calendar, not because it's cryptic, but we published the calendar and then Ms. Nelson and I sort of fretted about some of these things need to be tried. These lawyers, there are certain defense attorneys who are pulled in lots of directions. Mr. Johnson is one. I don't know if you've even had a chance to meet him yet because he is pulled in lots of directions. And so the way that you put lead in their boots is by doing a special set. I don't need to do that to Ms. Wood or Ms. Feely because this is where they are for a trial calendar. So to answer your question, yes, there are two specially set cases, one for the week of the 9th, that is Jerry Peck. Ms. I think Charles has that for your office, and it's Mr. Johnson. And then on the 23rd, right now, no, not the 23rd, the 30th, I think is our other week. Yeah, the 30th. Mr. Johnson and Ms. Feely are specially set on a murder case that is Mr. Abate's, but he's going to be busy, he said, doing a Barcelona shooting. And so a colleague of his will handle that. But it's also specially set again to get Mr. Johnson here. The 9th will go forward unless Mr. Peck pleads. The 30th may have to be rescheduled if YSL starts, hey, we're ready for Mr. Piles. Oh, you knew that. Okay. That's why you just got here. The one on the 30th may fall apart if YSL goes forward and Mr. Johnson is part of what's going forward. So a couple variables. Does it go forward? Is he in the first tranche of defendants who go? But if he is, we can't do it. So anything with your name on it could still go. And especially setting just means that's what will go first if it goes. I suspect Mr. Peck will go. I don't know what we can do with it. Williams and Tolbert. I don't know if the names matter, but those are the co-defendants that are specially set the week of the 30th.
Understood. Thank you.
You bet. Okay, let's go on the record once I get my hands on the petition. Or warrant. Looks like it. Okay, this is 20 SC 174240, State versus Milton Piles. Hello, Mr. Piles.
How you doing, sir?
I'm all right. How are you doing?
I'm doing fine.
Mr. Piles, you pled guilty to a charge of criminal damage to the second degree a while ago, and were given probation. Yeah. And there is an allegation that soon after you were released, you failed to report. So basically, you never reported, and you moved out of the address that you gave as your address, and then so that would have been in early 2020. Fast forward to the middle of 2021, still a while ago, you allegedly committed a new offense, criminal trespass here in Fulton County. So we have what we call technical violations. You never reported, and you moved without explaining you were going to move. So we didn't have a new address for you, or you just never went to the place where you said you were going to live. And then a more substantive violation because of this new charge in July of 2021. Ms. Tucson, how much time remains on Mr. Piles's probation?
He has one in the one for Fulton. He has 2 years and 14 days. That's the one now, 20 SC 4240. And then there's a Rockdale County case that has 19 years, 3 months, and 23 days remaining.
Got it. All right. Rockdale's a little bigger. Okay. Thank you so much. Ms. Wood, is Mr. Piles admitting to these allegations, challenging them? Where are we coming down?
We are, Judge, we're admitting.
All right. Are we recommending anything?
Yes. So I've talked to Mr. Jordan about Mr. Piles's situation. He's been in custody since November 8th of this year, so he's served 43 days. It's our understanding that the state is okay with him being revoked for the time served and reinstated. And Mr. Piles may want to elaborate his Rockdale County matter. He's in something called resource court. And so he's eager to get on his way and get back into his program over there, Judge.
Okay. Did the criminal trespass get prosecuted, dismissed? What do you know, Ms. Wood, about that?
Did you plead in criminal trespass?
Yes.
Yes, it's resolved.
Okay.
Mr. Piles.
All right. And what happened with not reporting? Was it a issue with housing? Was it an issue with addiction? Was it an issue of, I just don't want to report?
He tells me, Judge, it was related to the pandemic. There was a lot of confusion. It looks like the first one he missed was right after the shutdown started. And then it kind of just transpired from there. And I do have a new address to give Miss Tucson for him as well, Judge.
Okay. That address that we're going to get, Mr. Piles, is that an apartment, a house?
Apartment, sir.
Okay. And is it one that you are renting, or does resource court get it for you, or how are you affording rent?
What's going on right now, Judge, is that I got 18 months of resource court with 19 years probation. Right now, I can't stay at home. I'll be doing work release. So I go into Rockdale County Jail at 7 o'clock every day.
Okay. And that's housing for you,
yes,
basically. So when it's time to eat dinner, go to bed, you're back in the Rockdale County Jail. Sun comes up and you're off working.
I'm going to the program.
The program.
Yes.
Got it. Okay. And that program meaning resource court.
Yes, sir.
And is the objective eventually to connect you with employment, or?
This program actually helps me, Judge, as far as my mental health resources, as far as my disability. I'm going for different approaches that I feared through the years, like GED, license. Judge, I just really want to tell you, I've been doing good. You know, when I get to the point where I don't have money for my medication and I get a little bit unleveled. And at the time, me and my fiance, we was moving, and I kind of packed my medication up and got irritated and off balance. And
what do you take medication for?
I take medication for PTSD, anxiety, and depression.
And you're taking it now?
Yes.
You've been getting it at the jail?
I just started getting it at the jail, but I'm getting it.
Now you're getting it.
Yes.
Were you getting it through resource court?
Yes.
Okay. What was the crime in Rockdale County that got you the 19 years probation?
Me and my fiance had I kind of, you know, like I said, I didn't take my medication, and I got a little irritable, arguing, and, you know, the law came and it was over with.
Okay. So was it an aggravated assault? Is that what the charge was?
Yes, sir.
Is there a judge who helps run resource court in Rockdale?
His name is Mumford.
Judge Mumford.
Judge Mumford.
Excellent. Okay. Mr. Jordan, your thoughts about what we do with Mr. Piles?
Your Honor, the state is in agreement with the negotiated stipulation to revoke the time served and continue him on probation, especially given the information that he's currently in a program, which sounds like is doing him good currently. So the state would just like to allow him to continue on probation so that he can handle business here and out in Rockdale as well.
Thank you. Ms. Wood, you were going to share a new address, but it sounds like Mr. Piles's address is the Rockdale County Jail. And maybe that's the address you were going to share.
I was gonna let him help me elaborate on that, but I went ahead and gave Ms.
No.
Tucson his family's address. That's, yeah, that's fine.
Judge, my address that she's about to give you is my address. It's just that I can't stay at home with my family.
That's what you said. You're right. So you could actually
can
have
go
Christmas
home.
dinner,
Yes.
but Christmas lunch, but by 7 o'clock, you need to
You have
be,
to be at Rockdale.
okay. And what happens if you miss a curfew?
I'll be back in jail, which
Okay.
I don't want to do.
Judge Mumford
Yeah.
will deal with that. Okay. All right.
It looks like there's another warrant from Judge Kraus. Is it possible for us to handle that as well, or does that have to go through her? I can't remember the rules.
No, I can handle it.
Okay. It's 19 SC 170992.
Miss Wood, was there still a hold on that one? Because it
It's
looks
showing in the
that
Odyssey.
case is closed.
Oh, wonderful. Yeah, it's showing in the booking screen.
Yeah, it says here on that particular case, it ended August 16th, 2022.
Thank
The
you.
probation.
Done.
Never mind.
Okay. All right. I'm excited and intrigued by this resource court. I know Judge Mumford, so I'm going to reach out to him and learn a little bit more about that. We have accountability courts here, but we've never had one where you're basically checking yourself back in at the end of each day. I don't know that our sheriff would warm to that notion logistically. I think conceptually he'd be very supportive of it, but it's kind of tricky to, in a jail the size of ours, to have people checking back in all the time. But there may be ways we could build on that, especially since we've got 600 beds right down the street. Okay, so Mr. Piles, I find that you violated the terms and conditions of your probation when you did not report.
Yes, sir.
And when you committed the new criminal trespass, that criminal trespass was before you started resource court?
Yes.
How long have you been in resource court?
I just got resource court like November.
So you've been in, well, but wait.
I've been incarcerated 10 months.
10 months for the criminal trespass.
Like in Rockdale or in Fulton County?
In Rockdale.
Okay.
Oh, for the aggravated assault?
Yes.
Okay. I'm just trying to get all the dates here. So you
I got incarcerated, Judge, April 14th.
of 2022.
Yes.
So you haven't been able to start resource court yet.
No, they're waiting on me now.
Got it. So you were sentenced to resource court and 19 years probation
Yes.
as a result of the aggravated assault in Rockdale. It's not that you were doing it for a while and then you got grabbed on this probation warrant. You're just now taking care of all your business.
Yes.
The big piece of business was in Rockdale.
Yes.
The smaller piece is here, and this will get you back to.
When I get released, I have to go to report to the program and then report to Rockdale County Jail that night.
Got it. Okay. Ms. Tucson, anything we need to work through in terms of reporting for Mr. Piles? He's going to be residing in effect at the county jail for the first part of his 19 years and for a chunk of the remainder of this case.
I believe that what we have in the system, he is under, they sent it back to Fulton, because of this probation violation.
Mm-hmm.
But I can send a email to his officer letting her know I did the revocation, and he would need to call her and I could send Miss Wood her phone number. And the case will need to be transferred, so he'll still need to report to probation if he knows where it is in Rockdale, or he can come to Atlanta.
Okay. Your family home, is that in Fulton County or in Rockdale,
In Rockdale.
where your mom lives?
Oh, my mom stays here.
Okay. Well, when you're done with resource court, where are you thinking you're going to live?
Oh, with my wife, with my fiance in Rockdale.
Oh, in Rockdale?
Yes.
Okay. So it sounds like, Ms. Tucson, that Mr. Pyle's short-term residence will be Rockdale at the jail, but longer term also a residence in Rockdale. So where he certainly has to report to resource court when he gets released. Where ought he to go to plug back in with probation?
That is 981 East Freeway Drive, Suite B as in boy, in Conyers, Georgia.
It's called Freeway Drive?
It's 981 East Freeway Drive, Southeast.
Okay. All right. All right. So we're writing that down.
Confirm where you are revoking how many months?
Oh, I was about to get there, and then I was thinking
Okay.
through, wait, where's he gonna be? So what I'm going to do is revoke 45 days because I do find that Mr. Pyles violated his probation, and then reinstate the balance. And I'm going to add the special condition that Mr. Pyles complete the Rockdale County Resource Court Program. So that's a condition of this case as well. So if Mr. Pyles decides he's going to quit resource court, he'll have to deal with Judge Mumford and Judge McBurney.
Nah, that'd be too much.
Okay.
Mr. Jordan, anything else on Mr. Pyles's case?
Nothing further from the state, Your Honor.
All right. Ms. Wood, anything else for Mr. Pyles?
No, Your Honor, thank you so much.
Any questions, Mr. Pyles?
No, sir, thank you, Judge.
You bet. Take advantage of this opportunity. You're not a youngster anymore, and it looks like you've been wrestling with some mental health issues, maybe some addiction issues. They often go hand in hand. And if resource court's going to get you headed in a different direction, that's good for you, and it'll certainly make your fiance happy.
Yes, yes.
All right. Good luck.
Thanks.
Yes.
Who's coming out next?
Andrew Cockrell, number 4.
When I was in court with ADA Hand, do you normally prefer the prosecutors to take the plea from the witness stand?
So the preference is driven by Ms. Rivers being able to hear things. I'll be able to hear you, and I think she prefers, because you're not blocked by that screen, but I don't mean to speak for her. What's your?
The defendant's coming out.
Yeah, the defendant's going to be at the podium, and then you're blocked by that duo.
Understood. Thank you.
Okay.
And my understanding, before we get on the record, this is a misdemeanor plea.
It is, Judge.
Okay. Are you ready?
Yes, Your Honor.
Okay. Ms. Wood, are you ready?
Yes, Judge.
All right. This is 22 SC 182537, State versus Andrew Cockrell. I'm Judge McBurney. Sir, how are you?
Pretty good, sir. How are you doing today?
I'm all right. Ms. Wood tells me that you are prepared to enter a plea in your case. Something is being reduced or dismissed such that ultimately your plea is to a misdemeanor or some misdemeanors. Is that your understanding?
Yes, sir.
All right. Mr. Jordan is the prosecutor on your case. He's going to put you under oath in just a moment. Once you're under oath, it's important that you answer all of his questions truthfully and completely. It's just as important that you let Ms. Wood or me know if you've got any questions, because I need to be comfortable that you've understood what we talked about. Will you do that?
Yes, sir.
Great. When you are ready, Mr. Jordan.
Thank you. Mr. Cocker, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Andrew Curtis Cockrell II.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone to school?
46, 3 years of college and also the Air Force.
Are you able to read, write, and understand the English language?
Yes, sir.
You understand that you have been charged with the following offenses, even though this is not what you were pleading to. Count 1 being felony obstruction, count 2 being battery, and count 3 being theft by shoplifting.
The battery charge, that all I'm aware of is shoplifting obstruction.
Here's the indictment. Hold on. One moment, Judge. So, hold on. Charges are what you came in on, and then they added that one. So right here is the indictment.
Okay.
Right here. So that's the one that's being reduced, that charge. And then these are the 2 other misdemeanors.
Okay.
Right there. And then this is the 3rd one.
Okay.
Are you good with that?
Yes.
So the battery just relates to an allegation that you hurt Officer Brown's hand because you grabbed it and bent it in a certain way. It flows from the obstruction count. That's all it's about. Does that make sense?
Yes, sir.
Okay. And you'll have you're going to get a chance to tell me anything you want about the situation. I just need to make sure you understand what the charges are.
Understand.
Okay.
Do you understand that you have the right to plead either guilty or not guilty to these charges? If you plead not guilty or remain silent, you will receive a jury trial.
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Lacey Wood, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
As I said, I was not aware of the battery charge.
Do you need more time to speak with Ms. Wood about the battery charge in terms of whether there's a good defense for it or whether you want to move forward? Let me pause that question. Is your expectation, Mr. Jordan, that Mr. Cockrell is entering a plea to what counts?
It would be all 3 counts, Your Honor. It would be count 1 would be reduced to misdemeanor obstruction.
So three misdemeanors, all flowing from this alleged shoplifting and then Mr. Cockrell's interactions with Officer Brown.
That's correct.
Okay, got it. Do you need more time to speak with Ms. Wood about the situation?
Yes, please.
Okay, we'll do that.
Judge, do you want me to step back with him now or do another plea?
Why don't I have another one of those scheduling teleconferences
Okay.
At 4:30. So why don't we press on with the other pleas? We're not going to skip you today, but it's important that you have this conversation with Ms. Wood. And so I think we'll bring out whoever you want brought out next, handle those pleas. And when Ms. Wood is done with her other business, she'll talk with you about the battery, okay?
Yes, sir.
Perfect. Judge, if it's okay, because I think this one might be easier than Mr. Swindle's. Leonard Jackson is my add-on guy.
Oh, right. He was supposed to happen last week or something Monday. Great. Can we have that case number?
22 SC 184680.
And how did he get brought over today?
I have no idea, but I'm so appreciative. Thank you.
All right. Thank you, Sheriff. Because they didn't have, yeah, like it had anything to do with you. Just one case?
Yes, Judge.
And Mr. Jordan, is this news to you?
No, it is not, Your Honor. This is one that ADA had so graciously worked out before he departed.
All right.
And may I have the case number one?
Yes, 22 SC 184680.
Thanks so much. And I'm ready to proceed whenever.
Okay. Is this a plea to the charges as brought? Are there any reductions?
It is a reduction, Your Honor. It's been worked out that count one, the aggravated assault strangulation would be reduced to simple assault.
Okay, so misdemeanor plea.
Yes, sir. That's correct.
Got it. All right. Let's switch it up. Now we've got 22 SC 184680. It's State versus Leonard Jackson. Hello, Mr. Jackson.
How you doing, sir?
I'm all right. I'm Judge McBurney. You're Mr. Jackson. Ms. Wood is standing next to you. This is Mr. Jordan, the prosecutor. He's going to put you under oath in just a minute. So you can move forward by answering his questions truthfully and completely. Please let me know if you've got any questions of your own. Will you do that?
Sure.
Great. Let's go, Mr. Jordan.
Thank you. Mr. Jackson, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Son Bernard Jackson Jr., sir.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
Well, I was taking pain medication, but I have been healing off that, so I kind of eased the buffer because it's giving me like unexpected feelings. So I'm still on it, but not gradually, you know, every day. It's just when the pain occurs.
Understood. So that pain medication that you normally take, you did not take it today.
I wouldn't say this morning. No, I didn't take it this morning. I took it last night.
And that has nothing to do with your cognitive abilities or abilities to understand.
No, sir. No, sir. No, sir.
How old are you and how far have you gone to school?
I graduated, sir.
How old are you?
42.
42, and you finished high school or college?
High school.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with following offenses, even though this is not what you are pleading to? Count one being aggravated assault, strangulation, and count two being simple battery.
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you will receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Lacey Wood, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with her, sir?
Yes, sir.
Ms. Wood, do you waive formal reading of the indictment?
So waived.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Jackson's name?
So waived.
Mr. Jackson, do you recall having being arrested on these charges?
Do I recall being arrested for those charges?
Yes.
Well, yes, I do recall.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Wood, do you know of any outstanding warrants related to these charges?
We do not.
And Your Honor, as previously stated, this is a misdemeanor plea. So Mr. Jackson, has your attorney advised you the minimum and maximum sentence for these charges you're pleading to?
Yes, sir.
And just for the record, Your Honor, since these are two misdemeanor counts, both carry a minimum of 1 day and a maximum of 12 months. Mr. Jackson, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, as previously stated, this is a misdemeanor reduction from count one, and I apologize, I believe that the statute for the first count that it would be reduced to is 16-5-20, I believe, for simple assault. And the recommendation for that count would be 12 months to serve 6 months, with the balance being probated. I believe we have spoken to the victim. I I don't believe she wants contact with Mr. Jackson. As to count 2, the state's recommendation is 12 months probation consecutive to count 1. So in total, this would be a 24-month sentence with 6 months to serve and the balance of 18 months being on probation. Was that communicated to you, Mr. Jackson?
Yes, sir.
Do you understand that the court does not have to accept that recommendation?
Yes, sir.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including federal courts?
Yes, sir.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, sir.
Do you understand that since you're being placed on probation, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Do you understand that you waive any and all defenses, including the mental health defenses, by answering a plea of guilty today?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you're giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a plea of guilty today?
No, sir.
How do you plead to these charges of simple assault and simple battery and indictment number 22 SC 184680?
Guilty, sir.
Thank you. Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
You understand that you only have a limited right to appeal this guilty plea?
Yes, sir.
You understand that since these are misdemeanor charges, you only have 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Ms. Wood, have you advised to Mr. Jackson all of his deadlines for withdrawing this plea and filing a direct appeal?
Yes.
Thank you, Your Honor. For a factual basis for this plea, on July 3rd of 2022, the victim, Ms. Crystal Brown, and that's spelled Crystal, last name Brown has normal spelling, was staying at a friend's house at 917 Dunbar Street in Atlanta, which is within the confines of Fulton County, Georgia. Mr. Jackson also lived at that location. On the day of the incident, Ms. Crystal Brown and Mr. Jackson got into a verbal argument about another man showing interest in Ms. Brown. Although they were not dating, Mr. Jackson was interested in Ms. Brown. Mr. Jackson began strangling Ms. Brown with both hands. She was able to break free and run out of the house and down the street. Mr. Jackson did pursue Ms. Brown. As Ms. Brown was running down the street, she attempted to flag down cars driving by. A witness did observe Ms. Brown running down the street and Mr. Jackson chasing behind her. The witness stated that Mr. Jackson chased Ms. Brown around her vehicle and that once he caught up to her, he began slapping and punching her. Officers did meet with the victim, and when they went to the house, Mr. Jackson told the officers that Ms. Brown had actually put hands on him. Your Honor, we, according to ADA Hand's notes in the file, we did speak with Ms. Brown about this reduction from a felony. It appears that there were never any pictures taken of the of any kind of bruising or damage to her neck. There were no other witnesses that could verify the strangulation. So between Ms. Wood and ADA Hand, they did feel like a misdemeanor reduction was appropriate in this situation. That was communicated to Ms. Brown. She was not in favor of it, but she did understand that it was at the state's discretion to offer a misdemeanor reduction, given that we did not believe that we would be able to fully prove aggravated self-strangulation. So we would ask that you accept this negotiation.
And when you say, and I appreciate your subbing now for Mr. Hand, not being able to fully prove, Ms. Brown didn't back down on her story. She didn't say, oh, you know, it really wasn't that way. It's just you either didn't have an eyewitness or photographs of either the throat or her eyes or something that would corroborate her testimony, which of course would be sufficient if a jury believed it. But your office has decided that traveling on that alone, vis-a-vis a known resolution like we're getting, wasn't worth the risk.
That is correct, Your Honor.
Okay. Ms. Jackson, can you share with me what information you have about Mr. Jackson's criminal history?
Yes, Your Honor.
He wasn't on a calendar for you. I meant to interrupt once we started to say, hey, Ms. Jackson, you need to look this one up because you don't already have it.
That's okay. I did get the information. Thank you anyway. The defendant has 18 cycles. The defendant's last arrest was March 5th, 2018 in DeKalb County for battery, family violence. That case was transferred to the DA on June the 25th, 2018. There was no further information on that arrest. The defendant does have a prior felony conviction. It was in 2003 for aggravated stalking and robbery by force. And the defendant does have misdemeanor convictions. One in 2014 for simple battery, one in 2013 for forgery in the 4th degree, one in 2010 for battery and simple battery, and one in 2006 for obstruction of an officer, and one in 2004 for battery, family violence, and theft by taking. Nothing in addition, Your Honor.
Thank you so much. Ms. Tucson, is Mr. Jackson currently on probation in Georgia?
No, Judge. He has an inactive case, so there's no active probation at the moment.
All right, thank you.
Okay.
Were there any conditions of probation? You mentioned that it ultimately would be, in effect, 24 months to serve 6 months, balance probated, if I go along with that. But any conditions of probation?
No, Your Honor. The only condition that the state would ask, I didn't, to be clear, I didn't see any special conditions in the notes that ADA Hand left. We would just ask that he would not have any contact with the victim, Ms. Crystal Brown.
And that's something she supports?
Yes.
Okay. All right, Ms. Wood?
Thank you, Judge. Mr. Jackson is 42 years old. He's a lifelong Atlanta resident. He does have a high school education, as he told you. He, prior to this arrest, worked as a forklift truck operator. He can return to his job there. He's been in custody since July 3rd of this year, so 171 days. We would ask for credit for that time. And otherwise, we ask that you accept the state's recommendation in this case.
All right. Mr. Jackson, Ms. Brown was someone you knew, but was not someone you were actively dating at the time. Is that an accurate description, or how would you describe your connection to Ms. Brown in July of this year?
Well, me and my roommate was staying together, and like I said, I was working at the time, and it was someone that he had over at the house, and I was barely there, so I barely did know that person. And at that particular day, I was resting, and she came in disturbing my rest, and I wasn't expecting her because my roommate was gone, and she came in on approach and woke me up out of my sleep, she woke me up out of my sleep. So when I awoke, I realized that it wasn't my roommate. When I saw who it was, she started addressing me like, I don't tell her what to do, things like that. And so I was like, well, you could just leave and stuff like that. So that's when the argument began.
Okay, and you don't need to go into all the details, but it sounds like Ms. Brown was something of a stranger to you at the time?
Yes.
Okay, got it. All right. Anything else you want to add?
No, sir. About the strangulation and all that, it was her say so, and about the hitting when she had something that belonged to me. That's why I was really trying to get something back from her. And
What did she have
she
of
had
yours?
my key and my ear pad piece that I had in my ear, and I was trying to get them for her. And when the so-called witness arrived, I wasn't slapping her. I was asking her to leave like this, just
Okay.
go on about her business like that. So when they came up with the slap and all that, it wasn't, it was against my will, so I couldn't really do anything else about that. But other than that, no, sir, Your Honor.
Okay.
I just like to get back to my lifestyle. If I may, give me some proper rest, get back to fundamental living.
You clearly value your sleep, and Ms. Brown interrupted that.
Yes, sir.
Mr. Jackson, I find there's a factual basis for your plea, meaning if Ms. Brown came in and testified as she's talked to the prosecutor and the police, the jury could believe her. I don't know whether they would. It sounds like this trial would be a he said, she said. If you chose to testify, you'd say, there's no slapping. I was pointing and she woke me up and there was no strangling. And she'd say there was. And the jury would need to decide who they believe. You might at trial have a situation where the jury hears about all these other family violence batteries you've had, and that might not help you out a whole lot at trial. So I get why you are working this out to misdemeanors instead of a felony. But I do find a factual basis. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this, but you're standing up here because you've decided it's the best way forward for you. Is that correct?
Yes, sir.
And knowing means that you've understood everything we talked about. You have questions about anything Mr. Jordan said or I've said.
No, sir.
All right, then I'm accepting your plea. I'm going to sentence you on count 1, which is being reduced to simple assault, to 12 months to serve 9 months with the balance on probation. And count 2 is going to be 12 months probated consecutive. So it's an overall sentence of 24 months to serve 9 months. It's a little bit longer than what you've asked for, but I'm going to explain why. I wasn't there. I don't know exactly what went down, but I was not lost on me that you have convictions for battery, family violence battery, most recent arrest, family violence battery, ag stalking. I think you and the ladies in your life, and I'm not suggesting Ms. Brown was an active lady in your life, but that's a process you're going to need to work through. So 2 special conditions of probation. Number 1, no contact with Ms. Brown, which should be easy. If she's someone who only annoys you and interrupts your sleep, you leave her alone, and she's going to need to leave you alone. If for some reason she's coming around you, let Ms. Wood know. You need to not tell her, hey, buzz off, don't text her, don't write her. She's someone you don't ever interact with again. Number 2, you're going to need to complete what's called a Family Violence Intervention Program, or FVIP. Have you done one of those before?
Oh, no, sir. But I like to say the aggravated stalking, I don't know how that came up, but that was at the time me and my mother was going through. So it wasn't like it was with any other random female.
Got it. It was a family member.
Yes.
Okay. Well, I appreciate you flagging that. This FVIP thing is still going to be good for you. It's a class. You'll need to complete that while you're on probation. So no contact with Ms. Brown, and you complete the Family Violence Intervention Program. You'll need to report to misdemeanor probation when you're released, but you'll get reporting instructions. Ms. Wood is going to give them your contact information, and she may give you some contact information for them, but make sure you connect with misdemeanor probation when you get out, okay?
Yes, sir.
Mr. Jordan, anything else in Mr. Jackson's case?
Nothing further from the state, Your Honor.
Okay, Ms. Wood, anything else?
No, Your Honor, thank you.
All right, Mr. Jackson, when you do get out, make sure you take care of that Family Violence Intervention Program, okay?
Thank you, sir.
You bet.
All right, that's all your.
Ms. Wood, why don't you go talk with Mr. Cockrell, because I need to deal with the search warrants that are here. And then we've got Cockrell and Swindle. Anyone else?
I think those are the last 2.
Oh, we got to figure out what the heck is happening with that. Yep. Okay. All right, I'm gonna just sit right here and then I'm gonna work with these investigators in a moment. So, good afternoon. These are all sinners called everyone.
Yes.
Okay, so this is very, very similar. All right, just want to make sure. Why don't you come on up? And I have a favor, if it hasn't already been taken care of, to get from you, if I'm going to do these. The foreperson and the deputy foreperson have asked for the email addresses of all their colleagues. There's an issue that's come up and they need to communicate with all their colleagues via email. I don't know if they reached out to Ms. Settles Isby or someone else. They were promised they would get those email addresses by 10 this morning and they hadn't as of 10 this morning. And so they reached out to me. I just soon not have to get in the middle of it because then I'll go somewhere and then that'll come down on you guys. And so if you could check with Wakeford or one of those guys, figure out who can get all the email addresses to, it is in particular, what's his name, Mr. Parker, I think.
I think I saw it.
Mr. Perry. It may have gone out, but Mr. Perry, who is the deputy foreperson, he's the one who most often interacts with me. And
I'll do that as soon as I'm here.
great.
I'm sorry. I said, just said you would sign my warrants unless.
Happy Halloween.
You too. Good luck with all that.
Thank you, I'm gonna take care of it.
Yes, please do.
Right now.
All right. Have someone send me confirmation, please.
Okay.
Thank you.
Judge, when Ms. Rivers comes back out, would you like me to restart the plea?
Nope. Nope. As long as you remember where you were.
I believe that I just asked him about, enough time to speak with Ms. Wood. Was that the
Yes.
last question?
And Judge, I don't know if we need to put this on the record anywhere, but I did, Mr. Jordan and Mr. Cockrell would like to do this as an alternate plea.
Okay. As to all things or just the battery?
I think all things would probably be safest.
Okay.
The state has no objection.
All right. Well, we'll get all that on the record.
Thank you, Judge.
You ready, Ms. Rivers?
Yes.
Okay. We are back on the record in Mr. Cockrell's case, which was 22 SC 182-537. We got partway through our plea colloquy or discussion, and Mr. Cockrell expressed some concern about the battery charge, count 2 in his indictment. He seemed to be unaware that he had been charged with that, asked for some time to speak with Ms. Wood. Mr. Cockrell, did you have enough time to speak with Ms. Wood about your questions and concerns?
Yes, sir.
Are you comfortable returning to our plea discussion?
Yes, sir.
It sounds like you still want to go forward with the plea, but you'd like the plea to be what we call an offered plea, where you are acknowledging it's in your best interest to plead guilty, but you disagree with some or all of the facts that the state say would prove their case. Is that a fair description of what you want to do?
Yes, sir.
All right. Then we're going to pick up where we left off. Mr. Jordan.
Mr. Cockrell, after the break, do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with her services?
Yes, sir.
Ms. Wood, do you waive formal reading of the indictment?
So waived.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Cockrell's name?
So waived.
Mr. Cockrell, do you recall having been arrested on these charges?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Wood, do you know of any outstanding warrants related to these charges?
We do not.
And Mr. Cockrell, has your attorney advised you the minimum and maximum sentence for each charge that you are pleading to?
12 months. On each one.
Okay.
That's the maximum you could get if this went to trial on these charges.
Good.
Do you understand that?
I understand.
Just for the record, Your Honor, once again, since these are 3 misdemeanor charges, the minimum is 1 day for each, and the maximum is 12 months for each count. Mr. Cockrell, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? As previously stated, Your Honor, this is a misdemeanor plea. The state would move to move count 1 felony obstruction to misdemeanor obstruction. Count 2 and count 3 are already misdemeanors. The overall sentence, Your Honor, is 36 months to serve, and I believe it was 280 days, Ms. Wood?
Yes, that sounds right.
Yes, Your Honor, 36 months to serve, 280 days, the balance being probated. The breakdown for that is as follows: is to count 1, misdemeanor obstruction, 12 months to serve, 280 days, the balance being probated. The only special condition of probation, Your Honor, is that he not return to the incident location, which is 2452 Moragoso.
Morazgo?
Morazgo, my apologies. Morosgo Way. I believe that's Atlanta, Georgia.
And what were the digits of the address?
2452.
2452 Morazgo Way.
That's correct, Your Honor.
All right.
As to count 2, the recommendation would be 12 months probation to run consecutive to count 1. And as to count 3, theft by shoplifting, the recommendation is 12 months to run consecutive to counts 1 and 2. Was that the negotiated disposition that was communicated to you, Mr. Cockrell?
Yes, sir.
Do you understand that the court does not have to accept that recommendation?
I understand, sir.
You understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea under North Carolina v. offered today?
Yes, sir.
Do you understand that since you're being placed on probation, you cannot violate any criminal laws of any governmental unit or any of the special conditions, even though it's only one, in this probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you, my apologies, that's on phones. Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to the trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you, or to court-appointed counsel if you could not afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you to get you to enter a guilty plea under North Carolina v. offered?
No, sir.
Are you pleading guilty under North Carolina v. offered because you have decided that it is in your best interest to do so?
Yes, sir.
Are you aware that even if you do not admit guilt, this is the plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, sir.
Mr. Cockrell, how do you plead to the charges of misdemeanor obstruction, misdemeanor battery, and misdemeanor theft by shoplifting in indictment number 22 SC 182537?
I'm pleading guilty in my best interest.
Is this guilty plea under North Carolina v. offered freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that since these are misdemeanor charges, you have only 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Ms. Wood, have you advised to Mr. Cockrell his deadlines for withdrawing his plea and for filing a record?
We have discussed that.
Your Honor, for a factual basis for this case, on February 1st of 2020, the victim, Mr. Officer Brown of the APD, was in uniform, working an extra job at Kroger, which is located at 2452 Morsogo. I know Morosco Way. The store manager at the time, Mr. Nigel Vereen, Nigel is spelled Nigel, Vereen is spelled Vereen, informed Officer Brown that a man had taken 2 bottles of wine and placed them in a backpack. As the man passed all points of sale, Officer Brown stopped him and asked him to open his backpack. The man appeared to be anxious. Officer Brown detained the man and examined the backpack. He did find 2 bottles of Taylor port wine, valued at $25.18. The man, later identified as the defendant, Mr. Andrew Cockrell, asked Officer Brown to let him go, promised that he would not come back to that location. The witness, Mr. Vereen, meanwhile requested that Mr. Cockrell be arrested. Officer Brown then advised that Mr. Cockrell was placed under arrest, and as he was trying to handcuff him, handcuff him, Mr. Cockrell grabbed Officer Brown's right hand and then his index and middle fingers and bent them backwards, causing pain and later swelling that required an ice pack. To get Mr. Cockrell to release his right hand, Officer Brown struck Mr. Cockrell with his left hand. Officer Brown then placed Mr. Cockrell in custody. Your Honor, that concludes the factual basis for this plea. We attempted many times to reach out to Officer Brown and did not receive any correspondence back from him. Given the factual basis for this case, we do believe that a misdemeanor reduction is appropriate, given that the only injury was to Officer Brown's fingers and that he did not receive medical treatment.
Okay, other than ice.
Other than that,
All right, got it. Ms. Jackson, can you share with me, please, your information about Mr. Cockrell's criminal history?
Yes, Your Honor. The defendant has 10 cycles. The defendant's last arrest was October the 30th, 2022 in Dunwoody, Georgia, where a failure to appear that underlying charge was theft by shoplifting, a misdemeanor. The defendant does have one misdemeanor sentence. That was in 2021. The defendant received a nolo contendere sentence out of Clayton County for criminal trespassing. Nothing in addition, other than he does have a history of failure to appear. There was one in 2022 and 2020. That's it, Your Honor.
Okay, thank you. Ms. Wood, are there any thoughts about connecting Mr. Cockrell with any resources? It's a different criminal history. It's very minor and it's very recent, and he's 46, so it's sort of going backwards.
Judge, I don't know. I know Tin Park Place does like walk-in mental health evaluations. I'm not familiar if they also allow for other evaluations, but I'm happy to have that as part of the condition if we want to put a drug and alcohol evaluation into the recommendation and or a mental health evaluation. And I would be happy to kind of flesh out some of his background for you as well, Judge.
Okay. Well, let's hear from you.
Judge, I have actually been representing Mr. Cockrell since 2020. When I was a non-complex, he was my client, and then he came back on a pretrial bench warrant, and so I've gotten to know him quite well. He's 46. He is from Houston. Most of his family is in Houston. He is an Air Force veteran, and he has many different health issues going on. So he was medically discharged from the Air Force. I believe he was in from 2005 to 2007. Is that correct? Okay.
Close, 1995, 1988.
My bad. So he does struggle with some alcohol issues related to his time in the Air Force, Judge. And I know Mr. Cockrell, it was important for me to get on the record that he does dispute some of the things that are in the state's factual basis. He wanted me to point out that he felt like the officer was being a little overly aggressive in response to what the allegations were. And then once that happened, he got scared and confused and sort of reacted a little defensively. He is a high school graduate. He does have a college education. We're fine with that extra special condition in there. And I do, before I forget, want to put on the record how much the credit for time served dates. So he originally came in on February 1st, 2020. He stayed in for 19 days. So from February 1st, 2020 to February 19th, 2020. And then he was also booked in from November 2nd, 2020 to June 8th, 2021 for 219 days. And then his current booking number, he has been in since November 3rd of this year to the present for 48 days. So I think that does equal out to maybe a little past 280 days, but we would ask for all that credit to be given to him, Judge.
Okay, if you can make sure that Ms. Nelson gets those dates, and she was listening, so hopefully she wrote those down. I'm curious why it was intermittent like that. Why was Mr. Cockrell taken into custody in November of this year again on these charges?
I think from my research is that he missed when it got indicted, I don't think he received the notice. I think he missed an arraignment in this court.
Okay, so there was a bench warrant.
Yes.
Okay, got it. All right. Mr. Cockrell, I understand why you want to enter an offered plea in connection with your interactions with Officer Brown, because you felt Officer Brown maybe was a little overzealous or aggressive. I'm curious why it's an offered plea as to the shoplifting. It sounds like you were going to head out with port without paying. So that part doesn't seem like it really is contested. It's the way the officer was handling you. Is that a fair description? Or are you also saying, I didn't take anyone else's wine, or I paid for it, or whatever the situation is?
But technically, I had not left the store yet. I was still in the store. I wasn't in the parking lot or anything like that.
Yeah, was your plan to pay for the port?
That was the plan.
And you got stopped by the officer past the cash registers?
I was actually by the buggies. I was gonna grab some other things.
Okay, I know that store, and the buggies are, there's only one more door you can go out after that one. You are far from cash registers when you're at the buggies, and you had wine in your backpack.
Well, I was grabbing a buggy, and I was
Okay.
just like, and I turned back around, and that's when he stopped.
And that's when he got you. Okay, I'm not gonna lose sleep over this one. Mr. Cockrell, I find there's a factual basis for your plea, meaning the state could present the evidence that it's shared with me to a jury, and the jury could decide that you were guilty of those things. But I hear you loud and clear that you're entering this plea not because you're admitting to all that. You're saying there are two sides to the story, and you find your side, understandably, to be compelling. And if a jury believed your side, then they might find you not guilty. But rather than take that risk, you want to move on. Is that a fair statement?
Yes, sir. I would like to also say, sir, that this incident happened almost 3 years ago. I've prayed on it, put it behind me. A bad mistake on my part, even the judgment, and just asking for forgiveness. That's all.
Well, and you're getting it. That's a real important point. This was long ago, and other than maybe you had something going on in Dunwoody and you had this NOLO plea, and I mean, there were still other bumps in the road after this, which is what made me worry a little bit about making sure we connect you with resources.
But the only reason, I'm sorry to cut you off, the only reason why that I've been homeless and just not having a phone and not having contact and whatnot, and not being able to get to libraries, places closing because of the virus and whatnot. I haven't skipped town. I haven't even been outside the perimeter.
Okay.
So,
where do you have a place to live when you get out?
yes, sir.
Well, where's that going to be?
It's going to be down on Peachtree Street temporarily. I got Hope Atlanta and the VA helping me out to
Great.
get some more permanent housing, and just want to make the next year better than the last 5 years.
Let's
And
do
I
that.
promise
As long as it sounds like you've been thinking hard about resources, and that's good that you've got a place to stay temporarily until you get on your feet.
Yes, sir.
So I do find there's a factual basis. I also accept your plea as a plea pursuant to North Carolina versus Alford. You understand that's still a conviction. It's a misdemeanor conviction, but it doesn't show up differently on your criminal history. There'll be a misdemeanor conviction for these three offenses. Understood?
Yes, sir.
Okay. I also find your plea is knowing and voluntary. Knowing means that you've understood all the things either while we were talking about them or after you took a break and had a chance to talk with Ms. Wood further about the case. Is that correct?
Yes, sir.
And voluntary simply means that you've decided after prayer and reflection and discussion with your lawyer that this is the best way forward for you.
Yes, sir.
All right. Do you authorize my staff to sign the indictment on your behalf indicating your guilty plea? We try to do that electronically now.
Yes, sir.
Ms. Wood
Yes.
and Mr. Jordan.
Yes, Your Honor.
All right, we'll take care of those signatures. Mr. Cockrell, I'm going to sentence you as follows. On count one, I am sentencing you to 9 months to serve. You'll get credit for all the time you've been in. You've done more than 9 months, so you ought to be released in the next couple of days. Count two will be 12 months probated consecutive to count one, and count three will be 12 months probated consecutive to count two. So it's effectively 24 months of probation that you're going to have, 2 years of misdemeanor probation, because you've already done the 9 months, which is a long sentence for these particular offenses, but it was complicated by the fact that you disappeared for a while, et cetera. 3 special conditions of your probation. Number 1, stay away from that Kroger. at 2452 Marasco. You know the one I'm talking about?
Oh, very well.
Okay, the one near what used to be Zestos, but sadly Zestos is closed. Special condition number 2, you're going to submit to a drug and alcohol abuse evaluation, and probation will line that up for you. You don't have to find it. And if that expert recommends treatment, that treatment is part of your probation. So if they say you need to go to some AA courses or do this or that, that's what you'll need to do as part of your probation. Similarly, you'll need to submit to a mental health evaluation and follow any treatment. So if a doctor says, you know what, you do a lot better with some anxiety medication, or I'm making this all up, the doctor may say, that's not an issue for you. Let's make sure it's not an issue, because if it is, let's treat it. That will help you with some of the problems that you were encountering over the last 5 years, and is really consistent with your vow to make 2023 a better year than the last 5. So 2 evaluations. Any treatment that is recommended by those professionals becomes a part of your 24 months of probation. And you will need to get those evaluations within the first month of your release. Okay?
Yes, sir.
Mr. Jordan, anything else for Mr. Cockrell?
Nothing further from the state.
Ms. Wood?
No, Your Honor, thank you.
All right. Thank you, guys.
Thank you, sir.
For you.
Investigator, if you will come up.
Okay.
I had already read your search warrant, but then you were far away. We weren't going to do it Zoom wise. So that's good to go. And then you got a return in the Tutman case.
Yes, I snuck that in there.
That's all right. You swear or affirm that the contents of your affidavit and your return are true and correct, to the best of your belief and knowledge.
Yes, I do.
Great. Oh, I didn't sign the return. I got distracted by it. So you need to sign the affidavit, and then you'll sign the return in just a second. There you go. Thanks for your patience.
Thank you, Judge.
Have a good holiday.
All right, you too. Happy holidays.
So I got one more of those scheduling conferences, and then it's all us. I'll be back.
So on, Flint, just make it a little bit more simple, just to. Yeah.
Oh, is there one on there?
On the first one is 9 months to serve, count 1. 9 months to serve, followed by.
Yeah, so the judge had to step off, but I'm ready whenever you want.
Oh, no, I said, no, it's 24 months.
Oh, okay, good.
So-
I know there's always this condition.
Swindle, if we can, I'm fine with dismissing all of misdemeanors. Or 6 on the newer indictment.
Excellent.
I guess it's gotta be on the 21 SC, just 5 to serve 16 months.
Okay.
Since that's the max on that one, and then
Perfect.
second would just be 6 to serve 16 months, and then to all of the counts.
Excellent. Thank you. What'd you say? Bring him out? Yeah, that's fine. The judge stepped off, but I'm. He has a teleconference.
And we do have two on the, I don't know if they're both on the 23rd and the 9th, or just on the 23rd, but it's Jamie.
Oh, I need to talk about, well, I'll talk to you after,
Okay.
because he has been not in our jail for a long time. Yes, so.
Is he in Clayton?
Mhm.
Okay.
He is, and like, he's only been here, he was here for an arraignment, and then he went there, because that case in Clayton was further along. And I need to, because I didn't even talk to Pierce about that case. That's how long he's been away. I think Kay was the last one to have it. And the last like date that he was on the calendar, she was looking for some surveillance that she thought could be dispositive. So yeah, we'll get together on that one.
Got you. Just to give you a heads up, same issue. I don't think anyone ever got that surveillance.
Okay.
College Park hasn't been cooperating with us.
Okay.
They just sent me an email saying they need another 10 days to track it down. That's pretty much their normal thing, and then they completely fall off the map.
I was about to, I can't remember if it was his case or one of my other ones, but because when we were having this discussion, she was telling me about issues, and so I was like, well, I'll also try. And I want to say it was that case where we reached out to them and they were like, oh, our system is not working.
For last year, that's the thing about two.
Oh my goodness.
And we also have Nicholas Ford.
Okay, okay.
I think that was the domestic situation where we tried to.
There's like a vehicle.
Yes.
Yes, okay, yeah, I'll
I'm
talk.
sure we'll be able to work out.
Yes, that one definitely should be worked out before trial.
What's your first name?
Julian.
Julian.
J-U-L-I-A.
I knew that.
Thank you so much for letting me in earlier.
No problem.
That door right there wouldn't open for some reason,
Did you
so.
push the button?
I tried so hard,
Really?
yes. And
So you was stuck?
I was stuck and then I found my way out and then I was like, I don't want to trouble her anymore, so I just go back to my
I
house.
was, when I came in, I was like, oh.
Yes.
That's what you had to pull it like really hard, push it hard.
I kept pushing the button and then trying to slide the door, pushing it and keep sliding.
Oh, no.
It wasn't
Yeah,
budging.
yeah, it kind of stuck. So, yeah.
That's a great first date, man.
I didn't know you was stuck.
Were you in any other complex courtrooms other than Judge Eaton?
And just, I was in Judge Richardson for about maybe 2 weeks. And
Okay.
I was in Judge Eaton's court for about a year and
Okay. Yes, you come highly recommended from my people in there.
a half.
Yeah.
I'm glad. I like Tanya and Mr. Clark for the park a lot.
Yeah, they're very even killed.
Tommy Jones and stuff.
Yes.
She.
All the Lewis case.
Oh, I was about to say she was in LaGrua for a
That's
long
what I
time.
watched.
That's right, that's right.
Wow, that's amazing.
So I didn't change courtroom, I just stayed.
I always like people who say that, they hear recommendations and they'll say, oh, that's too long on probation and they come from the. You have people on probation for a while.
Mm-hmm.
Yeah. Everything's consecutive.
That's right.
Who took your spot in Judge Eaton's courtroom?
I want to say, so the last 2 weeks that I was there, Danielle Burnett she came over from non-complex.
Okay.
And she was my trial partner. But they're moving Miss Jenna Dixon, I think she was in case intake, to effectively replace me.
Oh, okay, cool. I know, I always ask as if I'm gonna even know any of the people that are in non-complex now. I feel like everyone that I knew is no longer down there.
Who were you in non-complex with?
Well, the longest person that was my opposite was Quentin Lewis, and I think where's he at, Ingram?
He's in Ingram and he'll be switching to, they were gonna switch him to Adams, but then they decided not to do that.
Yeah, Quentin and I were like, we were a pair for like forever, and it was so funny because all the other teams were like losing people left and right, and Quentin and I were just like, we worked together for a long time, and then he went to juvenile when I came up here, and then I like ran into him in an elevator a few months back, and he's like, I'm in Ingram. Oh, I know.
Judge Hicks.
Oh, Judge Hicks. Oh, he was great. Yes, when I came here, I caught like the tail end of his time before he retired. But yeah, there's like all the names are new to me now. Because like Travis was down there when I was down there, and now he's in a special unit.
That's right.
So yeah.
Very well. We stayed together when we went to the prosecutors conference this summer.
Oh, nice. Very nice. Yeah, you have to tell him I said hello.
I definitely will. Do you know Christian Atkins?
Yes, he is in a special unit now.
He is.
Okay, he covered for someone here recently. I don't think we crossed paths that much before that, but yeah, he was great.
He's my good friend.
Which unit is he in?
He is in the sexual assault.
That's right, because he was covering for Kay. Okay. Trying to think who else. I think a lot of the people that I knew have gone to like the CAPS DA office.
Yeah, quite a few refer on.
Yes. I think Elise went over there.
I saw her at the conference and said, can't remember.
Yeah. So wait, were you ever in non-complex when Rewa was over it, or?
I was.
Okay.
By the time I got there, it was Lamar Rhodes.
Okay. I think he's at the solicitor's office now, right?
I saw him in the hallway and I said, he left us high and dry, but he's doing well.
So who's over non-complex now?
Tom White.
That's right. I don't think I've ever met him, but I've seen that name on stuff. Nice.
He seems to be enjoying it. He just had a stroke.
A stroke?
Yeah.
Oh my gosh. Is he okay?
They said that he's up and like he's not up and around. He's breathing, he's alert, but he's gonna be down for a little while.
Horrible.
Yeah, we just had our Christmas celebration. He was there dressed as Santa Claus. He was having a great time. And then I come in on Monday and we're the strokes.
Wow. Gosh. Hope you'll have a swift recovery. That's terrifying. So how long were you in Cobb?
I was in Cobb for a little bit over a year.
Okay.
And then I went to Clayton County and I was there for about a year.
In the DA's office?
And I started out as a solicitor a little bit.
Okay. I'm just being all kinds of nosy.
Are we ready for Mr. Swindle?
Ready, Judge?
Yes.
Then we're resolving both cases?
Correct.
Off to a great start with Mr. Jordan. I'm so excited to resolve all these cases today.
I was not expecting that. And, this will be, he will be entering a plea to the felonies, but the state and Ms. Wood have agreed to dismiss the misdemeanors. So.
Wow, so the reverse of the previous ones. Okay.
That's correct. So all F5C stolen property on 21 SC and on 22 SC, the state will be dismissed count 6.
Okay. And I guess we'll learn more. Mr. Swindle has a co-defendant in the second case. Okay, well, I'll learn about that. But your understanding of the case is that Mr. Swindle's plea does not resolve things for Mr. Elder. Mr. Elder is going to continue to have criminal exposure.
That is correct, Your Honor.
Okay.
Give factual basis to that, I might make.
Okay.
What you asked for back there. That's it. He's just saying that he's dismissing these counts right here. So everything else is the same as we talked about. Okay? Do you have questions about that? Okay. Okay, we're good to go, Judge.
All right, let's get on the record for Mr. Swindle's two cases. It's 21 SC 179851, 22 SC 183684. Good afternoon, Mr. Swindle.
How you doing, sir?
I'm okay. How are you doing?
I'm alive, sir.
You're alive. All right. That is a great place to start.
Yes, sir.
Mr. Swindle, Ms. Wood tells me you're prepared to enter pleas in your two cases. Is that correct?
I am, sir.
The state's dismissing a bunch of charges. They'll go through that, but it's still a plea to one felony in the case ending in 851, maybe a couple felonies or so in the case ending in 684. Is that your understanding?
Yes, sir.
Okay. In a moment, Mr. Jordan's going to put you under oath. When you are under oath, you need to answer his questions truthfully and completely. My questions too. If you have questions of your own, it's important that you let Ms. Wood or me know so we can answer them. Will you let me know?
Yes, I will.
Good. All right, Mr. Jordan.
Mr. Swindle, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name?
My name is Bernard Davis Swindle Jr.
And Ms. Rivers, are you able to hear? Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Not at all, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone to school?
I am 47 years old, sir. I'm a native of Atlanta. I went to Job Corps.
Does that mean you finished high school or that's a way of
GED, sir.
GED and Job Corps?
Yes, sir.
Are you able to read, write, and understand the English language?
Very well, sir.
Okay. And do you understand that you have been charged with the following offenses? And I will start with the oldest indicted case, which is 21 SC 179851. These are the offenses that you have been charged with, even though you're not pleading to all of these offenses. Count 1 being theft by receiving stolen property. Count 2 being failure to obey signs or control devices. Count 3 being a brake light violation. And count 4 being expired or no license on the person.
Yes, I remember those charges, sir.
Okay, and then the second indictment, 22 SC 183684, you have been charged with 1 count of burglary in the first degree. Count 2 being possession of tools for commission of a crime. Count 3 through 5, all being theft by taking. And count 6 being missing or defaced or obscured license plate.
Yes, sir. I remember those charges. Yes, sir.
Okay. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you will receive a jury trial.
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Lacey Wood, about all of the facts and circumstances known to you regarding the charges and these indictments, including any potential defenses?
I do believe so, sir.
Do you need any more time to discuss the case with her?
No, sir.
Are you satisfied with her services?
I am.
Ms. Wood, do you waive from a reading of these indictments?
So waived.
You also waive any and all defects of these indictments, including any with respect to Mr. Swindle's name.
So waived.
Mr. Swindle, do you recall having being arrested on both of these particular indictments?
I do, sir.
Your Honor, the state is unaware of any outstanding warrants related to these in both of these indictments. Ms. Wood, do you know of any outstanding warrants related to these charges?
We do not.
Mr. Swindle, has your attorney advised to you the minimum and maximum sentence for each charge that you are pleading to?
So that's for that one, and then these are the ones down here. Do you see those?
Yes, I do.
Okay.
Your Honor, just for the edification of the court, count one is the only count that he will be entering the plea to in 21 SC 179851. And theft by receiving stolen property carries a minimum of 1 year and a maximum of 5 years. And the second indictment, 22 SC 183684, he will be entering a plea to counts 1 through 5. Count 1, burglary in the first degree, carries a minimum of 1 year and a maximum of 20 years. Count 2, possession of tools for commission of a crime, carries a minimum of 1 year and a maximum of 5 years. And for the theft by taking counts, all three, I believe, are felony variety, and those carry a minimum of 1 year and a maximum of 5 years.
Wait, I think the 3 through 5 you said, those are misdemeanors.
Those are misdemeanors. My apologies, Your Honor. So since those are the misdemeanor variety, those carry a minimum of 1 day and a maximum of 12 months.
Are they not being dismissed? I thought you were dismissing all the misdemeanors, but it may have been that was coincidence. You were never planning on dismissing the theft by takings, and they are what they are. It turns out they may be misdemeanors, but you want to proceed on the theft by takings.
That is correct, Your Honor. And my apologies to the court. I did think was under the previous understanding that those were all felony counts. But given that that's key to the burglary, I would ask that we proceed on those counts.
Sure. Well, you don't have to ask. They're your counts to proceed on or to null pros. So I'm looking at those 3 thefts. They're all labeled misdemeanors. So, and everything is less than, it's a dryer, a washing machine, and an oven. So it sounds like this is an appliance heist. And each of the appliances was of a value of less than $1,500, which makes them all misdemeanor counts.
Thank you, Your Honor. My apologies.
That's okay.
Mr. Swindle, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, this is a global resolution as to both cases. The total sentence will be 6 years to serve 16 months.
16?
Yes.
Okay.
With the balance being probated. The only special condition of probation, Your Honor, would be that that the state would recommend is that he not return to the incident location in 22 SC 183684. When I get the factual basis, I'll make sure to give that address.
Is that the Greens Ferry address?
Yes, Your Honor.
Okay.
As to 21 SC 179851, this is the maximum. It's 5 years on the first count. As to that case, the state's recommendation is 5 years to serve 16 months, with the balance being probated. As to 22 SC 183684, count 1, burglary, the state's recommendation is 6 years to serve 16 months, with the balance being probated. That is to run concurrent with 21 SC 179851. Count 2 is 5 years to serve 16 months, with the balance being probated. That is to run concurrent with count 1. And counts 3 through 5, and my apologies, Your Honor, for doing this in the middle of the plea. Since he has served, I believe, over the 12 months, the state's recommendation for those counts would be 12 months to serve, credit for time served.
Okay.
And those are, my apologies, they won't run concurrent since they've already expired.
Well, they'll need to run concurrently, and I'll run them concurrently with count 1. So that way I'll get there, but I understand the joint recommendation, should I follow it, is that Mr. Swindle be sentenced to 6 years to serve 16 months, which would be 4 years and 8 months of probation.
That's correct.
Okay.
Mr. Swindle, was that the negotiated recommendation that was communicated to you?
Yes, sir.
Do you understand that the court does not have to accept that recommendation?
I do, sir.
You understand that the court can sentence you to the maximum of each charge and can run those sentences consecutively or one after the other?
I'm aware of that, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
I'm definitely aware of that, sir.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering guilty plea today?
Yes, sir.
Do you understand that since you are being placed on probation, you cannot violate any criminal laws of any government unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
I understand that, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
I understand that as well. I've never carried a firearm, miss.
Understood. Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that, for example, your guilty plea may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment?
I understand that too, sir. I was wondering, would there be a time clause in my probation, like if I'm able to do it in, maybe 24 months or per se,
So, Mr. Swindle, you will be considered by probation for either early termination or what the first step would be to move you to unsupervised probation. So at first, you're meeting with probation regularly. Got to check in with them. They're checking in with you. If you're doing fine, they back off, and it may reach the point where they say, let's just make it unsupervised. You don't have to call us, and we're not going to bother you. That's a natural next step. The ultimate step would be early termination. And you could ask for that after some time has gone by. We'll need to see how things are going. Or probation may come in and ask for it, saying, we have so many headaches. Could we just close out Swindle's case? Because he is not a headache for us. But that's on you to not be a headache for them.
And then would that allow me to get my rights back?
So you'll still have a felony conviction if this isn't your first one. Your rights are, in terms of voting and being able to carry a firearm and whatnot, that's driven by whether you have a felony conviction or not. If you already have one, this isn't changing that situation. If you have any, there are steps you need to take outside this court process to get your rights restored. It is doable, but you cannot do that till your sentence is complete. So focus number one should be, let's get through probation without tripping up. Okay?
Yes, sir.
Mr. Swindle, do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in the commission of a crime, you'll be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
I'm aware of that, sir.
Do you understand that you waive any and all defenses, including any mental health offenses, by entering a plea of guilty?
Yes, I do, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, I am.
You understand that by pleading guilty, you're giving up the following rights, which I will now list off. The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
I'm aware, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
Not at all.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir. I am in fact guilty.
How do you plead to these charges? And we will start with indictment 21 SC 179-851. How do you plead to the charge of theft by receiving stolen property?
I am guilty, though I feel by mitigating circumstances. I was parking cars that day. I parked the car. I was in the car. So I am guilty. Yes.
And as to how do you plead to the charges of burglary in the first degree, possession of tools for commission of a crime, and 3 counts of misdemeanor theft by taking in indictment number 22 SC 183684.
I am guilty, sir.
Thank you. Are these, is this guilty plea to these 2 indictments freely and voluntarily given with the full knowledge of the charges against you?
It is, sir.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
I'm not aware of the limited time, but I'm listening. I got you.
All right. Do you understand that you, for the felony charges, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea, and 12 months from today for the misdemeanor charges to file that same petition?
Gotcha.
And Ms. Wood, have you advised to Mr. Swindle his deadlines for filing a direct appeal and for withdrawing his plea?
Yes, and I'm gonna write them down for him as well, Mr. Jordan.
Thank you very much. And Your Honor, if we can start with 21 SC 179-851, the factual basis for that plea. On December 23rd of 2020, an APD officer was patrolling the area of Walker Street and Peter Street when he observed a black Toyota Corolla traveling southbound on Walker Street with a broken left brake light. The vehicle went through the intersection at Walker Street and Peter Street, disobeying the traffic control device. When officers approached, the driver, later identified as the defendant, Mr. Bernard Swindle. They asked for his driver's license. Mr. Swindle stated that he did not have a driver's license. Officers then did detain Mr. Swindle and a male passenger. Officers did run the vehicle information, and the vehicle came back as stolen from 678 Fire Street Southwest. The initial location where the vehicle was reported stolen was only 2 miles away from where the traffic stop occurred. When questioned by officers, Mr. Swindle stated that the vehicle's owner had given him the key and money to park the vehicle for him while he went into the Escobar bar at 327 Peter Street. Mr. Swindle did not have a valet permit to conduct valet for hire. Officers did contact the manager at Escobar, and they did not recognize Mr. Swindle or the description that Mr. Swindle gave for the vehicle's owner. Mr. Swindle was then charged with the offense of theft by receiving stolen property. And Your Honor, as to the second case, for factual basis for that case, on May 11th of 2022, officers were dispatched to a burglary in progress at 565 Greens Ferry Avenue, Southwest in Atlanta. A resident, Mr. Keith Hardrick, and that's spelled Hardrick, observed the incident and contacted police. The description was given of 2 males, one African American and one Caucasian, driving a black van, and that they were breaking into a vacant apartment, which was apartment 1419 at the location. Upon arrival, Officer Coleman was notified that the male suspects were at the back of the apartment unloading items. The officer also noticed that the back door of the apartment was open. The African-American male, later identified as the defendant, Mr. Bernard Swindle, was observed dragging an oven that was wrapped up in a blanket out of the apartment. The officer detained Mr. Swindle without incident. Officers on scene to assist approached a black van. The van was occupied by Mr. Swindle's co-defendant, identified as Mr. Coley Elder. Inside the van was a washer and dryer that had allegedly been removed from the vacant apartment. Officer Coley confirmed that the washer and dryer were missing from the apartment. And further investigation revealed that the black van's tag did not match the make or model for the vehicle. Mr. Elder stated to police that Mr. Swindle had put the tag on the vehicle before their arrival, but he did claim ownership of the van. Mr. Swindle's statements did corroborate Mr. Elder's statements to the police. Officers also on scene recovered a knife, pliers, lighter, battery, and screws from the defendant's possession. Both individuals that were then taken into custody and transported to the Fulton County Jail. That does conclude a factual basis for the plea, Your Honor. And I apologize, Your Honor, I did leave out when I spoke to Ms. Wood when we were negotiating this case earlier. We would like it to be a condition of probation that Mr. Swindle provide truthful testimony if called as a witness against his co-defendant, Mr. Coley Elder. Your Honor, we did reach out to the apartment complex that had the items taken from it. They did not respond yet. So at some point, the state may file a motion for restitution.
But the restitution would be damage from removing these appliances. The appliances were recovered. They may have been damaged while being moved, but it's not for the cost of the appliances.
That's correct, Your Honor. Only damage to the apartment that has been sustained by removing the appliances, but all appliances were recovered.
Okay, understood. Thank you. Ms. Jackson, thanks for sticking with us past 5 o'clock. Can you tell me what you've got on Mr. Swindle's criminal history, please?
The defendant has 36 cycles. The defendant's last arrest was April the 7th, 2022, with the City of Atlanta Police Department for possession of Schedule II controlled substance. There was no disposition for that arrest. The defendant does have prior felony convictions. This one in 2004 for 2 counts of theft by shoplifting, felony, and robbery, and criminal damage to property in the 2nd degree. And there was one in 2002 for possession of controlled substance, and one in 2000 for theft by receiving stolen property. Nothing in addition, Your Honor.
Thank you so much. Ms. Tucson, is Mr. Swindle on probation right now?
No, Judge, not at the moment. No active probation.
Thank you. Ms. Wood?
Thank you, Judge. Mr. Swindle is 47 years old. He is a lifelong resident of the metro area. He has family in Rex, Georgia. That is where he plans to return to upon resolution of all of his legal issues. As he's mentioned earlier, he has a GED and went through Job Corps. I did just want to let the court know there was a large amount of discovery that Mr. Jordan served on me yesterday, and I did inform Mr. Swindle that I did not have a chance to go through all of it, but he was eager and very adamant. He wished to resolve this case today, and so we do ask that you accept the state's recommendation. The credit for time served dates, he's been in 3 different times, similar to Mr. Cockrell earlier. So he served from December 24, 2020 to August 13, 2021, 233 days. And then he also served again April 18th, 2022 to May 10th, 2022, 33 days. And then finally, he's been in since May 12th of this year to the present day for 223 days.
Wait. He was April to May of this year. When to when?
April 18th.
Yeah.
And May the 10th, Judge.
All right. And then what's the next range?
May the 12th.
So he got out for 2 days?
Later.
Okay.
Actually,
You get a chance. I thought I heard a very small gap, and it was a small gap. Okay.
And then through today, so 223 days. That totals out to be 489 days. I did send this breakdown to Ms. Nelson for convenience because it's kind of confusing. But we would just ask that you accept the state's recommendation.
Okay. Mr. Swindle, tell me, you wanted to interject, which is fine, and now's your chance to do that. You got out for 2 days, or you didn't get out? You just weren't in the county jail?
Okay, the apartment, 1490.
Oh my gosh, you were out for 1 day and then you did this thing.
576 Greens Ferry.
Yeah.
Apartment 1419 was an apartment that I had been staying in. I've been staying in that apartment for off and on for probably about several months, sir. We were squatting in the apartment. I had Louis Vuitton, red bottoms. I had HPs, Apple Mac. I had all kind of computer and content stuff inside of the apartment. When I got out on the 10th, I went to the apartment to get the rest of my things out of it. You know, as far as the appliances went, they were strewn all over the place. I drove them out. I had friends there who were staying there. My things got missing. I knew that they would still be coming back and forth to the apartment. So I started taking the appliances out and putting them in the van so they wouldn't have any reason to go down there to wash any clothes or dry any clothes. That was my intended purpose. You know, taking the things out of there because they had done stole a lot of my stuff because I was locked up for the 30 days. You remember from April the 6th.
I did.
To May the 10th, I had
Right.
been locked up. When I got there, my things were gone. You know, I could prove that I was staying there. I even have content on my phones.
Okay. But it sounds like you were staying there, not paying rent there.
Exactly. We were squatting there, sir.
Okay.
Honestly.
All right. But now I understand. So you got out and then right away got into a pickle with law enforcement and got back in.
Yes, sir. I went down there to the apartment to get my things. Someone called the police. They hadn't seen me around there in a while. I guess you call the police.
Yep. There you are putting a oven on the van or something.
Yeah.
So Rex, Georgia is where you're going?
My mom lives on Martin Luther King. So I can't tell you that I'll actually be in Rex, Georgia. My grandmama lives on Martin Luther King as well. I have nieces and nephews. I got a niece and a younger brother that lives in East Point. Between them, we're going to get this situation situated. I promise you, it's going to be fine.
Well, so your promise is interesting.
Yeah,
This was arrest number 37.
I gave her my sister's address. I took the probation. I asked her to give me the probation because of the structure of it. It holds me at some. I have to do right. You know what I mean? I did this to myself. You know what I'm saying? I'm consigning myself to the probation because I know that I don't want to be locked up anymore and I don't want to go through this anymore. You know what I mean? I'm 47. I'll be 50 in 3 years. I need to try to get some right, you know. So this is what it is. But between me and my family, I do have a support system. I do have people who are willing to work with me in any way that I'm willing to, because I will work. I will do right. I have done right in the past. So, you know.
Maybe being in Rex is better for you because you're away from whatever gets you in trouble in Atlanta.
Yes, I'm gonna still have to get a job. I'm gonna have to be around somewhere where I can get around. Transfer or whatnot. They don't have it out there in Rex. So it's gonna probably be, I'm gonna get a job here in Atlanta probably, or maybe somewhere like Cobb, but somewhere in the metro area.
Okay. Well, we need to know what address you'll be staying at because probation doesn't hunt around for people. They have a one address where Mr. Swindle will be living. And I'm not saying that needs to be in Rex. I perked up because that seemed to be away from a lot of your troubles, but I didn't realize you've got a mother and a grandmother that will be expecting you to help out. So you may need to be closer than Rex. So where will home be?
I gave my lawyer here my sister's phone number and my mother's phone number. Between these two, they'll tell her where they'll do, you know, where I'll be. I'm gonna have to call them myself. I'm gonna call them when I get over and be like, okay, look, this is what's going on. I haven't awared them to the situation because I didn't know how it would go.
Okay. All right.
But
So
I won't be homeless. I won't be in the street, I promise you.
Okay, good. We'll just need to figure out where that place is when you pick one. Because like I said, probation needs a single fixed address.
All right. call my sister and use her address.
Okay, I'm probably not going to call your sister, but someone will, and we'll get that address and we'll get it to probation.
Thank you.
Anything else you want to add?
Thank you. That's all, so.
Okay. All right. So, Mr. Swindle, I find that there is a factual basis for both your cases. It sounds like you have an explanation for both. You were parking someone's car and you were, I guess, removing these appliances from a place that you thought was kind of your place, even though you were squatting there, because that might discourage people from going back in there and taking your stuff, but it sounds like they had already taken it. Either way, another fair interpretation, especially of the more recent case, was that you and Mr. Elder were leaving with the appliances from that house. I also find that your pleas are knowing and voluntary. Knowing means you've understood what we talked about, and if you didn't, you asked Ms. Wood or me. Do you have any questions about anything?
No, sir.
Okay. Voluntary means that no one is forcing you to do this, but that you've decided that is the right way forward for you. Is that correct?
Yes, sir.
All right. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that for the part of your sentence that's probation, if you have a minor violation of probation, you and probation will figure out what ought to happen because of that. But if it's a major violation, you get arrested again, something like that, that comes back to me. And then you and I and a lawyer will figure out what happens with you. Do you, Mr. Swindle, authorize my staff to sign the 2 indictments for you indicating your guilty pleas?
Yes, sir.
Ms. Wood?
Yes, Judge.
And Mr. Jordan?
Yes, Your Honor.
And Mr. Jordan, you are moving to null pros counts 2 through 4 of the indictment ending in 851 and count 6 of the indictment ending in 684?
That is correct.
All right, I will grant those motions and those counts will be dismissed. Mr. Swindle, in 21 SC 179851, I am sentencing you to 20 months to serve. That's it. That's your sentence. And you'll get credit for all those days that Ms. Wood has laid out. In case 22 SC 183684, count 1 is going to be 7 years to serve 20 months with the balance on probation. Count 2 will be 20 months to serve. It'll run concurrently with count 1, and counts 3, 4, and 5 will all be 12 months to serve. They'll all run concurrently with count 1 as well. So overall, if you mush your 2 cases and all those counts together, it is 7 years to serve 20 months. You'll get credit for the 490-ish days, whatever the exact number is, you'll get credit for all of that against the 20 months. And then the balance is on probation. So it's about 5 years probation. Special condition of probation number 1 is that you will stay away from 565 Greens Ferry Avenue Southwest in Atlanta. You know the place, you used to live there. Special condition number 2 is that you will provide truthful testimony if called upon, should Mr. Elder decide to go to trial in the case that you share with him. That's the case ending in 684. And the third special condition is that if you are not working 1 month into your period of probation, then you will have 10 hours of community service for each week you're not working. So you can get a month to get on your feet. I'm going to waive the probation supervision fees for that first month as well. But once you're out, if you're not working, then each week there'll be 10 hours of community service. Once you are working, even if it's part-time, if you're working more than 10 hours a week, you don't need to worry about the community service. And I will need an address that we can give to probation. I don't need it right now, but Ms. Wood is going to need to get that address to Ms. Tucson, who's with probation, so they know where to find you. And you can be, it sounds like you're going to pick either your sister or your mom. That's going to be a Fulton County address.
Yes.
So then I'm going to let Ms. Tucson give you your reporting instructions, but it will be to probation here in Fulton County. Mr. Jordan, anything we left off?
No, Your Honor.
Ms. Wood?
No, Your Honor, just to confirm, it's Fulton County probation to report within 48 hours.
Well, I'm gonna let Ms. Tucson talk about that because Mr. Swindle has a little bit more time he's gonna serve, so it won't be right away, but it'll be real soon. I assume it's 48 hours, but we'll let Ms. Tucson explain that. Ms. Tucson, you there?
I am here.
Excellent. So
So he will be in custody a little while longer.
that's correct. A few more months.
Okay, so then when he is released, he'll need to report to Fulton within the 48 hours.
Okay.
Since he's not going to be getting out. Like if it were like, if you're getting out today or tomorrow, I would give him a date.
Yep.
Since they're both new cases, but since he'll be in a little bit longer, he would just need to report on both cases. They will be uploaded within 48 hours of release. And of course, if he's not going to be living in Fulton at the time, then they will transfer it. I think Rex is in Clayton. They'll transfer it there. So he'll need to report to Fulton.
Got it. And there's no probation on the case ending in 851. So he'll only be on supervision for the case, position 6, the case ending in 684.
Okay.
All right.
All right. Thank you.
You bet. So Mr. Swindle, good luck. You are 47 and in 3 years you will be 50. It would be great if you have very few more cycles and don't have to go back to that county jail. I hope you're able to do that. Okay?
Thanks, Judge.
You bet. So we have one more case we need to talk about. I don't think it's going to involve probation or pretrial. Can I let them go? All right. Ms. Jackson, thank you so much for your time this year. I will see you in 2023. Ms. Tucson, the same. And I think we've got one other person that just disappeared from pretrial who was on, but I appreciate everything you guys do. This was a long day. Happy holidays, and we'll see you in the new year.
Thank you. Happy holidays to you too, Judge.
Thanks. You too. Everyone have a good one.
All right, let me find this case.
Oh, you need a translator? Because you need a translator.
Okay, that isn't gonna happen today, I know, but we're gonna talk for 1 minute and then we'll try to say something real simple. I'm just trying to find his
It's
case.
on position 9.
There it is. Right. So Mr. Morga has a new case.
Yes, Judge.
Let's look that up.